Good morning, everybody. Welcome, welcome. I am wondering if we are already starting off with good old audio issues. I just have to check because I couldn't hear my own intro little thing. I don't know. I turned up my mic sound a little bit. Guys, we're playing a little bit because we are very aware that it's not awesome when there's such a big discrepancy between my volume and the volume of the stream that we're trying to watch because we get very bad quality coming in from court TV or whatever, and then you got to crank it up to be able to hear it, and then my voice comes in like, gazillion decibels and blows people's ears out. We don't want that. So we are experimenting a little bit. So hopefully do bear with us if we run into any issues there. We'll do our best to get them fixed. Well, welcome back. Bright and early, 5:45. It's a little early to be trying to fix tech stuff already, but that is just how it goes. We get what we get. So of course, the hearing was originally scheduled to start at 9, but we do have reason to believe that's going to be delayed. And the reason why is because Dr. Turtleboy has announced that he and Karen Reed both are going to be in court on his case because Mr. Brennan is going to be appearing to ask. Basically, he's trying to get Turtleboy's cell phone records. So he has to go do a motion in that court. They're going to be doing that first, and then they'll be making their way back into Judge Cannoni's courtroom to deal with whatever it is we're going to deal with today, which is, as you may know, kind of the million-dollar question at this point. So first off, I did do a Twitter poll. Guys, and I was kind of surprised, honestly. That's a pretty solid supermajority. About 69% to 31% think no, this trial is not going to start on April 1st. A week ago, absolutely no chance I would have said no. And to me, still, really the biggest signal in that direction is the fact that she cut Tuesday's hearing short. The fact that she cut it short, especially right there when the Commonwealth basically said, Mr. Schellinger, again, a little confusing who exactly is representing, but seemed to indicate that the Commonwealth also thought it would be better for this appellate issue up in the First Circuit to be wrapped up before they move forward with trial. And so we just, stopped that hearing that was going to be all day. And we still have, 16 motions in limine to get through, plus all of the new ones that came in. And now we have a formal written motion in limine. So let's go ahead and take a look at that, guys. Let me shrink myself up there we go. That'll work a little bit better. Defendants assented to motion to continue trial to a date on or after April 25th. Assented to motion. So, okay, the Commonwealth is not joining in this motion. They're not saying, yes, we are also making this request, but they're saying we're okay with it. Which, gotta tell you, I did not really expect. And I kind of wonder, I have to wonder if there's other reasons for that, reasons that, I don't know, might have to do with Mr. Brennan being over in Dr. Turtleboy's courtroom this morning. I don't know. So asking for it to be continued to April 28th with a final pretrial conference on April 25th. Commonwealth assents as further noted below. They say it's necessary to permit her to appeal the denial of her federal double jeopardy claims, which the federal district court expressly found to be substantial, to the First Circuit Court of Appeals prior to being forced to undergo a retrial that Ms. Reed contends would violate her rights. Remember when they found this substantial, that's the certificate of appealability. That's them making the finding that she will have the right to appeal the denial of her habeas writ. That is not automatic. You do not always have that right to appeal a habeas because there's a lot of frivolous habeas litigation. So they have set it kind of up for themselves where they get to screen out ones that are clearly frivolous or they think just don't warrant any kind of further consideration. If it's an issue where they think it's enough that there should be a second set of eyes on it, we could be wrong, reasonable jurists could differ, then they allow that to be appealed up. So she's definitely cleared that hurdle with that finding, meaning this is not frivolous, this is not completely without merit. The judges seem to think there's room potentially for disagreement on these issues. So we got to get the next page here. After the mistrial, she moved to dismiss. They're just kind of going through the procedural history. She went up through the SJC. She went up through habeas, and the federal district court found 1, Ms. Reed properly brought her petition. 2, she satisfied the custody requirement. 3, she exhausted her state remedies. 4, no abstention doctrine barred the federal court from considering the petition. Yeah, that was pretty significant given that the case was still pending. So had they decided it in her favor, would have stopped the prosecution. So they're going to be looking at their authority to go in and interfere with the state level prosecution. And because of the magnitude of the rights involved, they said, yes, abstention is not appropriate. Is that going to be the same standard on appeal? That's the $1 million question. So yeah, this page is all just basically the procedural background of the motion. Let's see. Okay, it did switch. So they say the appeal is going to be fully briefed by March 26th. That's next week, guys. That is next Wednesday, just 4 days before her scheduled retrial. They are really accelerating this. And granted, we heard that from the hearing on Tuesday. That's something that the parties have agreed to. That's kind of within the scope of what they're allowed to do. But they can't control the court, how fast it's going to decide it or not. Even honestly, continuing it to April 28th, that gives the court a month to decide. That's pretty fast, guys. That's pretty fast. Just doesn't usually happen on that type of time frame on appeal, but never know. Never know. So Ms. Reed respectfully submits that the double jeopardy protections at stake in this matter are simply too important to force her to stand trial for murder in what she contends would be a violation of her rights before having the opportunity to appeal her substantial constitutional claims. It's very persuasive the way that they have presented that. Like, you wouldn't necessarily know she's lost this issue at every level so far that's looked at it. That certificate of appealability really does give it some heft, that if you were just looking at it without that context, you might be like, yeah, she lost an appeal. She lost in the Supreme Court. She lost at the first level of the federal court. We don't necessarily need to hold up because she's probably going to lose again. They got that substantial finding. So that really gives them a little bit more weight, heft to this argument. Moreover, whether Ms. Reed's retrial will proceed on all 3 counts or be limited to count 2 will materially impact her trial counsel's strategy and decision-making, such that the defense believes Ms. Reed is entitled to know which counts she will be tried on in advance. And that's the argument they put forward in court on Tuesday. It's a different trial if we're just going on manslaughter than if we're going on murder. And that's true because, murder, the issue is intent. They have to be prepared to address that and focus on that. If they don't have to focus on proving no intent, then we're really just narrowing in on the technical issues of was there even a car collision? So you have different experts that you retain. You emphasize different things in who you call and in the things that you ask them to present, how you focus on it, and so forth. Um, I can think of how it affects your, like just even how you give your opening statement and stuff like that. If they got to focus on, Karen didn't intend, and we're anticipating all this stuff, like the Commonwealth wants to bring in all this relationship history, quote unquote, prior statements of John, the hearsay statements of John, and so forth. Uh, Although apparently not Aruba, apparently conceding even they realized that Aruba is a big old stretch. But they want to bring in this idea that there's problems with the relationship, and that was motive. That was why Karen had this intention. You got to deal with that. You got to be going down that road. The jury's hearing all that stuff, and that can be prejudicial. They're already forming initial impressions of her, and if they decide, oh, she probably is a woman scorned, that's not real helpful. Not real helpful. And so if none of that's coming in because you're not even going forward to trial on an intentional murder charge, you're just going forward on manslaughter, then I don't know. You're not bringing that same stuff in. So I don't know. I don't know that you would even really address the mental state at all. You'd have to focus so much more, I think, on the intoxication side, because that's really where the risk is, in my view, of the finding of the recklessness. If the jury thinks that Karen was drinking and driving, and even if she didn't know she hit him, nevertheless, she was being reckless, and it resulted in her clipping him or whatever. Yeah, that could get him there. So you got to focus real hard on the whole intoxication, the retrograde extrapolation, the validity of the blood testing, all that stuff. You're just gonna, I think, focus on that quite a bit more than if you have multiple charges that you're having to navigate. So the continuance assents to a short continuance of the trial to the end of April 2025. That assent is without prejudice, and the Commonwealth expressly reserves the right to oppose any further continuance or delay of the trial, including if the First Circuit appeal has not been resolved by the time of the new trial date. So I do wonder, like, where do we come up with this deadline, April 2025? Is this just kind of out of the blue? Some folks did ask over there on X. Some folks were asking, Mr. Schellinger made the comment in the court hearing, on Tuesday, that they would need to go and confer with the victim's family, with Mr. O'Keefe's family. And a lot of people were like, well, why? Why on earth would they have to do that? Well, it's because of the Victims' Rights Act. Massachusetts has a Victims' Rights Act. Many states do. And it basically gives victims of crimes certain rights with respect to the process, with being informed about it, being able to attend it, and having some limited input into it. Now, that doesn't mean they get a veto or they get to tell the prosecutor what to do or whatever, but the prosecutor is generally going to hear them, may or may not go along with what they want for a variety of reasons. So it could very well be that, they conferred with the O'Keefes, and the O'Keefes were fine with that long, but not further. So the Commonwealth is fine with that long, but not further. It could be that the O'Keefes don't want any continuance at all, would be my expectation. But the Commonwealth is trying to kind of split the baby here between, well, I don't want to necessarily kick it all the way down the road, that it could take for an appeal to be decided, because that could be like 6 months down the road. Honestly, it could be a while. We just don't know. So trying to find some kind of minimal compromise. Well, we'll kick it forward a little bit, even though the family doesn't want it. But we're not necessarily going to say, yes, we'll agree to continue it until the appeal is decided. We're just going to kind of play it by ear and see how it goes. Now, okay, the Commonwealth has assented. Does that mean this is automatically going to happen? No, no, absolutely not. It still remains up to Judge Canoni. It remains up to Judge Bev. And is she going to do it? I don't know, because her big concern at the hearing last time was, we've already sent the jury summonses out. And I got to be fair, I try to be fair. I'm not here to give people a hard time unnecessarily. She might have a point with that. She really might have a point with that. This is a trial where they're going to have to bring in an unusually large jury panel because of all the publicity. They trying to remember how many they brought in last time. Do we know? I want to say like 600. That's what's in the back of my mind. But I could be confusing that with a different case. You need a lot of people. And so most cases don't need anywhere near that much. So just your routine jury summonsing for any particular trial date, it's likely to be quite a bit less than that, maybe 100, maybe not even that much, maybe 60. It's kind of hard to say. I don't know what their normal practice is, but those are kind of numbers that I'm used to dealing with in these types of trial contexts. So if they continue the trial out until April the 28th, number one, it's highly possible that summonses have already gone out for April the 28th, and you might be able to send out some more, get more people called in for that date, but it's just not really a lot of notice. 5 weeks notice, roughly. Yeah, it's not a lot. It's really getting a little close to the wire. The closer you get, the less reasonable it is to expect people to be able to show up. You're just more likely to have more conflicts. So people can't, arrange their schedule around it as easily. So that's really her obvious reason to not do it. And it's not unreasonable. If that is the case, if it does present logistical challenges for them to be able to get everybody in, then yeah, I think that's a perfectly good reason. Now, that said, because she has discretion with the motion to continue, that doesn't have to be a reason either. She cannot do it just because she doesn't want to. But we'll see. The fact that the Commonwealth is joining in and they both think it's a good idea. Historically, it seems like when that happens, she has tended to go along with it. So like we're seeing even with the motions in Limine, if the Commonwealth doesn't object to the defense's motions, which is pretty much, the bulk of what we've done so far, haven't really addressed the Commonwealth's. But if the defense and the Commonwealth are generally in agreement, we don't even spend any time on it. We just go ahead and go along with that. Oh boy, what was our other big news? Trooper Proctor got the boot. Trooper Proctor finally got the boot by the Massachusetts State Police just yesterday. Kind of overdue, in my opinion, personally, but of course, entitled to our opinions. But I'm going to go ahead and bring that up. just so that we can see, yeah, what exactly they did. They had their trials, and yesterday on March 19th, they found he is guilty of all of the charges, and then they specify what those are. So we know exactly what they fired him for. On various dates between January 29th, 2022 and August 17th, 2022, he did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. So he violated their policies while he was on the occasion of a crime or disorder or, whatever. This occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, sent derogatory, defamatory, disparaging, and or otherwise inappropriate text messages about a suspect in this investigation to other individuals. So, against their policy for him to do that, for him to say all that gross stuff about Karen to his friends while he's the lead investigator. Yeah, that's pretty bad. Trooper Proctor, on various dates between January 29th, 2022 and June 9th, 2022, did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. This occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, provided sensitive and or confidential information about a homicide victim, potential witness, and or potential investigative steps in the investigation to non-law enforcement personnel. Yeah, I remember that's what really bothered me a lot. I mean, obviously a lot about Trooper Proctor's texts bothered me a lot when we heard them all in the first trial. But the fact that he's like the day of this incident, the investigation has started, he's out there telling his friends about it and how it's going to go, being the whole big man in the group chat, when the public is not going to be privy to any of that information. I hate when people in power act like they're the elect, they have special rules, and they get to provide special benefits to special people. They don't. So that particularly bothered me, was all of this stuff going to those friends that they had no business getting that particular information. Next up, Trooper Proctor, through his actions on various dates between January 29th, 2022 and August 17, 2022, did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. This occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, through his unprofessional and inappropriate conduct, created an image that he was biased in his dealings with a homicide suspect, and or brought otherwise himself and the Massachusetts State Police into disrepute. Yeah. Doesn't that seem to be in direct contradiction of what Trooper Proctor himself was trying to tell us on the stand in the last trial, that, oh yeah, these texts are disgusting and he shouldn't have sent them. Yeah, nice of you to acknowledge that. Really didn't have any choice. Imagine trying to defend that behavior. Although apparently now they are doing that in their whole PR announcement, trying to excuse it as he was upset. He was dealing with the death of the Boston police officer. Imagine excusing that behavior. Even he knew better than to try to do that in the first trial, but nevertheless, he insisted, but it didn't affect the integrity of the investigation. Well, it kind of seems like your bosses think otherwise. They think it sure looks like it did. Sure looks like it could have affected the integrity of the investigation, and people who thought that wouldn't be unreasonable in thinking that. They wouldn't be unreasonable in thinking that you were biased and that you demonstrated that through your behavior. Trooper Proctor on July 19, 2022 did consume alcohol while on duty and not in the performance of duty and while acting under specific orders from a supervisory member or proper authority. This occurred when Trooper Proctor consumed alcoholic beverages while eating dinner on duty and then proceeded to operate his department issued cruiser. This was the Kevin Albert dinner that we heard about when they were over on the Cape, supposedly working on a case. And Kevin Albert left his gun. They got the text messages, left his gun in his car. I mean, where's Kevin Albert's IA? Where's his? Isn't getting drunk and losing your gun also worthy of attention and disciplinary action from the Massachusetts State Police? Did he ever get anything as a result of that? I don't know. Of course, we didn't hear about it in this case, but Kevin Albert was, what's the word I'm looking for? At 6:11 in the morning, like recused. He was recused from the investigation. Obviously, he knew nothing about it and wouldn't have heard anything or seen anything, even though Karen Reed's SUV was parked at his workplace for a number of days. So, wouldn't be shocked if we didn't hear anything that happened with him, but, yeah, something should have happened to him too. These people that enforce these laws against us act with impunity in breaking the rules themselves. If that's not a clear example of a tyrannical government, I don't know what else is. The rules don't apply to them. They decide. They're not subject to the rules. That's tyranny. We have a case over here right now. I saw that some shows like Law and Crime, one of the Law and Crime programs, picked it up and did a thing on it. And maybe some of you guys have heard of it. I don't know. I didn't realize it was such a big deal because it's just the town over from me. But this Washington State Patrol trooper hit a motorcyclist and killed him at an intersection, and had slurred speech, glassy eyes, odor of intoxicants, all the things that you ordinarily hear in the DUI type investigation. And so it looks like I'm hearing we got started in court. So I'm going to go ahead and get us over to that. Let me find out where we're at. Okay. Here we go. Anyway, so she's being charged with vehicular manslaughter, and yeah.
Because of that, I have, from the beginning, kept a very line of separation between both Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit and a search warrant, and there are two pleadings as well in my motion.
Boost the sound a little bit.
The public docket. And so what I know is that there are two phones that were searched by Trooper and is in the possession of the District Attorney's Office.
Very glitchy this morning.
The information is relevant material to Karen Reed's case. The reason why it's important and relevant is that
I hear saying go to Law and Crime instead, so I'm going to go ahead and try to do that, guys. Just give me a second here, and I'll get us out. Let me see where we're at over here. And All right. Get to the beginning, and hopefully that will not be as annoying as this one. Okay. Here we go.
Under these circumstances, a Commonwealth lawyer is obligated to obtain a Rule 17 subpoena to pursue or obtain other information available in a separate case. But these are a bit unique in circumstances in that I am a specially appointed prosecutor to Karen Reed's case, Commonwealth versus Karen Reed, and Judge Cosgrove, Special Prosecutor Cosgrove, is specially appointed to Mr. Carney's case. Because of that, I have, from the beginning, kept a very strong line of separation between both Mr. Carney's case and Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit in the search warrant, and there are 2 pleadings as well in my motion that are on the public docket. And so what I learned is from my public reading and from watching hearings. And so what I know is that there are 2 phones that were searched by Trooper Tully and is in the possession of the Norfolk County District Attorney's Office, and the information is relevant material to Karen Reed's case. The reason why it's important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Carney, but a relationship in where information, some of it private, some of it suggested grand jury minutes, was passed purposefully from Karen Reed to Mr. Carney. Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party, would then be sent to...
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well aware of that person's name. It may be, but I don't know that, and that's why I've refrained.
Let me ask you this, counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove and that they have the reports that have been generated.
Has the underlying data from the 2 phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes.
This judge is sharp.
As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show separately and in Mr. Carney's phone is that there was a relationship between Karen Reed and Mr. Carney in which Ms. Reed would provide information indirectly and directly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Mr. Carney targeted witnesses in Ms. Reed's case with the express purpose, according to Mr. Carney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle.
Providing info.
So
doesn't link
the case law says
that info.
The party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023. 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney is attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team, unless they have standing in this.
We're a little confused, and I don't mean to interrupt the proceeding, but as we're...
Can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of... We didn't see which case number was called for Rule 17, if it was Mr. Kearney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Cannoni, this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights. And the issue
is being recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Kearney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
And she needed to be here, and she has a right to counsel, and we believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel.
Correct, but
which can be dealt with at a later time. Those are what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I understand, and respectfully, I don't necessarily disagree that from an evidentiary standpoint or an admissibility standpoint, that can be dealt with at a later time. But the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Kearney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Kearney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're prepared.
Did you give the court notice of that?
We did to Justice Cannoni.
Okay.
The day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues that Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration, the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes the ultimate ruling, and once Mr. Brennan is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection procedurally. The counsel wants to join in my filing. That's an issue in terms of the filing. So just put it
Thank you. Thank you,
Well,
Attorney.
Your Honor, I do object.
Right, we know you
Ms.
do.
Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party.
It's a
She
case.
has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17. So
Thank you,
Bizarre.
ADA Brennan. She is a party in this case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her
Thank you, Your Honor.
considerations there
We
too.
appreciate the court accommodating us.
So, ADA Brennan, with the court's apologies for the interruptions, the crux of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and I've identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at section D, there was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe, to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is...
Hey, Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel from Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Reed case, Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the two phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth versus Kearney case, docket number 53, Commonwealth revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, It's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an aired broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
I don't think that's necessary, so I'll decline respectfully the offer. ADA Brennan, thank you.
And so in light of the fact that this information was seized pursuant to a warrant of probable cause, in light of the proffer in the affidavit, in light of Ms. Reed's admissions of the sharing, and inevitably the obvious consequence to witnesses, this is relevant to conscience of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I've filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to D, E, and F, not the entire phone. And those materials would be provided to Judge Cannoni in a motion in limine regarding conscience of guilt. Also, we'll dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense. It's in good faith. I provided both pleadings from Mr. Kearney's case, the search warrant, affidavit in support of the search warrant. I've offered videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
Oh, nice. I'm not seeing how
Counsel.
providing
very much, Your Honor.
information is
Good morning,
endorsement
Your Honor.
of third-party use of that information.
Judge, this is a Lampron request, is the case, and I know you're familiar with it, Your Honor. The purpose of the court's focus here, Judge, is on preventing unwarranted harassment of witnesses and third parties. The focus in Lampron as well is avoiding unwarranted delays. So this search warrant was done back, I believe, in February of 2024. So here we are at the 11th hour, and the Commonwealth is throwing, last-minute bombs out. I happened to look at the Reed docket last night. It's amazing to me how many motions in limine are filed. The government's trying to try that case through motions in limine versus, the immediacy of a trial. It was my impression of that. So, we're now getting sucked into these motions here at the 11th hour. And in terms of a Lampron analysis, Your Honor, there's relevancy, evidentiary, meaning it has to be evidence. As you said, not potential relevance, but actual relevance. Not otherwise obtainable at trial. You can't prepare for trial without it. And most important, Judge, is that the application is made in good faith and not as a general fishing expedition. This is the ultimate fishing expedition, Your Honor. And I want to go back. When this happened, Judge, we didn't have a dog in the fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, there was probable cause in a search warrant, but then they took it to a grand jury, so we're past that. They had the two easiest forums you can have for a prosecutor. Sitting in the judge's lobby, shooting the breeze with a search warrant affidavit in front of you and nobody else there. And then they went to the lowest hanging fruit.
Not me. When you say you, not me.
Right, not you, Juror. And then they had the lowest hanging fruit you can get as a prosecutor, going to a grand jury without anybody else there, crafting the evidence in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said there is not probable cause. Again, the lowest hanging fruit in our system. they couldn't establish probable cause based on this information. And I remembered when this happened, just sort of, not even so much representing Mr. Carney, but just as a constitutionalist, as a person interested in the Constitution as an attorney, I saw this, I read the search warrant, out of the Herald or something. And I was prompted to write this press release that I sent out about this exact issue. And I went back to it, I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page short story about its efforts to try to find and isolate, and you have it in there, right, to find and isolate communications. And the government wants to criminalize communications. And if you look at my press release, and I'll submit it, or I'm just going to read a few things from it, we have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs. And she has the right to fight any way she wants, and talk to anyone she wants, and communicate with anyone she wants, and say, hey, don't share this. Hey, keep this between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights to present all proofs. So when the government cites that just as a bare proposition, she tried to keep this secret. She communicated with Aiden Carney. Then we're going to make this gargantuan leap that she's sharing the intent to intimidate witnesses. Yeah. So the whole thing is completely bereft of any evidentiary value, Your Honor. Just the notions that they put in the search warrant, and ultimately the fact that they tried to use it to get an indictment and failed. So that's why this has no evidentiary value. The relevancy is zero because they can't put it into evidence. And then further, Judge, as a practical matter, I looked at the docket. I spoke with counsel. From the Reed matter, it's my understanding, and everyone's here and they can correct me if I'm wrong, the government agreed to not put anything in their case in chief relative to this issue about communicating with Mr. Carney and consciousness of guilt unless it was, quote unquote, the door was open, which of course is sort of a proposition that is, out in the ether, and that ain't ever going to happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California. We talked to this lady, and they were communicating. All they say is they were communicating. They don't say, hey, let's really get that person, and let's get them off of this, and let's try to have that person not testify. Let's scare that person. Let's harass that person. There's no communications like that. They just have the fact of communications, and that's not evidentiary. That's not relevant. So, Judge, here, they just want to get in Mr. Carney's phones. We're not concerned about what's in Mr. Carney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications in our client's phone, in my client's phone, Your Honor. So there's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's a pending motion to dismiss with Judge Doolin, basically saying that all these witness intimidation allegations don't cut it under the Constitution, under the First Amendment. So that's pending, number one. Number two, Judge, is this taint team issue. Counsel doesn't have it right when to say that, oh, these first two phones, we already got into them. So the taint team covers everything, all of Mr. Carney's phones. So the fact that the state police snuck in and forged ahead and searched some phones before the taint team could get set up should not inure to the benefit of this Commonwealth. And
great point.
This is a firewall type of a case with respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of
Counsel, what's the legal import of the pending motion to dismiss
Sure.
in Mr.
So-
Kearney's case?
Sure.
How does that change either the relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17 context?
Sure. So we expect Judge Doolin to come back with a decision that says all of these communications, maybe they're distasteful, maybe they're obnoxious, maybe we don't like them, they're all protected by the First Amendment. So let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Carney. They don't even have that much. They don't have quotes. They don't have communications. They just have the idea that, well, they communicated. The fact that they communicated cannot be a basis for a criminal investigation. And
Yeah.
it's the extraordinary step of getting into the phones.
It's gotta be
A couple
more
of quotes on the cell phones,
piercing
Judge, just
has
to
to meet an
set
exception.
the context.
Exception to the First Amendment if it's going to be criminalized.
This is what from Commonwealth versus Onyx White. That is a landmark case that involves the notion, and you know, the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about a crime. And it would have been an unbelievable expansion of government power to search people's private information. Thankfully, the SJC said, no, you need to have a nexus between the phone and the crime. And they cited some other cases in terms of quotes about cell phones. Just two quick quotes, Your Honor. The cell phone is a repository of just about everything that is materially important to a possessor. Documents, messages, emails, notes, thoughts, communications, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home.
Yeah.
So the
I
cell
appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in it's in 88 Special 88 Cosgrove's possession, custody, control. It's already been seized. 88 Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
But it never should have happened. The search never should have
That
happened.
issue
It should have
isn't
gone through
before
the
me,
team.
counsel. That issue isn't before me. The issue before me is what he's looking for relevant?
Right. What do they have? What do they have to set that up? They have the fact that they spoke. And the fact that they spoke is not evidentiary. It's not relevant. If the fact that they spoke was the basis, we'd be at Onyx White. We'd have the wrong decision in Onyx White, Your Honor, that just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your Honor. That's really the crux of why I'm here. And the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And on the taint team issue, there's more litigation to be done where the court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privileged information in the phone is ridiculous. There's a ton of it. We're also asking right now, Your Honor, for the taint team to scrutinize the phones we're going to ask for husband-wife communication.
You're not asking?
No, not you. Just so you know what's out there. I just want you to know what's out there. We're asking for husband-wife communications. We're asking for that journalist source materials, of which there's a plethora. We're asking that those be scrutinized by the taint team and all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny this, Judge, just on the fact that this is an 11th hour request. If you look at Lampron, it talks all about undue delay. They had this back in February of 24, and here we are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say, we will find something criminal in those phones. Thank you, Your Honor.
Thank you, counsel. So, ADA Brennan, before I hear from you any further in response, I am going to hear from counsel for the defendant in this case.
It's going to be Attorney Elizabeth Little, Your Honor.
Thank you, Your Honor. Elizabeth Little appearing on behalf of Ms. Reed. First, I just wanted to thank Your Honor for allowing us to be present and to be heard on this issue. The defense joins in Mr. Bradle's request in opposition to this Rule 17 motion. There's just two very brief points that I wanted to address that I don't believe were addressed by Attorney Cosgrove. Your Honor, if you take a look at Attorney Bradle, apologies, Your Honor. There are. Your Honor, the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. So just on that basis alone, the Rule 17 is deficient. That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4.
Even a conclusory allegation.
And that's because the Commonwealth knows full well that a grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr. Kearney. And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Thank you, counsel. ADA Brennan, I'll hear from you in response briefly.
The breadth of it does not help,
I think most
overcome the
importantly,
fishing expedition.
the parties are conflating two issues. Whether there is probable cause or beyond a reasonable doubt to convict a person of intimidation of witness and the relevance to consciousness of guilt. It's two separate assessments. It is true there was a no bill, and it is true that there is litigation in Mr. Kearney's case, but these phones are in the possession of the district attorney's office. The information is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions.
So we're acknowledging
the constitutional prowess of Mr. Bradle. It is this reflective of consciousness of guilt?
And Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless...
That is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed. That is an entirely separate issue than consciousness of guilt. I agreed that unless the door is opened, a witness should not get up and talk about their state of mind and how they believe they were harassed. I agreed to that because I will instruct the witnesses unless the door is open and you have an invitation, that would be improper. Separately, a consciousness of guilt motion in limine, which I expect to file if it's viable based on the information, is an entirely different proposition. It's an entirely different proposition than opening the door to the state of mind. The consciousness of guilt has more to do with the conduct of Ms. Reed. Did she do something that reflects her consciousness of guilt to try to cover for the crimes that she's alleged to have committed? We know she was providing information, even protected information to Mr. Kearney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know that the witnesses, whether is a conviction on condition of witness or not, felt very intimidated. We know the mental anguish they suffer. The defendant, in our case, Ms. Reed, knows it as well, because if you do see the video, with a smile, she acknowledges the consequence of her actions and seems to encourage it impliedly. And so this evidence should be available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Cannoni if appropriate, and then she should decide the admissibility in the Commonwealth v. Karen retrial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today, and I'll endeavor to get your response as soon as possible. Thank you.
Thank you.
It's been worn. Yes, and my teenage kids are. Yes, exactly, exactly. So if you want to, reupholstering is really expensive.
Change the courtroom now. Okay, I don't know why we were suddenly looking at a person here, and now we're going to look at a fan. So I'll just go ahead and get us off that until they are ready to go forward in Karen's case. Well, that was exciting. I didn't know we were actually going to get this part of the hearing televised. The way that Dr. Turtleboy had announced it was that they were going to be in the large courtroom for this, and then afterwards they would move upstairs to Judge Cannoni's courtroom. But it looks like we're in the same courtroom. Doesn't it look like we're in the same courtroom? The judges just kind of swapped out chairs or something. So I'm not seeing the link here between Karen provided information to Aidan Kearney and Karen then endorsed, let alone intended, the subsequent use of that information. We would need at the very least some kind of a timeline, you know, like she provided him this, and then at this point, some actions were taken and she knew about them and she continued to provide the information. Or at this point, you know, Aidan Kearney said something about his intentions and she knew about it and she endorsed it and continued to provide information. Like there's really nothing like that that's been established. And so just the mere fact that she gave him information and third parties did stuff with that information, that's not a link. That's not providing the nexus that she even, you know, knew about it, let alone that was her intention in providing it in the first place. So that's the problem that I have with the consciousness of guilt stuff. That kind of relates to Mr. Bradle's argument that, yeah, communications, pure speech, you cannot criminalize that. Pure speech is constitutionally protected. Very interested to hear about, I might have to go look now because I'm a nerd like that, but independent Massachusetts constitutional jurisprudence on provide all proofs. Provide all proofs. That's interesting. I'm inclined to look. I love that kind of stuff. We have, as I've mentioned, I'm sure many times here, our own independent state constitutional jurisprudence when it comes to search and seizure. The federal constitution just kind of gives you a floor of what the rules have to be, but states can give you more protection than the federal government if they want to. In Washington, we have much more protection against search and seizure than in the federal government under the Fourth Amendment. So we don't even really have to brief Fourth Amendment stuff in Washington. We'll bring it up to preserve it for habeas and getting into the federal courts and things like that. But typically, if you got a good search and seizure issue, it's going to be stronger under Washington law anyway than it is under federal law. So it sounds like they have a equivalent type of thing in Massachusetts, but with respect to speech and with respect to the First Amendment, which is so ironic to me, given how easy it seems to be to charge somebody with witness intimidation based on speech or based on, communicative types of conduct, like leaving a rubber duck somewhere. That's quite bizarre to me. So yeah, it's protected. It has to be within an exception to the First Amendment if you're going to be able to be penalized for that. And so, what counts? True threats. True threats count. But if we had, proof of true threats, and I don't think these motions to dismiss would be, being granted the way that they have been. I don't think that this would, not be anywhere near as close of an issue. A true threat has a very specific legal definition. Person has to be placed in reasonable fear that the threat has to be a threat, a serious expression of intent to inflict serious bodily harm or death, and the person has to be placed in reasonable fear that the threat will actually be carried out. Don't know that we've reached that hurdle, and certainly not by the time you are attenuating this all the way back down to Karen Reed provided information to Aidan Kearney. You're far from the universe of establishing a true threat. There's an exception for speech that is inherently criminal, and that will apply to things like perjury. That will, could potentially apply to something like a witness intimidation. But again, it seems like you got to kind of establish that crime before you can show that exception would apply. And the grand jury looking at this, as they keep pointing out, has already decided that didn't happen. So I don't think you're going to fall within the exception for, the speech constitutes, it's like inherently a criminal act, because the grand jury already said, no, it isn't. I think that's a pretty good argument. I like this judge. Boy, it's kind of nice to get a little bit of a break and get to hear from a judge who is sharp. He knows exactly what he needs to hear. He's able to direct them the way he needs to go. He's direct, and he's going to control his courtroom, but he's certainly polite with them. The fact that he gave them the opportunity to be heard, that's smart. Yeah, that's smart. It's her own case. How does she not have standing to be heard with respect to her own case? You err on the side of letting her be heard, instead of just doing what you feel like doing and expecting the appellate court to sort it out if you're wrong. So that, I think, was a prudent decision by that judge, and also just kind of shows open mind. Really nice thing to hear from a judge, because of course when AJ first comes in, he's very skeptical. He's not sure that Mr. Jackson even has the right to be here, let alone to be addressing the court. Made that very clear. How do you have standing? This is Rule 17. But yeah, it's his case. And so on reflection, the judge decides to go ahead and do it. So first instincts might have gone one direction, but upon consideration, he changed his mind. I love a judge who can change their mind. Oh, so how do we get that guy on this case? Unfortunate that can't that can't happen. Not a fishing expedition. I think it's pretty good to bring that up. I would have perhaps emphasized that not only Ms. Little is focusing on the affidavit, doesn't address these elements, but that in and of itself isn't really dispositive, because if you can infer it, from the affidavit, even if it doesn't expressly say so, you're still going to be fine. But it's the fact that this subpoena is so broad, as the judge is pointing out, that's what undermines the argument that it's not a fishing expedition. If all you want is consciousness of guilt, you don't need all the communications. You just need ones that tend to show, one, Karen Reed intended to intimidate witnesses or to, interfere with their testimony or change their testimony or something like that, and provided communications that were relevant to that purpose. You don't need all of the details of exactly what she did, and you certainly don't need stuff like, Aidan Kearney's calendar, his communications with other people. All you need is the stuff that's very, very relevant to Karen Reed. So if I am predicting the outcome of this motion, that's where I think it's going to land. He's going to say, yeah, some of it could be relevant, but nowhere near the scope of what the Commonwealth is asking for. He's going to narrow the scope dramatically. That I wouldn't necessarily have a problem with. They can receive anything that shows she had the consciousness of guilt. If that's the relevance, then yeah, they should be entitled to that. But the question is going to be establishing what consciousness of guilt is in this context, and I think that has to be limited to she intended to have some type of impact on the witnesses. She was trying to interfere with the course of justice. That's the whole argument of consciousness of guilt. You know, you did it. So you're trying to conceal your tracks. You're trying to cover things up. You're trying to fix things after the fact, stuff like that. We get like, it's so common. You get jail calls that come in as consciousness of guilt because somebody's offering to pay somebody off, somebody's asking for things to be taken care of. It's happens a lot. So sure, if they could establish that, probably is relevant, but I don't know that they're going to be able to clear that hurdle. So that's where I'm at if I'm the judge in this case. I did go back through my notes. Looks like they're getting close to getting started in the other one. But the motion in limine that they addressed was the one regarding witness intimidation. And so, yeah, okay, they're talking about being harassed by the blogger, et cetera, et cetera. He's not going to go into that, but he's going to go into what she wanted to. I'm not quite sure I see this line that he's trying to draw. He's saying they can't talk about their feelings about it, but he can try to elicit that it actually happened. I really don't know. How and where this dividing line is in Mr. Brennan's mind between he's not going to get into witness intimidation, but he's going to try to use witness intimidation or what he alleges is witness intimidation to prove she had consciousness of guilt. I don't know how you square that. I don't know. Chat. You got any ideas what the difference is about that? I don't know. I'm still seeing the fan over here on Law and Crime. I heard they got the Zoom set up, so I do think they are ready to get started momentarily. But I don't think we're quite there yet. Probably waiting for Judge to come into the courtroom. So, yeah, boy, that's where I would emphasize the fishing expedition is the breadth. The breadth is what gives it away. The breadth is what gives it away. The fact that they're looking through all kinds of stuff that doesn't have anything to do with Karen Reed's intentions. What does Aidan Kearney's calendar have to do with Karen Reed's intentions? Just a simple question. What does his calendar have to do with her intentions? I'm not seeing it. Can they show that that's relevant? I doubt it. They want to all right, so it looks like NBC 10 has it. So let's go ahead and get going over there. Let me shut that one off. Let me get us to our live. And we will go ahead and get started. Let's see, is it this one? I believe it is.
In a case that specifically says under these circumstances, a Commonwealth lawyer is obligated to obtain a Rule 17 subpoena to pursue or obtain other information
Is
available
this
in
the
a
same
separate
thing
case.
that we just
But these
watched?
are a bit unique in circumstances in that I am a specially appointed
Yeah,
prosecutor.
this is what we just
to
watched.
Karen Reed's
So,
case, Commonwealth versus Karen Reed.
okay, let me skip us ahead here. Oops.
Massachusetts. This court is now open.
All right.
You may be seated.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Avalon for the Commonwealth. Good morning, Your
Good
Honor.
morning, Mr. Lally.
Good morning,
How's
Your Honor.
our
Hank
sound
Good
here?
morning, Mr. Brennan.
Am I a lot louder than the court?
Good morning,
Are we
Mr.
doing
Jackson.
okay?
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your
Or
Honor.
a little
Robert
bit,
Leslie on
just in
behalf of
case.
Ms. Reed.
Good morning, Mr.
You're on the
Leslie.
side of
Good morning, Your
being
Honor.
louder
David
than
Unetti
me.
for Karen Reed.
Good
Maybe.
morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so we have a lot to cover this morning, but what I want to start with, I was just handed a couple of things too that I'm going to need some time to read.
So are we going to immediately go into recess?
What I'd like to start with is paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
Hang on, guys.
I'll address
Let me just pause here. I got another screen going somewhere. I don't know. Is somebody is replaying? I think it was the other one. Okay. Sorry about that,
Court, with court's
guys.
permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately, along with
All three indictments, correct? You're defending all three.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that that probably is the better practice. And we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance. And I'll submit.
All right, does the Commonwealth want to be heard on this?
Of course he does.
Your Honor, the Commonwealth is relying on advice of appellate counsel. I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse. The concern is that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible. There is an expedited scheduling order, which could hopefully imply that there's going to be quick progress in the federal court, but we don't directly communicate with them or have any control. Our hope is that if there is a short continuance, it accommodates the defense's concerns. I understand the trial strategy for different charges is somewhat different. But most importantly for the Commonwealth, the hope is that it sets a benchmark that will allow the First Circuit to resolve the petition, or if they're going to allow oral argument, a benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly and that we can have this trial in April.
Okay. Well, I'm not going to grant the motion. All
No,
right.
I knew
We
she would.
have jurors coming in that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks. I'm not going to do that. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches, and we'll take it from there. But we will start April 1st with impanelment.
Thank you, Your Honor.
Okay. All right. So let's go to the next motion, and then we'll go back to doing them somewhat in order. Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of what you just handed me? Because I don't know where I put it.
Can get.
So we're going in weird order now.
I have it
Buffer
here somewhere.
zone was filed late.
So we did hear from people this morning. I know you all have, I have it. I have it, Jim. I think Mr. McDermott gave you a copy of, I guess, what local merchants have requested.
We received it.
Okay. All right. So I'll hear the Commonwealth on your buffer zone motion.
I knew the jurors would be the hang up. And I mean, that honestly is kind of
Your Honor,
fair.
the Commonwealth's primary concern is the sanctity of the jury and the jury process.
The same, I'm sure it
We
is.
are
the
concerned
sanctity
based
of the
on
jury.
past reports and information that noise, interruption, and other uncontrollable events can potentially impact the jury's consideration in this case. They should be free from outside influence, so it does not in any way oppress or push them in any direction, either way in this case. The courthouse is very close to the public areas where people congregate. It's been reported that during the trial, the jury would be able to hear outside noise and influences, not just honking of horns, but other types of noise that could be influential, intimidating, concerning. And so we've proposed
Like what?
what I think is reasonable and minimal
What intimidating noises?
recommendations to the court to move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence of the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being wholly familiar with the Dedham area. It seems that is one of their concerns. I think they mentioned an open market. In my memory from coming by on other cases at other times, there appears to be open markets in that area. And so if that's influencing their business, that is a separate but related concern that
Yeah, I don't know
they
about
have
merchants
expressed to the court. And I do
walking.
think that the court should be sensitive to the community's concerns. But importantly, that closeness and that amount of volume and influence on the jury, I think, can affect the sanctity of the jury. I don't think it is a strong imposition to consider the streets that have been identified in our buffer zone motion and have the buffer zone include limitations to those certain streets. And I think that will potentially help some of the outside impact and adverse influence on the jury.
All right. There's a portion of your motion that I disagree with. Do you want to be heard on it? About the court enforcing or enforcing the buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce the laws and regulations as law enforcement sees fit. And so I don't think that burden should be imposed upon the court.
Thank you. All right. With that, does the defense object to the buffer zone?
We take no position.
Okay. All right. I'll take this under advisement. I have to figure out exactly how far this is. And I have not yet had a chance to read and consider today's email from the merchants. Okay.
Got an email.
Yes.
Well, it should be made part of the record at some
Can I
point.
just have this marked for identification for this hearing, identification? And from the record, that came from the Dedham Square Circle, the organization that runs the Dedham Farmers Market.
Okay. Dedham
Thank you.
Farmers Market.
So we can talk about the witness list when we talk about impanelment, when we really have the heart of the final trial conference. But I do need at least cities and towns from these witnesses. Neither side gave them to me on the civilian witnesses. So, and there's a lot of overlap, and you'll have to fix that for any final trial conference report anyways. All right.
Your Honor, could I be heard on that one issue, just briefly?
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth. We did not file that publicly.
Okay.
We'll happily add the towns for the court. But I would note that the Commonwealth has not yet turned over that information that's required under the new rules. I believe they put a footnote on their witness list. I think, they can't shield themselves from their discovery obligations. It's mandatory under the rules. We'd ask that they comply with, the requirement that they provide us contact information for their witnesses.
So there is a footnote. I'll hear you, Mr. Brennan.
A footnote. I don't remember a footnote.
Your Honor, the motion notes that the Commonwealth moves to be partially exempt from Rule 14 because of the past history of perceived harassment and intimidation of witnesses, which the Commonwealth believes is ongoing. I think a potential resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal. I think that is protecting the interests of the Commonwealth and the witnesses from.
I don't have a problem with that. I still need cities and towns.
Of course.
Okay.
Yes.
All right. Thank you. So we will start with it's paper 593. The Commonwealth's response is paper 610. Defendant's motion eliminated to allow evidence of lack of bias. Who's arguing that for the Commonwealth?
That's the defense's motion. So
The Commonwealth first, Your Honor.
Oh, it's defendant's motion.
yes,
The Commonwealth opposed it.
yes, but you just said
Who's arguing that for the Commonwealth? That's why
I'm
I-
sorry, defense motion. Okay,
that's fine.
sorry, I
Yes, good
apologize.
job,
I
Judge.
could go first if you'd like.
Excuse me?
I could go first if you'd like, whatever. the
I'm
court
fine
prefers.
with him going first if you'd like.
Okay.
Weird.
I think the heart of this motion is that the defense would like to introduce the ARCA witnesses as witnesses that were employed by the federal government. I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment and at the time they wrote the report. And then subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation and report. I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial. As we stand here today, the Commonwealth does not have a clear answer why this investigation was initiated, what the purpose of it truly
Why
was,
does that
the
matter?
scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications
Nothing to do
between the
with
federal
ARCA.
government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCA and what, if any, impact the defense had on ARCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the opportunity to provide information to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. What we know is that the ARCA witnesses were supposedly tasked to conduct an independent investigation, and they were given materials. We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials that they weren't given. And so clearly there is an undefined relationship between the defense and the United States Attorney's Office around this time of this investigation. And we subsequently learned that there was a continued relationship. And so today, as we sit here, we really don't know. What we know is ARCA listed materials that they reviewed that came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory. And so that's why we began by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it.
So they don't
Other
actually
Rule
have a
14 discovery,
relationship and they can't comply.
Obligations have not been complied with.
Does
We've
that
received
answer
no
your question?
information since that production on February 13th, nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. And so it would be misleading to have ARCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts and report was wholly and entirely objective. Just to give one point that emphasizes the concern, the ARCA witnesses were never given information about DNA. And yet when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA, and separately there was a hair, Mr. O'Keefe's hair. And so we know they didn't have all of the inculpatory information, and then the question still remains, how did they learn of that? How did they learn of that information before cross-examination?
Because it came up
so
in
I
trial.
think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about their directives from the United States Attorney's Office. They should answer questions about the materials they received. They should answer questions about what they were told or what they knew about the case. They should answer questions about all of their correspondence with the defense, including phone calls, emails, text messages. All that should be produced. It's not a Lanigan hearing where I question their qualifications, but if we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if the ARCA witnesses come in to be questioned as they should well before trial, in my opinion, we do not have the opportunity to question the United States Attorney's Office. We're resigned to TUI letters, which inevitably have been unhelpful. And so I think it sets a bad playing ground to have them get up and say they were hired by the federal government, because then the Commonwealth will be inclined to explain the inculpatory evidence, the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case in all related investigations.
Prove that, Mr. Brennan. Here's the witness you're going to call.
Would like to propose. And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did at the first trial. They were hired independently. And then subsequent to that, the defense retain them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery. And inevitably at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved. And
Is his name on the witness list?
I haven't seen it on the witness list.
No, Your Honor.
And we still don't know why the defense chose to call 2 of 3. As you noted, that report is vague. And so it doesn't identify, articulate which witness did what. So it's impossible for me to imagine how you would choose 2 or 3 of those witnesses. But more importantly, you can't effectively cross-examine a witness because, as we saw from the second witness, Dr. Rentschler, when he disputed DNA, which we don't know where the source of that came from, he is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply, but we haven't seen compliance, and I don't think we will. So my suggestion is to follow the protocol of the last trial, but before that, these witnesses should be brought in so that we can obtain actual records, not just ask them the questions and rely on their word. I think based on their past performances, that's insufficient. I think we should have a right to the records to demonstrate the relationship.
Mr. Yannetti?
Thank you, Your Honor. Your Honor, the Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARCA witnesses became involved in this case. Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. Mm-hmm. The defense wants the jury to know the truth. In the first trial, this court disallowed the ARCA witnesses from testifying about who hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions. But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved.
Yeah.
I think the court will agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate,
and,
right?
But the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that. If Ms. Reed's insurance company had hired ARCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into.
Okay, so first of all, and this is later in my argument, we're not asking.
So, no, could you answer that now and then? I'll let
I'm
you say
trying to,
everything.
Your Honor.
Oh, you
If
just said it's late. Hold on. You just said it's later in the
I
argument.
know, but I said, you interrupted me and I was just about to say, but I'll address it now.
Okay.
God.
We are not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an investigation, whether there was an investigation, whether there was a federal grand jury, what that grand jury did, what that grand jury considered, nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved, and it all inures to my client's, to prejudice my client. Thinking that they were potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball, when that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got, Mr. Brennan engages in a ton of speculation about what happened or didn't happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government, and I complied with that subpoena.
Wow.
We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA. And they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that ARCA should be allowed to testify that they were hired by the federal government to prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was complied with. And all of a sudden it was revealed to us that the federal government had hired these ARCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them. The Commonwealth chose not to contact them because the information was exculpatory. The jury should not be left with the impression that Karen Reed or the defense team had anything to do with hiring them or with their conclusions and opinions. The conclusions and opinions were revealed to us at the same time, and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination material. He's free to explore whatever he wants on cross-examination. So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCA came into the case.
Okay.
He can't comply with the federal subpoena for his entire file without Karen agreeing to it. Karen agreeing they can have the whole file. She's got nothing to hide.
Respectfully, the Commonwealth does not to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate's side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government and the jury is entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered, and what their directive was.
You don't hear that
from the federal government regarding direction, scope, purpose. We have nothing. Now, I didn't know that Attorney Yannetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew. I've never heard that before. I don't know how the defense knows what the federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship.
They wanted his
with
full
the federal
file.
Prosecution in this case, or their investigation. We didn't have any interaction, not because we chose to hide from exculpatory evidence, so we were hiding from the truth. We weren't invited. We didn't know. Now, I hear now that Mr. Yannetti's file was subpoenaed and information, whatever it was, his entire file was given to the federal government and they chose whatever they chose. This report by ARCA was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Yannetti on March 29, 2023, describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was obviously a relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence and information you have. As you've seen from the ARCA witnesses, from my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence. I do not think that cross-examining a witness, you should consider the witness a trustworthy guide unless they've established their credibility. I don't see that in these transcripts. So I will need materials to hold them in check and to hold them accountable for whatever it is their bias. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth, it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire trial trying to advocate influence or no undue influence with these witnesses.
It's absolutely not necessary to do that. And frankly, just saying
these witnesses prior to trial,
you were hired by the feds,
the same protocol you did last time.
Potentially helpful to the Commonwealth.
All
It
right.
sounds like the feds were involved in investigating Karen Reed.
If defense intends to call the ARCA witnesses, we need to have a voir dire next week. All right. So we're going to move on. I'll take this under advisement.
Can I just ask the parameters of that voir dire, the purpose of that voir dire?
Yeah.
Unless Rule 14 is complied with, it will be for the Rule 14 information. We can discuss this later. Let's move on, and I'll hear any objections later. All right,
yeah.
so the next
We need ARCA back for yet
motion
another
is the
court here.
defendant's motion for stating grounds for objections. I'll hear you on that, Mr. Yannetti.
Yes, I believe my written submission essentially makes the argument, Judge, but
Okay.
During the last trial, as a result of our inability to state in one or two words the basis for an objection, we had to go to sidebar far more often than we'd like to. And we're also conscious of the fact that, we have a jury sitting for weeks at a time away from their families, away from their jobs, and any, sort of view that one side may be delaying the trial could engender some hostility from the jury. So, there were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was. And the court made a ruling on that objection. And I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth was, what's the basis for your objection?
To make a record at that point.
I understand, but it's, what's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know
I
it.
agree with that.
And
You should have known the basis for the objection.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary rules whatsoever. But in any case, this will avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender hostility from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity. We think that this would, and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections as long as there's no trying to coach a witness or, trying to influence a witness in any way. And that's not what we're seeking to do here. The objection hearsay, the objection lack of foundation, just standard basic objections. I think there's no prejudice to stating them in open court. It will move the trial along more quickly. It'll allow my client to preserve her due process rights. And we'd ask the court to change its ruling from the first trial.
Okay, that motion is denied. So the next motion, defendant's motion, eliminate to exclude false and irrelevant statements of Michael Proctor, 591. Does the Commonwealth intend to put this evidence into the case?
We do not.
Okay.
So we can agree to that motion.
All right, so that motion's allowed, Ms. Tianetti. There's a defendant's motion for reconsideration of the March 6th court order denying defendant's motion to exclude witness Crosby. Mr. Alessi, what I'm going to do with that is if I can readdress that before rebuttal, before the witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right, so we can address it later.
Thank you, Your Honor. And also, just so I'm clear on that, and to the extent we argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it, after Dr. Russell's testimony. All right, there's a motion. It's 599. Defendant's motion, eliminate to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So we don't need to belabor this. We talked about this before. No one has contact with the jurors other than the court officers. So defendant's motion, eliminate to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So there's that. So I think now we move on to something that may take a little bit more time. The defendant's motion, eliminate to exclude the testimony of Dr. Judson Welcher. How do you pronounce his name, Mr. Brennan? Welcher, and the Commonwealth's opposition. So who's arguing for the defendant and how long do you think this might take? Because we can do some of the quicker Commonwealth motions if you want.
I am going to make the argument, Your Honor, and I estimate 40 to 45 minutes for this motion.
Okay. Mr. Brennan, how long do you think you'll take?
It's really dependent on what Mr. Alisi says, but I can't imagine it's more than 15 minutes, perhaps 10.
Okay. All right. Before we go there, there are a couple of the Commonwealth's motions that seem pretty quick that I just wanted to know if the defense had objections to. To appoint a stenographer, we've already done that. Prevent identification of jurors and impound the juror names during trial. Why don't we do a few of these, then we'll take the recess around 11, and then we'll come back with the lengthier motion. So I'll hear you on this, Mr. Brennan.
Thank you. Which motion, Your Honor?
It's your number 1, 575. Commonwealth's motion eliminate to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
Okay. Preventing identification of jurors. This case is a case that has garnered extraordinary public interest. There are some concerns that in the history of this case, jurors have been identified by different characteristics, whether it's their hair color,
Tagging anybody from
their
describing
profession,
the jurors
and
is not going to
inevitably,
fly.
as the trial progresses,
She
it
might
seems
do it.
through sometimes the media.
That's a constitutional
the
problem.
Jurors, although maybe not identified by name, have some of those characteristics
He is
promoted.
allowed to report
That
independently
would
obtained
cause, I would
information.
think, a strong concern by a juror that their verdict could be disfavored by one side or the other. That's the last thing I think anybody in the courtroom would want. And so the jurors, I suggest, should not be identified before, during a panel, and during the trial. I think the jurors' names should be impounded. There has been past efforts by many to identify jurors, interview jurors, get information about jurors that is then highly publicized. That will chill, I think, the process of deliberation in a fair trial for both sides. I think it is a measure that is accepted, it's appropriate, and under the circumstances of this case, I ask the court to do that.
Any objection from the defense?
Your Honor, we have no objection to appointing a court stenographer, impounding jurors' names and information, and in fact, we join in that request.
Okay.
The motion, however, also asks for the impoundment of all sidebar discussions. Before I address that, I guess I would first ask whether Mr. Brennan is pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors?
Well, if it's sidebar discussions regarding jurors, we're in complete agreement.
So sidebars are impounded regarding jurors anyway.
Right. So we're in agreement with that. I interpreted the motion perhaps incorrectly that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listening to FTR.
Okay, well, that's what I'd like to address.
All right, so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a change.
This is a new trial, Judge.
Right, no, so just to be clear, this is a change.
I don't recall what we did or didn't do last time, but this is our position for this trial. Obviously, the reason some discussions are held at sidebar is to prevent jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right. There's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a courtroom be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information, but the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
All right. So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
Yeah, good question.
I don't have an answer to that. It's something I'll need to look into because it is
Oh,
a
my Lord.
legitimate concern of the Commonwealth, but there needs to be authority. And I can't say right now I have authority for it. I can tell you the
Brought a
concern
motion
is
without
that
authority.
many of the sidebars help vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information, whether they're looking at news reports or not, whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment.
No,
It's not an
because the
attempt
jury
to
isn't
deprive the
supposed to be
community
listening to what
of
we're
the full
saying.
value of the public trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion. The cottage
That's
industry
more
in ways,
reason for
unfortunately.
openness.
And that creates an enormous amount of social media and media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny in social media,
to listen to
that's the government's concern. But I agree the government should have a legal basis. If you'd give me an opportunity, we can offer the court whether we have that basis or not, but I can't tell you that now.
All right. So I am taking a lot of these motions under advisement. I'll give you until tomorrow afternoon.
Thank you very much.
Is there an objection to, it's 577, it's the Commonwealth's Exhibit 3, Motion 3, Commonwealth's motion for in-court identification. Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk. And the next one, Commonwealth's motion eliminate to admit the victim, one photograph of the victim, two photographs of the victim's injuries as observed by medical providers during the autopsy. Is there an objection to
No
that, Ms.
objection.
Little? That's allowed. 578.
Thank you.
So the manner of death, so that is on the death certificate. So this is your number 5, Mr. Brennan, paper 579, Commonwealth's motion eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate.
While apparently also
Oh, yeah,
wanting
that-
another
yes.
expert to testify to manner of death. Let's be clear. Exactly what he seems to want.
Pursuant to Mass case law, Commonwealth versus Almonte and Wallace, as we've laid out in our memorandum, we would like to have the cause of death redacted from the certificate. Certainly, the defense can cross-examine any witnesses that are called regarding the manner of death, but this notation on the death certificate is extraneous and it should be inadmissible. General Laws, Chapter 46, Section 19.
What?
provides nothing contained in the record of a death which is reference to the question of liability for causing the death shall be admissible in evidence. Again, different when questioning a witness that is offering an opinion regarding the cause of death, but the certificate itself should be redacted, and it should follow Massachusetts general laws, and it should follow Massachusetts case law. And for those reasons, we ask the court to redact any cause of death in the death certificate itself.
Right, who's
He's
arguing this for the
confusing
defense?
cause and manner of death. He's conflating all this. This is messy.
In this case, the medical examiner who completed the death certificate concluded that the manner of death was undetermined. The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks not only to have the court redact the manner of death here, but they're also not calling the medical examiner in this case, which creates certain issues. All of the cases cited by the Commonwealth in this matter deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death without redacting the word homicide, because it violates a defendant's constitutional right under the 5th and 14th Amendments to the United States Constitution. That is not the situation that we're presented with here. None of the cases cited by the Commonwealth that were just referenced by Attorney Brennan stand for the proposition that a death certificate listing the cause of death as undetermined should be redacted. If the court looks closely at even the cases cited by the Commonwealth, specifically Commonwealth versus Ellis, I'd urge the court to carefully read that opinion, because what it says is that the SJC identified the words that best practice dictates should be redacted from a death certificate. And what the SJC said is this, and this is dicta, it's not even true case law. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that is the word undetermined. And that's because undetermined is not a finding of liability. That is what the whole statute was meant to protect from. So there is no case law that suggests that the word undetermined should be redacted from a death certificate. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred. And the Commonwealth's own medical examiner has opined that she was unable to make that determination in this case. That finding is relevant, it's exculpatory, and it should not be redacted from the death certificate.
So you say the medical examiner is not testifying?
It's not, I believe the medical examiner is not on their witness list.
Oh, I thought I saw Dr. Scorti-Bello. Oh.
Not on their witness list.
Wow. I didn't notice that. Want to clarify, Hank? You could clear it right up right now. Just stand up and say if she is or isn't.
She's number 81 on the Commonwealth's witness list.
All right, I'll take this under advisement. I'll take a quick look at Ellis again.
I would just note, I apologize. I know Attorney Brennan did represent at one point that they are not likely to call the medical examiner. So that was my impression.
Okay.
Perhaps I'm incorrect.
That's fine. Thank you. All right. One last, hopefully quick one. Commonwealth's motion to eliminate to introduce certified records from the Registry of Motor Vehicles. Is there an objection to that, Ms. Little?
No objection.
Okay. Probably one more quick one. So that's paper 580, Jim?
Thank you.
Commonwealth's motion to eliminate with the intent to obtain query records of potential jurors. That's allowed as long as it doesn't disrupt the trial in any way.
May we be heard on that?
Sure.
Your Honor, potential jurors are asked when they fill out the jury questionnaire whether they have a criminal record. They're also asked if they know anybody in law enforcement. They're asked if they've ever been a victim of a crime. And for every other answer on the questionnaire, the parties must accept the potential juror's answer, which that juror is giving under oath on the form itself. In fact, there are times when a court may deny an attorney from inquiring further about a clear answer on the jury questionnaire, precisely because the answer was clear and it was given under oath. It is solely through the issue of a past criminal record that the Commonwealth seeks to question whether potential jurors are telling the truth. If someone claims not to know law enforcement, the Commonwealth is content with that answer. Does not ask for permission to conduct any further research. If someone claims never to be a victim of a crime, again, the Commonwealth is content with that answer and is not curious about whether the potential juror is telling the truth. In other words, it is the potentially hidden, if the potentially hidden information benefits the Commonwealth in their viewpoint, they're fine with that. The only way to make this process fair to both sides, therefore, with regard to this motion, would be to release to the parties the jurors' questionnaires in advance of trial so that each side can do their own independent research and investigation to vet the potential jurors in the pool. I know that there is case law to support the invasion into a juror's privacy regarding a check on the existence or not of their criminal records and a vetting of potential jurors' truthfulness. But it is interesting that the very first case the Commonwealth cites, the Hampton case, stands for the proposition that criminal records of prospective jurors are not an indispensable or necessary means to the selection of an impartial jury as a matter of federal or Massachusetts constitutional law. That was a case in which the defense had sought a query check of potential jurors, and the judge denied that request. And the SJC said it was fine to deny the defense's request. That means, Your Honor, that you would be justified in exercising your discretion to deny the Commonwealth's request to be allowed to invade the privacy of potential jurors, because pursuant to Hampton, it's simply not an indispensable or necessary way to select an impartial jury. Having said that, Your Honor, if the court is inclined nonetheless to allow the motion, we ask for an order that every bit of information turned up by the Commonwealth in their investigation of jurors be turned over to the defense.
I think that's the common practice of this office. What do you say to that, Mr. Brennan?
Is it the common practice of this office?
The Commonwealth gets to investigate jurors and the defense.
Your Honor, is the court's question common practice of giving everything, or is it common practice of running queries?
It's actually seems to be both.
I believe I've been informed that it is the common practice, and that is the practice we would follow to give everything to the defense. I think the assumption that the Commonwealth would not want somebody with a criminal record on the jury might be misplaced. Somebody who has a criminal record shouldn't be precluded from jury service. In fact, maybe people who have a criminal record in re-entered society who the Commonwealth would embrace as jurors. But sometimes people forget or mistake that they have a criminal past. I understand may have happened in this case, has happened in many of my cases. And the nature of any past criminal record is sometimes helpful to see if there's an association between that and the charges in this case. So we would embrace providing everything to the defense and ask the court to allow it.
All right. If you remember, I give a catch-all too to the jury that sometimes we're in a hurry to fill out these forms. Sometimes that when we get these questionnaires, we think, well, this situation may not apply to me. So I give them time before they come up. And I specifically say, perhaps your experience as a witness or a juror or a defendant in a criminal case, or if there's any prior record, things that you may have forgotten. If you didn't include it and you remember it, please tell us when you come to sidebar. And inevitably, every trial there's somebody that says they forgot to say something, or they had a record that, got in trouble when they were 17 or something. So it happens.
Right, and that's an argument against the Commonwealth's motion, because you're giving the jurors a chance to correct what they put on the initial form. There's no need for the Commonwealth to do their own independent research to confirm or deny that.
All right, so you're asking me to flat out deny the motion, but if I allow it, you'll get the copies?
Correct.
Okay. All right, why don't we take the morning break at this time, and we'll come back and we'll do that motion, the defense motion regarding Dr. Welcher.
All right, please.
Now,
You are muted.
I will acknowledge that I think personally it's, people don't forget that they have a criminal past. But I definitely am sympathetic to the idea that people don't necessarily either know or pay attention to the details of what that is or its implications with something like jury service. Felony conviction makes you ineligible for jury service, but there are ways to go in and get your rights restored. I don't know what the process is in Massachusetts. In Washington, we have some automatic rights restorations, different things at different points in time. Sometimes it's upon the release from incarceration. Maybe it's on, finishing probation. Most people aren't going to know the ins and outs of those types of details. So they may or may not know if they have, eligibility for jury service. And frankly, people don't even always know if they've been convicted of a misdemeanor or a felony. People don't always even know if their case resolution constitutes a conviction. Examples are things like deferred dispositions or deferred prosecutions, the type of thing where like you go in and you plead guilty, but they stick it in the file and you're on probation for a year and you have to do certain things. And then if you comply with that, we go in and we withdraw your guilty plea and then the case is dismissed. Is that a conviction or not? Well, that depends, and it can get really complicated because under certain federal laws, yeah, it still will be. They'll still consider anything that enters a guilty plea to be a conviction. But under state law, it might not be. And for purposes of jury service, it might not be. So that stuff can get kind of technical, I would grant that. But I think the point would just be that you need to encourage in how you draft your questionnaire, jurors to be provide more information rather than less, because it's really your responsibility to make sense of that and determine if they are not qualified to serve by virtue of that prior history. That isn't necessarily their job to have to do that. So it does seem pretty selective, doesn't it? If they have case law in Massachusetts, so there are some places that have case law limiting your ability to go and investigate jurors. From my perspective, there's nothing like that in Washington. One of the first things you better be doing is going as soon as you get your jury list. You usually get it the night before the trial starts. You need to go and check them on social media. You need to go and see, what they put out there publicly. If they are court followers, news followers, things like that. Particularly in cases, that have been covered in the media. But there are some places that have opined that you aren't allowed to do that. That it's an invasion of privacy. I have a hard time seeing how investigating stuff that people have put out there publicly would be an invasion of privacy. Using any type of resource that's publicly available, to me, that's stretching what an invasion of privacy is. The whole, Fourth Amendment context for privacy is, do you have a reasonable expectation that this information is going to be kept secret? And if you've put it out there on your Instagram, your Facebook, whatever, you don't have an expectation of privacy in that. There's nothing that says police need a warrant to go and scroll through your public Facebook page. So I don't know. It sounds like Massachusetts may have some case law that says jurors have privacy. And so, but now criminal history, these types of records, typically are much, much more protected because we don't all have access to them. The prosecutor and law enforcement has access to them, but Ms. Reed, the defendant, she can't go run a check in these databases. She doesn't have access to it. So I don't know if their case law is just limited to this particular criminal history issue, if it's something broader that deals with investigating jurors. I really don't know. Yes, they should get the questionnaires ahead of time. They need time to review the questionnaires anyway. It shouldn't be a situation where you're handed a stack of questionnaires and the jurors are immediately being called in and brought to sidebar, and you're having to evaluate the questionnaire, while they're while they're answering questions. It certainly shouldn't be like that. You need some time to read it and digest it. And, yeah, if you have a team and the ability to do it, you should have the opportunity to investigate what you can while that process is going on. So just my thoughts about that. Commonwealth's common practice, she seems to think, is to do this anyway. Do they always ask for leave? I don't remember them asking for leave to do this in the last trial. Did they not do it then, or did they just do it without asking? I don't know. But it sure seems to be a little bit alarming if they need that authority and they haven't been asking for it. Well, boy, I don't know if they're going to call the medical examiner or not. I guess she is on the witness list, but apparently Mr. Brennan represented at some point that he might not. That would be a little messy. That would be a little messy, wouldn't it? That would be up there with not calling ex-trooper Proctor, not calling the lead investigator. We thought that might be a possibility at the last trial, just because all of that impeachment information, as far as the text and stuff, was already, they already had it. They were going to be able to use that. He didn't have the internal affairs issue going on at that point in time. It kind of seems like it was the publicity of the trial and all of that coming out in the trial that finally got Massachusetts State Police to recognize, this guy's making you look really bad. You probably ought to do something about it. So they didn't have that particular piece of it, but they certainly had all those texts. And so, yeah, we wondered, what if are they going to not call Trooper Proctor? And it looked that way for a minute, too, because when they had Trooper Buchanan on the stand, they were asking him a lot of things about Trooper Proctor's part of the investigation. So, for example, one of the things that I had been looking out for, Trooper Proctor signed that affidavit where he says he sat down and watched the video from the waterfall and from CF McCarthy's, and he counted the drinks and he provided the timestamps for when he saw Karen Reed take a drink or saw her buy a new drink or something like that. I was like, better be able to back that up once we get this video in. And they presented that through Trooper Buchanan. So I remember wondering, are they trying to avoid getting Trooper Proctor on the stand? But it's just very, very difficult to do that without sacrificing, certain aspects of the investigation and so forth, because he was the lead, that he was he's the only one that can testify to. So, not calling the medical examiner is not maybe that bad, but it would be pretty bad because, yeah, again, of course, the defense would then call her. And this motion, I don't understand. I guess now I'm confused about what he's even asking, because he's saying, well, they can cross-examine about it. If it comes in anyway, then why does it matter if it's on the death certificate? It doesn't make any sense. So yeah, it's exculpatory. Her testimony in the last trial was, as part of making her determination, she gets the information from law enforcement about their investigation and their theories, and she incorporates that into deciding what the manner of death is. And after hearing all of their theories and so forth, she couldn't say, yeah, that sounds right. She couldn't do that. She had to put undetermined. Why? Well, maybe because, as she testified, the injuries are not normal injuries that you expect to see from a motor vehicle collision. Nobody talked about not describing the jurors. That was part of the Commonwealth's motion. If you read that closely, they don't want people in the courtroom to be able to describe the jurors, because then people might be able to identify them. I think that's going to be a problem. I really do. I really do. That's a gag order. That's a prior restraint. And you're very, very limited in your ability to do that. It has to be really, necessary. Like the only way that you can avoid the harm you're anticipating is by imposing this order. And it also has to be, very narrowly tailored to the harm that you're trying to present. So I don't know how they're going to make that standard when the thing is that anybody can stand outside the courtroom, outside the courthouse, and watch the jurors come and go. Not necessarily the media or the people in the courtroom. Like any member of the public could do that, and you can't just bind any member of the public. They have to have notice, et cetera, et cetera. So somebody's physical appearance, again, is usually not something in which there is a privacy interest. If you go in public, people can see you. And that's kind of just how it is. You take it for granted that people can see you. But of course, they can't know your name. Of course, they can't know your address and stuff like that. That type of information isn't immediately obvious just by virtue of you existing in public. So I had concerns about that when I read it, but they didn't bring that up. We'll see if the media, if she does order that, if the media has any kind of objection to that, moves to reconsider or something like that. The impoundment of the sidebars, yeah, it is. That is a problem. That is a problem vis-a-vis the right to a public trial. It's overbroad is the issue. If your concern is, we're talking about jurors, then yes, impound those ones. If the issue is we're talking about confidential information, impound those ones. It's overbroad to just impound everything when it implicates the stuff that the public has the right to hear. And Hank's argument here that, there's political implications, that elevates the reasons for it being public. Political speech is the highest level of protected speech under the First Amendment. So I don't know why you brought that up. That's helpful. And he doesn't have authority. How do you get up there and ask to seal part of a trial and not have authority for the court to be able to do that? How do you even do that? Like, this is for a practitioner, honestly, it's like 101 stuff. Public trial is 101 kind of stuff. At least it should be. You should always be alert to that type of thing. So not having authority is a little bit past the point of being embarrassing and kind of into the realm of being just irresponsible. So a lot of those, no objection. We're going to come back to Welcher. Nobody has contact. You're going to come back to Crosby. Only after Russell testifies, because I guess he's just a rebuttal witness. He's not going to be somebody they call in their case in chief. We'll see. The stating the grounds for objections. Boy, she's defensive about that, isn't she? And a bit rude about it. Yeah, you should know. Why? Because we're supposed to mind read. We have no idea. We have no idea what some of these objections are and what your thought process is. And if you don't know what the basis is, how are you supposed to then modify your question to be able to comply? If the issue is the form of the question is bad, I can still get into the substance. I just have to ask it in a different way. If the issue is the substance itself has some problem, what's the problem? What's the problem? What a cunty answer. You should know. No, Judge. That's why objections get made and argued all the time, because people have different reads on how the rules of evidence apply in any particular situation, to the point that these even go up to courts of appeal sometimes and get litigated about whether it's correct or not. So, and why not? Why not be able to say objection, foundation, objection, hearsay? That is routine. It happens in every court across the country, far as I know. Only time I have ever seen this, you're not allowed to state the grounds for your objection. I am going to inject myself. I'm going to put myself into the shoes of an advocate and imagine what the objection is and rule on it based on how I would be advocating. Not appropriate. Not an appropriate position for a judge to be putting themselves in. What's the problem? There's no problem with that. And it's clean and it's easy and it's efficient. So why is she so against it? Does she want the outcome that Mr. Yannetti is pointing out for? We got to have all these sidebars. Makes us look like we're delaying the trial and the jury's going to get mad. She doesn't seem to care about delaying the trial. She doesn't seem to care because, yeah, it's a lot faster. Hearsay, sustained, overruled. Then you know if you want to argue with that, that's when you need to have a sidebar. But you at least know what the parameters are. I really don't know what the problem is there. But boy, was she getting nasty about that unnecessarily. They made a very good point that they need to make their record to make sure that they are preserving issues. So they got to go to sidebar if they disagree with her ruling, or to clarify exactly what her ruling is. Maybe there's multiple grounds for an objection and she sustains and you don't know which one she sustained on. Then you're going to have to go to sidebar and you're going to have to clarify that. It's just not appropriate in so many ways. Oh, the ARCA motion, the lack of bias. Mr. Brennan's argument here is really, it just comes down to, I don't know what happened, and so therefore I want to infer that it's the worst. And that's not reasonable. That's not reasonable. You need proof of bias if you're going to argue bias. And you need proof of bias with respect to this particular witness, not the DOJ in general. You do not have to open the entire door to the federal investigation and you know what happened and what they did and so on and so forth. And yeah, I don't know how you even get that in. Who are you going to call to testify that the federal investigation is closed? You can't call Rafferty. You know why? Because it's hearsay. She doesn't know. She was told. She was told. You're going to try to subpoena somebody from the Department of Justice in to testify to that? You're going to have to go through TUI. Remember, TUI applies if you're going to subpoena a government witness into court? Yeah. Good luck with that. Good luck with that. No position on the buffer zone. You know, the issue that I have with the buffer zone, I talked about this briefly. I understand it's been upheld. I understand the general concerns from the protecting the jury type of perspective. I have a hard time believing that honking horns is going to influence the jury in some way. If they hear honking horns, that is somehow intimidating or coercive. They don't know what the honking means. And as far as like disruption, how many times do we hear sirens and stuff going through? We have to stop. We have to stop. because it's noisy outside there. It's just noisy. So I don't see those as particularly justifying, the jury. There's no rule that like the jury needs absolute silence. It's about, content. It's about exposure to content, exposure to messaging. So if they can't hear messaging, or they don't understand what it is because it's communicated in the form of a honk and they don't know what the honk means, then I don't, there's no need for it. And once again, you're dealing with First Amendment grounds, you're dealing with protesting, the right of people to petition the government for redresses, make themselves heard, etc. Political stuff, the operations of the government. So people have a right to do that. And if you're going to restrict that right, it has to be narrowly tailored. It can't be broader than what's necessary to protect the right that justifies the intrusion in the first place. And so you can't just push them out of the way to give the jury total silence. That's not, that's going to be overbroad. The issue I have with it, though, is the issue of notice and enforcement. And I know a lot of people are concerned about this because, Hank chose to write this motion in a way that it's just it's inflammatory and it's kind of it's challenging. We want the police to be able to like go hands on with protesters and use force if necessary to ensure compliance. He's doing that. He's doing that on purpose. He's doing that to be inflammatory and to get people pissed off because whether police can use force or not is always going to depend on the law of the lawful use of force. And so police can use force to effectuate an arrest and to carry out their orders. Looks like we're back. But that doesn't mean they have carte blanche to be able to go hands-on with people just to try to, do something short of an arrest. I have the sound.
Before we begin, realizing how much everybody has to do before this trial, I won't have the voir dire of the ARCA witnesses next week. We'll have it before they testify. We'll do it the day before they testify. And we'll give you until then to comply with all Rule 14 discovery and see where we stand. So we don't need to bring them here next week unless you made arrangements.
No, I didn't make arrangements. I just want to make sure that we're very well defined on what issue is before the court that would justify a voir dire. I just want to make sure. I don't think that's been clearly articulated. I just need to know what the parameters are.
Okay.
We need to know. I think Mr. Alessi is going to handle the argument in substance, but I need to know what are we dealing with for a voir dire.
Okay. All right. So what I need you to do beforehand is make sure that all Rule 14 discovery is complied with. And if it is, then we'll see. Okay.
So it's basically
Yes.
defined on Rule 14.
Yes.
Got it. Thank you.
Does that work for the Commonwealth?
My concern is if we have questioning of the witnesses the day before their testimony, and part of that includes the production of records, and they don't have the records with them, they're going to be unable to produce them because they would have to return home. And so having.
So we'll need that, Mr. Alessi, okay? Well in advance.
Yeah, understood.
That would be part of the Rule 14 discovery. If they comply with Rule 14 discovery in advance, you'll have all of that.
That was exactly my understanding, what Your Honor was suggesting, and we will comply with that.
So see where we stand. If we need to address it, we'll address it before then.
My discovery motion extends beyond Rule 14, and the reason why is it includes the communications between the parties, which is necessary to understand. So it's not simply Rule 14. We have a court-ordered discovery motion that we filed that includes the request for this information to show bias, and I don't want that to be overlooked.
All right, so talk to Mr. Alessi in advance. All right, and I'd like you to be able to tell me before we start the trial where you stand with that. Okay?
Yes, Your Honor.
And what you still think you need, Mr. Brennan.
I'll inform the court.
Okay.
And I'm pleased to speak with Mr. Brennan at Your Honor's direction.
All right, thank you very much. All right, so now we'll go on to your motion, Mr. Alessi.
This is the Welcher motion. Welcher, I believe, is the accident reconstructionist.
May it please the court. In my presentation today with regard to Dr. Welcher.
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan on doing that or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
Yeah.
In my presentation today, Your Honor, I'm going to, just so Your Honor has the documents in front of you that I'm going to be referencing. I'm going to be referencing the 140 slide presentation.
Okay.
What the Commonwealth has dubbed a report, which is approximately 12 pages of a letter dated January 30, 2025 from Dr. Welcher to Mr. Brennan. And I am also going to be referencing a case law that the parties have cited. What Dr. Welcher has submitted is notable both for what is submitted and what is not provided. Dr. Welcher has gone extraordinarily well beyond not only his area of expertise, but he has, and that's in terms of what he has provided, but as remarkable is he has not provided any documentation of how his methodology is tethered to any study, any common acceptance, or any of the Daubert factors. And this, again, is a pattern of the Commonwealth where they provide, as they did with Dr. Wolf, as they have done with Dr. Crosby, they provide long CVs, long qualification lists, and then are completely silent on the tethering of the methodology to a common acceptance or the Daubert factors. So that is the jurisprudential motivation for me to hit the case law with regard to why that deficiency is fatal to their burden of proof under the Massachusetts law. So I'll start with case of Canavan, the SJC's decision of 2000. And I am going to provide 4 parts of Canavan. Number 1, it's in head note 11. And this case was about, as the court may know, the Commonwealth, not the Commonwealth, a party proposing an expert that was commenting on, which was fashionable at the time, multiple chemical sensitivity. And the expert witness trying to state that an individual suffered from multiple chemical sensitivity. Here's what the
That's a junk science I haven't heard of.
stated in response to the expert that was proffering that testimony, and it's extraordinarily close to what is happening with Dr. Welcher, what happened with Dr. Wolf and Dr. Crosby. The SJC said there was no evidence in the record to show that Dr. LaCava, that was the proffered expert, used a reliable methodology to transform his general finding of chemical exposure to his more specific diagnosis of MCS, multiple chemical sensitivity. Immediately after that, the High Court said, and I quote, Dr. LaCava referred to the, quote, literature as confirming the existence of MCS and asserted that based on the examination and tests he conducted, the employee had symptoms highly suggestive of environmental sensitivity. However, Dr. LaCava did not identify any specific studies that showed the existence of MCS based on specific symptoms and did not identify tests that can be performed to prove that the patient suffers from MCS. Skipping one sentence. Thus, the only evidence on this record tending to show that the employee suffered from MCS was Dr. LaCava's assertion. The purpose of the Lanigan test is to prevent an expert from offering testimony to a fact finder that is not based on a reasonable or reliable methodology. We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test, absent any other evidence showing its reliability.
That's a good point.
I have used the Latin phrase ipsi dixit,
Yes.
translated into because he says so, or he said. And it's not my pejorative. That's the ipsi dixit, comes right and is used in case of cannabis. And that's what the SJC calls it when you don't tether a methodology to a study or common acceptance. It's just that expert witness saying it. The reason I perseverate on this is because that's exactly what Dr. Welcher is doing in a 140 slide presentation. It's exactly what he did in his 12-page letter to Mr. Brennan. Nowhere in either of those voluminous documents does he mention one word about two things he did. He did an analysis. He has a purported methodology, just like Dr. LaCava in case of Caravan. He doesn't mention one study to support his methodology. Unless there be any concerns, the law is clear that the Lanigan analysis is applicable to medicine, science, and technology. And clearly, Dr. Welcher is in the technology area. In the Dalbert Lanigan analysis, it's referred to as the hard science. So he also, Dr. Welcher, conducted an experiment. And I'm going to treat that separately from the lack of a methodology. So I want to stay just with the methodology that is purported to be used by Dr. Welcher. So keeping on with case of Canavan, Dr. Welcher also is proffering to provide opinions on the medical causation of the injuries to the right arm of the deceased. It's clearly what he is doing. Here is what
couldn't do.
The SJC said about causation. It's head note 14, and they labeled the heading of it causation. The SJC said, quote, "There is no suggestion that the judge conducted a Lanigan analysis to determine whether Dr. LaCava used a reliable methodology to conclude that the chemical exposures to which the employee was subjected caused," and caused is italics in the opinion, "her to suffer from MCS. This was an error." They went on, quote, "Because understanding medical causation is beyond the knowledge of the ordinary layman, proof of it must rest upon expert medical testimony. Because and I'm skipping several sentences, because the judge below did not conduct Lanigan analysis to determine whether Dr. LaCava relied on a reliable methodology to determine that chemical exposures caused the employee's MCS, it was an error to admit the opinion." In the concurring opinion of Justice Greene, he added an important point. I quote, "Further and perhaps more importantly, the application of the standard will make little difference in how an appellate court decides a hard science." The issue was, what was the standard of review? Is it going to be abuse of discretion? And the concurring justice said, in hard science, it really doesn't make a difference. But here is apt for what we're here for today. The goal of Lanigan, as was the goal of the preceding tests, is to keep unreliable or so-called junk science from fact finders, thereby reducing the prospect of the return of verdicts or the rendition of decisions with dubious validity. So I rehearse apt provisions of the case of Canavan because the SJC sets forth what the burden is of the proponent. And I know Your Honor has heard me make this argument before, but I am now providing the SJC decision for direct support, what I've said with regard to the experts, Dr. Wolf, Dr. Crosby, and now Dr. Welcher. Next case I provide is Commonwealth v. Meeks, and that is another SJC decision. And if I'm not mistaken, I think all of the cases that I'm providing in my oral argument are cases cited to by the Commonwealth as part of this motion. I'm not 100% sure with regard to Meeks, but I think it's a decision that they cite as well. And oddly, all these decisions favor the defense. So here is, I'm only going to need to read one part of Meeks, even though it's a very long decision of 2006. It states at 2006 Westlaw 2819423, and this is on page 53 of the Westlaw copy. Quote, at trial, this court will require the Commonwealth's firearm identification witness to provide on direct examination, et cetera, et cetera. Last sentence, such discovery is essential to an effective cross-examination and therefore to a fair trial. And I've made this argument many times before about the prejudice to Ms. Reed from the pattern of the Commonwealth to provide experts, long reports, long CVs, completely silent on tethering the methodology to a study, etc. And the SJC points out that that information is essential to an effective cross-examination and therefore to a fair trial. And with regard to the last case that's really more apt to the experiment that Dr. Welcher apparently performed, not apparently did perform, that is the subject of his slide presentation. And this is, there's various experiments, but the most prominent of which is painting someone's arm blue, painting a hand yellow, and then trying to use the results of that experiment to support some wayward theory as to how the SUV made contact with the decedent. There's no doubt that's an experiment. So it's important when I get to that experiment, what the legal standard is before such an experiment can be admitted in evidence, and what's the test under the Commonwealth v. Davis and Lanigan as to how an experiment could possibly come into court.
This sounds like a weird experiment.
You've heard of the case, and I know Your Honor knows of Arcola. We basically cited it for the proposition of qualifications, but substantively, we haven't talked about it. And I know Your Honor is well familiar with it, so I'm just going to summarize what's apt for our motion. Okay. What the High Court said there is that the precise question is whether Giulianelli, this was the paint expert proffered by the Commonwealth, possessed sufficient education, training, experience, and familiarity to determine forensically when and how the paint was applied to the basement floor in the victim's body based on the information he was provided. And a large part of Arcola was, listen, this person was a paint engineer at his company and he had a lot of experience in that. But what he really didn't show and didn't have was experience forensically addressing the question. And that was certainly a big part of Arcola. So the court, to that point, said there is a significant distinction, however, between what Giulianelli had done in the paint industry for over 20 years and what the Commonwealth asked him to do in this case. So the court went on and discussed the difference, and it said he also, this is Giulianelli, he also did not do any research on the topic or search for any academic or industry materials on this topic. So the court, with that predicate as to what was lacking, which is completely the same as what's lacking with Dr. Welcher in his experiment, the court said this, and this is on Westlaw copy 14, head notes 19 through 22. I quote, expert testimony also may be based on or informed by the results of experimentation. Skipping. The conditions in the experiments must nonetheless be substantially similar to those at the crime scene.
That's the problem.
For the experiments to be of any value, and where new hard science is involved, an appellate court will always take a hard look at the trial judge's decision to admit or exclude the evidence.
You have to be dummy.
So here's what happened that's very apt to Dr. Welcher. Our analysis of Giulianelli's approach begins with the important principle that judges should closely scrutinize expert testimony where the testimony is prepared solely for the purpose of litigation, as opposed to testimony flowing naturally from an expert's line of scientific research or technical work.
Makes sense.
There is no evidence whatsoever in the Commonwealth's papers that Dr. Welcher had ever performed this experiment as part of his line of scientific research or technical work. From all indications, it appears that he performed this experiment specifically and exclusively for purposes of this litigation.
Well, it does sound like that.
And
I don't
that's
know.
where the SJC started. So they immediately said, if it's just experiment done for this litigation, we right off the jump have a big issue with it. The SJC then goes on with this very, very questionable area of experiments and said, rather than flowing naturally from his work, therefore, his experiments greatly differed from the work he ordinarily performed and the observations he had experienced making in the key. And his opinions were developed solely to assist the Commonwealth's prosecution of the defendant, which from all indications appears exactly the purpose of Dr. Welcher. And here now to the tethering of the methodology to a study which Dr. Welcher does not do at all. The court, footnote 31, because Giulianelli conceived of and designed the experiments without any stated basis in existing science or literature, and because neither the Commonwealth nor the trial judge applied the Dalbert-Lanigan factors, it would make little sense to attempt to apply them here. The SJC said, we're not even going to go do this analysis because the proposed expert didn't cite to it. So we're not going to guess at what happened. And it then said, relatedly, and I'm quoting, the Commonwealth has not pointed to any basis in existing scientific literature or research for Giulianelli's methodology or experience. Instead, it appears that Giulianelli designed these experiments on his own without any guidance. Reading down below, quote, Giulianelli's experiments also did not appear to have been performed consistently with basic scientific principles. We have no evidence in anything the Commonwealth submitted that the experiment of Dr. Welcher was performed in accordance with any scientific principles, because his report and the slide presentation is completely bereft of any citation to basic scientific principles. Next, the court said Giulianelli did not repeat or validate any of his 6 experiments is also significant. Mm-hmm. There is 0 in the current record that Dr. Welcher repeated or validated his experiment. Nothing. That is
we painted
the
a guy's
legal
arm and hand
standard for experiments
and put it in a position,
Massachusetts,
and back there. And
the defense creating the standard.
He did not back a car into a guy.
The defense suggesting what the standard should be. What I just read is a 2021 opinion of the SJC. With those important legal precepts stated, I now turn to the letter, what the Commonwealth provides as, or calls a report, which is the January 30, 2025 document from Dr. Welcher. And I start on page 9 of that report. And if Dr. Welcher had adhered to his own standards about what a biomechanical engineer is to do, my presentation would be much shorter. So let's see what he said the role of a biomechanical engineer is, and then what he did. Because this goes to the point of him exceeding the scope of his qualifications wildly. So on page 9, he said in the first full paragraph under numeral 11, he says, in the middle of the paragraph, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. I have not made any type of diagnosis. He then goes down below, in 2/3 of the way down, he says, injury causation analysis is a multidisciplinary endeavor that employs objective medical and biomechanical data and analysis to determine whether a MVC caused a pathological condition or symptom diagnosed clinically. He continues, the entire body region will be covered under 3 of the 4 main branches of impact biomechanics, which are injury mechanisms, mechanical response, tolerance, and the biofidelity of surrogates. Thus, injury criteria are needed by biomechanical engineers to describe the relationship between one or more physical parameters and the injury they cause. These criteria usually take the form of a simple mathematical expression or a force or acceleration level. I couldn't agree with him more that that is what biomechanical engineers do. And he then goes on the next page, first full paragraph, I understand my current assignment in this matter is to analyze the available data in this case, including but not limited to the data in and damage to the Reed 2001 Lexus LX 570, and to determine the events that applied forces to Mr. O'Keefe that resulted in the damage to his body, structural failures, fractures, injuries. I agree completely again. That's what a biomechanical engineer is supposed to do. And what is it that he's talking about with force acceleration? At the risk of getting a little too nerdy, but it's really important, what biomechanical engineers do is they apply Newton's second law of physics, which is force net equals mass times acceleration. That's the mathematical formula, because biomechanical engineers want to know what's the force being applied. And when you do that, then you can then say, okay, is this force capable of causing this result? And if that's what Dr. Welcher had done, again, my presentation would be very short. But that's the setup that he says are his guardrails, his boundaries. Now let's see what he actually did in this case, is where we have great objections. It's his conclusions and opinions, which take up about 1.75 pages only on page 10. Let's see what he did and how he honored or didn't honor his own standard. And I'm going to, hopefully to assist the court, identify what I believe should absolutely be disallowed from him opining on. Conclusion opinion number 1. I'm not going to talk about things that we aren't contesting. I want to go to the things that are clearly wayward and improper. 1C. He cites to Julie Nagel and occupants of Richard D'Antonio Ford F-150, Ryan Nagel and Heather Maxim, arrival in time outside 34 Fairview, not seeing anybody exit Lexus or damage to the Lexus. What he is doing is he is not only using, but he's trying to credit contested testimony.
So let me find out, do you intend to introduce that testimony, Mr. Brennan, through this witness?
I intend to introduce that testimony prior to Dr. Welcher testifying. If it's not in the record, he would not be able to testify to it, but if it is in the record, he can refer to it as part of his opinion.
All right.
That's a very apt question, and Mr. Brennan's answer underscores the issue. So what I understand completely the foundational evidence issue. I understand all of that, but the transcending issue is an expert witness can't use contested testimony because experts are not allowed to credit and talk about the credibility of witnesses. It's clear in every jurisdiction, including Massachusetts. And he does that throughout his report. And we've provided in our supplement correction, the clear case law. I'm not going to go through it because I know Your Honor knows this. It's almost Hornbook law. So based upon Mr. Brennan's answer, it only underscores and establishes our concern. So 1C
putting his thumb on the scale
should be excluded. Now to 2. 2A Romanets 3 and 4. Romanet 3, 2A3. No evidence light was broken at 1 Meadows Ave. When does a biomechanical engineer get to testify about a contested issue and say no evidence? That's not for a biomechanical engineer. And when he set up his own boundaries, he didn't talk that he was going to be looking at contested evidence. Romanet 4, 2A4. No fragments of taillight on or in snow behind O'Keefe Chevrolet. That's an evidence, collection of evidence, preservation of evidence, etc. It's not for a biomechanical engineer. Then he goes on to 2C. Testimony of Jen McCabe. That's his heading. Karen Reed stated to her, etc., etc. In other words, given Jennifer McCabe's testimony, and then he talks about what he believes Ms. Reed knew. That is not only trying to credit testimony, we've got now a biomechanical engineer that is going to be stating the Commonwealth's case for it. What is the biomechanical force calculation for talking about Julie Nagel, Ryan Nagel, Jen McCabe's, or frankly, anybody's testimony?
Yeah.
It's unprecedented. Now, continuing on page 11 at the top, and this is C Romanet 1-1, 42622 Julie McCabe, 42622 state grand jury page, etc., grand jury minutes. That's testimony. It's testimony of lay witnesses. Inherently, he is crediting that testimony as truthful. That's not what any expert can do, let alone a biomechanical engineer. Number 3, the location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right tail light of the Reed 2001 Lexus LX 570. So let's cut through the euphemism of orientation. What he is referring to is pattern recognition. He is saying that the pattern of the lacerations on Mr. O'Keefe's right forearm are supporting his opinion. Where is his qualifications to determine pattern recognition of a wound on a deceit? They don't exist. 4, and that should be stricken and not allowed. 4, perhaps the most egregious of all, and I respectfully submit what I've pointed out are incredibly egregious. 4, the totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting, etc., of his head on the frozen ground. So there are several maladies with that statement. First, where is his qualifications to testify as to frozen ground? He's not a pedologist. He's not a hydrogeologist. He's not a geologist. He has no basis to testify in that regard. But more importantly is his phrase, the totality of the evidence. And if Your Honor now looks at what he considers to be the totality of the evidence, it is extraordinary. He is, and I will state each one, he is becoming a medical examiner. He's becoming a lead investigator. He's becoming a cell phone data forensics expert. He is also, once again, talking about testimony of individual witnesses. So he says the totality of the evidence is consistent with the right rear corner of the Reed Lexus impacting John O'Keefe and Mr. O'Keefe, et cetera, and of his head on the frozen ground. So what he's doing is he's now talking about cause of death and manner of death.
Do you intend to introduce that evidence, Mr. Brennan?
Of course he does.
I wouldn't be introducing evidence of frozen ground through Dr. Welch.
No, but you're trying to introduce his opinion.
Cause of death.
He would not be offering a cause of death. I think the spirit of the report is putting all the information together to seize observations, but I recognize that he's limited to his field. The hard ground and the cause of death are not within his bailiwick.
All right, thank you.
Again, appreciate that apt question, and I'm going to go into why there's still an issue. So I think it's best just to go through each one. Thank you. So 4A, he says and this is what he means by totality of the evidence. Cell phone data. Where's his qualifications to discuss cell phone data? That's a data forensics. We had obviously many moments I'm sure your Honor may wish to not remember, but with regard to Mr. Green, et cetera, we went through a lot of issues about the expertise needed, the methodologies, the various tools. Where is his qualifications to talk about cell phone data? There are none. It's improper. So A in its entirety should be stricken. C, forearm lacerations 3 above. So that goes back to the euphemism orientation where he wants to talk about pattern recognition. And it's interesting that the Commonwealth vigorously contested Dr. Russell, and we all know her credentials on pattern recognition, but yet they're proffering a biomechanical engineer to talk about pattern recognition. D, air temperature and frozen ground. I'm understanding, if I understand correctly, that the Commonwealth is now stipulating to excluding that. And it's really the frozen ground aspect of it, of D. Then E, I'm sorry, Mr. Brennan.
I don't mean to interrupt. The frozen ground, we're not going to bring in. The air temperature is important because it talks about the density of the strength of the taillight. And that's part of the conclusion. So there'll be evidence before he testifies about the weather we expect. Okay. And he can rely on that to talk about how that might affect the taillight. But frozen ground, we agree, that would not come in through Dr. Welch.
We have no objection to the air temperature testimony of Dr. Welcher.
Okay.
E, hat line and fracture location consistent with fall and posterior head strike. Extraordinary. Even the medical examiner in this case wouldn't venture onto that. But that is clearly an example of what I'm talking about in terms of Dr. Welcher going well beyond his field. He's talking about hat line and fracture location. That's a wound to the back of the head. And to make matters worse, he makes clear fall versus assault. He's making a distinction between a fall and an assault occurring. We've contested Dr. Wolf on that issue. Now with regard to F, this is the wayward, undocumented experiment that Dr. Welcher conducted. F, Romanet 2 should be excluded It says drop test conducted by me with a hybrid 3 falling backwards,
Drop
measured
test?
heads, G's of approximately, et cetera, et cetera. That experiment I've covered in what the case law requires for him to show. There is zero support for this experiment. I went through in Rentola, I won't repeat it, of all that needs to be established before an expert can talk about an experiment.
What did he
Dr.
drop?
Welcher supports his experience with zero. This experiment that he did, this drop test, has zero documentation of where the methodology for that is supported by science. Recall in Rentola, the paint person conducted an experiment and the SJC said, yeah, you conducted it. Yeah, you know, this is your area, but you've got to show all of these things, including where is this supported by the scientific method? What studies? Did you repeat this experiment to make sure that there wasn't an error rate of
Is it
concern?
even replicable?
Every single deficiency in Rentola is extant with Dr. Welcher. His experiment must be excluded if Rentola is to have any meaning in Massachusetts jurisprudence. G, Julie, Nagel, and Ford occupants. Again, what does he say? Pulled in behind Lexus and never saw anybody enter or exit Lexus or walk into 34 Fairview. He's crediting, again, testimony and contested issues with regard to some important issues in the case. Unprecedented, the biomechanical engineer gets to come anywhere near that. And we provided, again, the clear case law where in Massachusetts, that's not allowed. And as egregiously, H, people inside of 34 Fairview on evening of 128, early morning of 129. H, Romanet I. John O'Keefe never entered 34 Fairview. Is there any more of a contested issue than that? But yet he's proposing to testify and state that. What biomechanical engineering principle is being applied there? The answer is none. Except for Karen Reed, everyone at 30 and outside 34 that indicated John O did not enter 34 Fairview. Even more egregious than H Romanet I. So with regard to Dr. Welcher, I have, again, genuinely tried to assist the court with regard to blue penciling his report to make clear, based upon the case law, what is within his bounds and what is not within his bounds based upon his own stated parameters. And with regard to the case law about commenting, not being able to comment on a witness, crediting their testimony, Commonwealth v. Quinn, which we cite, says such testimony impermissibly intrudes on the jury's province to assess the credibility of the witnesses. So not only is Dr. Welcher beyond his qualifications, but he's intruding on the province of the jury. And the Massachusetts courts state such testimony, the kind where an expert witness assesses the credibility of another witness, could substantially influence the jury's decision about whom to believe. And lastly, and importantly, should the Commonwealth try to save this wayward part of the report by saying, well, you know, is he really directly or explicitly doing it? The Commonwealth v. Lopez case, and I quote, vouching for the credibility of a witness, here's the key part, whether explicitly or implicitly is impermissible. So I believe it's explicit for the reasons I've given, but even if the court were to conclude that some of his references to witnesses is not explicit what he's doing, it certainly at a minimum is implicit. So with regard to the experiment, The case law is clear, as I have recited. With regard to this experiment prepared solely for the purpose of litigation, not repeated, not retested, no documentation in the scientific engineering literature for the methodology or the experiment, dooms Dr. Welcher's experiment. And the bases in the jurisprudence of Massachusetts couldn't be clearer. Experiments come to courts with an extremely jaded eye, as Rentola talks about. Both eyes get even more jaded when it's created purposely for the litigation. And what is clear from the case law is the prejudice to the defendant in these cases by allowing experts such as Dr. Welcher to stray into all of these areas. In conclusion, Dr. Welcher is not qualified to do anything more than what the ARCA witnesses did, which is talk about and calculate forces and then determine whether or not those forces are sufficient and based on physics are sufficient. So, Your Honor, we would request that because all of these deficiencies so infect all of his report, meaning the experiment is the entire basis for his opinions. You pull out the experiment, he has no basis for an opinion. You pull out a lot of his items, there is no basis for his testimony, and it frankly shouldn't be the job of the defendant or the court to fly spec his report in his slide presentation. And that is the final data point I want to hit, which is his slide presentation. We have a 140-page slide presentation that is unintelligible on its own. You can't understand it, and the report merely references it. It doesn't explain it.
Let me stop. Mr. Brennan, do you intend to use this PowerPoint presentation?
Parts of it. It certainly needs redactions. Any reference to witness testimony needs to be redacted. Opinions on credibility needs to be redacted, but there are different demonstrations that we do expect. The demonstration at Meadows Road, which clearly depicts that the cars didn't contact the taillight, we want to produce. The drop test, similar to Arca's test.
Get by your mic.
You offer that. But as far as the extraneous commentary, no, that's not intended to be, it's not proper, and we wouldn't even try to use it.
Do you intend to use all 140 or however many?
No, that is, we were comprehensive in the production to the defense so they could see the data points, how it was produced.
Data points.
And so we've included, you see many of the slides is the cameras showing the different data downloads. There's only a fraction of that we would show. What we would show is the drop test, the demonstration of the Lexus hitting Mr. Welcher's arm. And also we would want to show the ways, locations based on the data that will be introduced through other witnesses and after it's been attested to and its reliability.
Okay.
If I may be heard on that?
Sure.
Thank you. I still don't know the answer to your question. The defense is entitled to know.
Right. So this will have to be provided to you prior to its done.
Thank you. And do we have a date so we can adequately prepare for trial, Your Honor, in cross-examination?
When will you have the redacted slides?
I could have them by Monday.
Okay.
And Your Honor, if we have an issue still, can we submit something to the court? Don't need another court hearing, but if Your Honor would like it, we're happy to do it just to get the basis.
Sure. So you'll get what you're entitled to, and which is just a narrowing down of what you already have. And then if you need to respond, you can respond and we'll take it from there.
Thank you.
Okay.
So in conclusion, Your Honor, the proffered information from Dr. Welcher is, in my experience, unprecedented. It is all-encompassing. It veers extraordinarily beyond his own stated boundaries. And even if he didn't state his boundaries, it's clear he's trying to perform roles, even with regard to what the Commonwealth has just said they're stipulating not to produce, still getting in extraordinarily to other disciplines for which there's no documentation. My last point is the point made by the Supreme Judicial Court. These experiments, especially of the insufficiency of Dr. Welcher, cannot be admitted into courts and go before juries for the reasons of the improper influence on the jury. And secondly, the methodology has to be tethered to a study or something in the literature to give the court, as the gatekeeper, a basis to say, this is science. This was done pursuant to the scientific method. And Dr. Crosby, Dr. Wolf, and now Dr. Welcher are completely absent with regard to that tethering. And as the SJC says, that deprives the defendant of cross-examination and a fair trial. And I don't know why the Commonwealth, I've been saying this for months, literally, as to why the Commonwealth doesn't produce it, either in reports or in their responses to our motion. I am left with one conclusion, Your Honor, and that is they don't want to provide it, and they want to, as the Commonwealth's favorite phrase appears to be, do trial by ambush. But that can't work with a defendant in a criminal proceeding. The Commonwealth can't ambush, and that's not my standard. That's the standard of the SJC. So we respectfully request that Dr. Welcher's report and his testimony be disallowed in its entirety. We will, of course, await the narrowing as Your Honor has ordered, and we would urge at a minimum that the defense know clearly what this witness is going to be allowed to testify to, and we would like to avoid an evidentiary hearing because I think it's pretty clear what the parameters are, but I have to reserve, Your Honor, our request in the alternative for an evidentiary hearing if what we get from the Commonwealth continues to be the vagueness that we've been getting all along. Thank you, Your Honor.
Okay. Mr. Brennan.
Oh, wait. I'm particularly disappointed that Mr. Alessi sees this as some type of trial by ambush.
Clutch your pearls.
I'm not going to digress the way he has, but the case study in that is the Arcola, and that's why I'm concerned about waiting until the day before trial to get simple Rule 14 discovery. Arcola and Mr. Welcher have some similarities because they're biomechanical engineers. Now, in our production, we gave over 8 gigabytes of information from Dr. Welcher. We gave any reference material, whether he was going to use it or not. We gave all studies, all data, anything that he considered, even if it was irrelevant.
So you did a discovery dump.
It was an extraordinary production. I've never seen a more complete production. But Dr. Welcher gave his entire file to the defense with all of the raw material, all of the studies, all of the reference material. It's not limited to this report. As you can see, Dr. Welcher is extraordinarily thorough. You can see in the letter report all of the different things that he looked at, far beyond what any other expert has looked at in this case, far beyond, I dare say, what Arcola even considered in this case.
Maybe because he's not supposed to look at that stuff.
But maybe not for the defense, so I will narrow it. That Mr. Welcher, Dr. Welcher, cannot come in and talk about the opinions or testimony of witnesses as it relates to their statements. So, for example, as Attorney Alessi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll testify to that herself, that there was no damage. In fact, all the witnesses did not see damage to that taillight. As to 2C, the testimony of Jen McCabe, that is for reference. Testimony of Jen McCabe is for Jen McCabe and the jury. He will not be offering testimony of Jen McCabe or anything that relates to it. Similarly, 2.1 regarding Julie McCabe and grand jury minutes, he won't reference grand jury minutes in the abstract, let alone the details of it. Number 4, he will talk about the weather if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground. Similarly, in 4G and H, this is reference material regarding Julie Nagel and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses, not for Mr. Welcher. And so the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, they weren't tethered to a specific study, and the methodology for each one is not outlined in a report. I wasn't sure if he was talking about Dr. Welcher or he was talking about the Arcola experts, because when I'm looking at the Arcola report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the Arcola report, you have one witness who decided to build a potato cannon for no reason that we know of. No evidence that anybody threw a glass, but apparently it was a cool idea, he cited on the stand. That wasn't tethered to a specific study. That didn't lay out the methodology of the potato cannon. That wasn't repeated or validated. There was no specific literature that was referred to in that report. And yet, not only were they allowed to offer this evidence, it wasn't inappropriate.
Well, you didn't object to it.
Now, it would be nice to know a little bit about the potato cannon, maybe a picture or a video or some specs on it, or maybe some details on how it actually operated. See, these are the things that Dr. Welcher provides to the defense. He doesn't just provide the information, the raw data, and the studies. He actually shows the demonstrations. He doesn't hide from his basis of his opinions and conclusions. He shows and demonstrates them with videos and pictures and photographs.
You had a whole voir dire of
Quite
it where
unlike
you could have
Arcola, where it
that.
is simply a conclusion based on just trust me. And so when you look at the production by Dr. Welcher, it is not comparable to the standard that the defense accepts for their experts. He is a biomechanical engineer. That is a combination and study of engineering and physics and science. And it also details medicine. He's not a medical doctor. He's not diagnosing an injury, but it includes all of those arts. Now, this is the same thing that Arcola says in their report. If you look at their report, they talk about the study. And they outline what they believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Alisi is Mr. Welcher's drop test. If you look at the Arcola report on page 10, they do the very same thing, except that they don't show it. They don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart. So different. And so there are no medical diagnoses by Dr. Welcher. These are his opinions based on a study of the evidence, and he goes to the extent of actually demonstrating those different assessments that he has made. In particular, the defense takes issue with basically everything he's done. And just as a general perspective, they would like the Arcola witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say. Dr. Welcher's opinion is different. It's the same engineering, it's the same science, it's the same concept. It's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Lisi is insisting on are excused, but if they don't like the opinion, somehow should be excluded. They're really polar opposites.
Well, it kind of depends on how he gets to that conclusion, doesn't it,
They
Mr.
both have a
Brennan?
different opinion about the taillight causing the injury to Mr. O'Keefe's arm. One the defense likes,
Why
one
does
they
he
don't.
have a different
It is the
opinion?
same science, same
Because he
study,
is
same
pulling it out of
analysis.
his butthole, or because he has properly
And so if it's
applied the
acceptable
science?
for ARCA, it must be acceptable for Dr. Welcher. Dr. Welcher actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The text stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it didn't stop along the way. We know, based on the phone data, Mr. O'Keefe's phone data, when he was in the car until. We
No,
have
you
all
don't.
that evidence,
Very
and as a
contested.
bioengineer, he can consider all of that technical data, which will be introduced through other witnesses at trial before he testifies. And it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30. And within 2 minutes, we allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature. It all coincides. He should be able to consider these things in his study. This is what he does. The demonstration at Meadowbrook, John O'Keefe's house, is depicted by measurements which has been provided, science and data, by the ring videos, which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence.
Because before it was
You can see in the
insisted there was no
presentation, he
contact.
actually shows not only the nudging and the car leaving through the ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses.
Mr. Brennan wishes he could get a gentle nudging.
The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right taillight. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken taillight, and it shows
What about his valid
with great
method?
continuity the height, location of that broken taillight,
That's what we
and how
call
it relates
mysterious
to a bent
correlation, Mr. Brennan.
and that is based on
That's why you need science.
engineering, biomechanics, the same things that ARCA employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that.
That has
And
nothing
then,
to
as
do
I
with
mentioned,
first
finally, the
generation.
drop test. This is the same information that ARCA proposes in their report. For some reason, I don't think that was offered at evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements. And we expect to present the demonstrations to support the opinions as corroborative evidence of those opinions rather than just naked opinions.
So no response to the
there
case
will be no
law
trial by
then.
ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the Arcola information. It does concern me delaying that information because, as Attorney Alisi eloquently said, you need time to prepare. We know he's a very prepared attorney. We'd like to prepare as well. And if we wait to get records and information and know who wrote what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called. We'll have to add him to the witness list if he has any relevance. We won't know until we question those witnesses. So I think I'm also inclined to ask the court to consider we have that questioning well before their testimony. But we will meet our commitment and provide those slides on Monday.
All right. And Mr. Alessi, again, you've already said you agree to talk to Mr. Brennan about the reciprocal discovery. Okay.
May I be heard?
Sure.
Thank you.
So no addressing the law. That's
Like with
standard.
Dr. Welcher's report, what Attorney Brennan did not say is even more important than what he did say moments ago. He didn't state or even address where is the methodology employed by Dr. Welcher tethered to a study, the scientific literature. He kept using the phrase, it's science and data, quote. Someone alleging that it's science and data doesn't even begin to approach that the methodology is established in the literature or satisfies the Dalbert-Lanigan factors. So, Your Honor, on the record before you, there's no better evidence that that tethering doesn't exist than the absence now for the fourth time upon challenge of that in Attorney Brennan's comments. That dooms Dr. Welcher. Now I want to address the false equivalency argument of Attorney Brennan.
Thank you.
Attorney Brennan said falsely just now that the Arcola report does not set forth the methodology. There are 14 footnotes in the Arcola report. I just looked at them again. Footnotes 1, 2, and 3 tether the methodology of the Arcola experts to the literature. The methodology is documented. I do not understand how an attorney can get up and say
He's mad.
a report doesn't have something without having a basis for saying it.
Yeah.
On a key issue that is disputed. Attorney Brennan also falsely stated that Arcola did exactly what Dr. Welcher did with regard to medicine and medical issues. That is completely false. Arcola, as is clear as day from the report, and I'll repeat it, did a force net equals mass time acceleration calculation and said the forces that come from 15 miles an hour, 24 miles an hour, and then so the unknown is the force, the F in the calculation. What is known, the M and the A. The M is the mass of the head and the mass of the arm. The mass of the head is 11 pounds. The mass of the arm is 11 pounds. You then take the acceleration theory, even assuming the theory of the Commonwealth, which we can test, which is it's 15 miles per hour or 24 miles per hour. You multiply the mass times the acceleration and you get a force. And then they said this force is expected to cause or not cause these types of injuries. That is a proper biomechanical engineering analysis. The Arcola experts didn't get into pattern recognition with regard to the wounds, the orientation, etc. But most importantly, there is no equivalency between what Arcola did and what Dr. Welcher did. With regard to Mr. Brennan stating, quote, this is what he does. referring to Dr. Welcher. The question is not, is this what he does? The question is what he does rooted in science. And what it means is not just any science, it has to be a commonly accepted, his methodology commonly accepted or satisfying the Daubert factors. And Mr. Brennan did not contest one aspect. He didn't say, Your Honor, here is where what Dr. Welcher did can be found. It's commonly accepted, either in court opinions, which the court could take judicial notice of, or in peer-reviewed literature, because it's not there. And with regard to the 5 non-exclusive Daubert factors, I covered that in my presentation in the beginning. I'm not going to repeat it, only to say that Mr. Brennan didn't address any of those 5 factors to show a proper foundation for that. With regard to what Mr. Brennan called arm experiment, relating to a bent arm, relating to injuries, I understand what Dr. Welcher did. The question's not what did he do, but is it accepted in the medical literature? So with regard to the arm experiment that Mr. Brennan just went through, he talked about it, but he didn't mention once where that's rooted in the literature. He finally concluded by saying, this is within the bailiwick of Dr. Welcher. I don't know what this is, but bailiwick is a tautology. It doesn't say anything about whether what he did is rooted in the literature or that it satisfies the Daubert factors. So in conclusion, Your Honor, I go back to Rentola, I go back to Meeks, I go back to Case of Caravan. The Commonwealth has not today, not before, this is their 4th time, has not satisfied what the Supreme Judicial Court requires in these instances. And what it has come down to is the defendants, which stands in a different position. This equivalency between ARCA, I've shown, and it's easily documented, the court can see it, that contrary to Attorney Brennan's false statements, ARCA did cite to and tether their methodology to the literature.
Or a really good band name.
When you have a defendant on trial for the seriousness of the charges here, to have no methodology, to have no tethering to the literature, that's, as Your Honor knows, the gatekeeper's function to stop those opinions from going to the jury, to ensure not what the defense has created, but what the Supreme Judicial Court has created, which is the purpose is to allow for cross-examination and a fair trial. They haven't satisfied their burden. They have the preponderance of the evidence burden, and the consequences should be borne by the Commonwealth, not the defendant.
Okay. Go ahead, I'll hear a quick response.
Regrettably, I know Attorney Alisi has decided to join the fray of disparagement. Now, he has said 3 times
you're one to
that
talk.
I've made false statements. This isn't the first time that Mr. Alesi has tried to portray the Commonwealth as being disingenuous, because they know full well this is being covered by the media, and they want to create a sense to dehumanize anything that they don't like, whether it's the government, the prosecution, the witnesses, or the evidence. There's no place for it. 3 times. This follows when he made representations, reckless representations in court, that Brennan lied 10 times. We found some of those transcripts, and I took enough dignity not to mention it because I didn't think I needed to, that the transcripts were not even accurate. Mr. Alisi was actually wrong when he was claiming I was lying about reading reports. Now, I don't want to stand up here and have a dispute, but when you use words like false statements as an officer of the court, they better be supported. That is a strong statement to repeatedly make, and it's a tactical one. It's purposeful. Attorney Alisi is joining the fray, and that is all part of the strategy here. Now, if you look at page 13 and 14 of Dr. Welch's report, perhaps that was missed in the review. There are resources in that report that number 26 different items of resources. And so if we're talking about support and tethering, it is at the end of the report. It's not footnoted like ARCA, it's at the end of the report. It's all there.
All right.
We're to just take your word for that.
So we're going to move on to try and get some motions in quickly. The motion regarding the chalks, is there an objection to the Commonwealth's motion requesting the use of chalks and directing both parties to provide visual presentations in chalks prior to using?
No objection.
Okay, thank you. 583. Is there an objection to the Commonwealth's motion in limine to allow the expert celebrate demonstration? We had it before. Is there an objection to that from the defense?
Yes, Your Honor.
Okay. Is this something that can be done quickly, or is this something you need more time on?
15 to 20 minutes, Your Honor.
All right, so we're going to have to table this. We may end up coming back tomorrow.
I can do it unless, you tell me what
No,
Your Honor's
let's
expectation
see what we can get before the luncheon break. The paper number 585, it's the Commonwealth's number 11. Motion eliminate to admit the victim's out-of-court statements relating to John O'Keefe's state of mind, the quals, bins, types of cases. So is there an objection from the defense on that? If there is, I'll hear quickly from the Commonwealth on its motion.
There is, Your Honor.
Okay, so I'll hear you on this, Mr. Brennan.
Evidence of Mr. O'Keefe's state of mind is particularly relevant in this case. In addition to the charges, this has a domestic aspect to the case. We know from his statements that he was in a relationship with the defendant. We know from the statements that there was a tumult in that relationship, and many of those statements are reduced to writing. The state of mind of Mr. O'Keefe is reflected in those statements. There was no time or reason to fabricate. You can tell by the content and the volume of them that there is a legitimacy to them. And it is clear based on that and other testimony that he was in the course of attempting to end the relationship with Miss Reed. And so his statements, especially over the course of the day of this incident.
All right, so what's the time frame? It's so over the course of the day.
Exactly.
I realize that the Aruba incident is too remote and you're not using that, but what's your time frame for me to be able to evaluate
As
this?
far as his messages, I will
Or the
look.
statements or the evidence that you're trying to put in under this doctrine?
His niece would testify, as she did in the last trial, about the tumult in the relationship.
Okay.
And we'd introduce the same text messages that we introduced at the last trial, reflecting Mr. O'Keefe's state of mind about the relationship.
Okay.
And there would be nothing different from the last trial, other than the fact that
This is
we
the
are
new
not
trial.
going to
Well,
pursue
yeah,
the
for the
information.
question
So it
about
has
the
actually a
timing.
narrower time window than before.
Okay. All right, I'll hear you, Mr. Jackson.
Thank you, Your Honor. I may be a little more brief given that explanation by Mr. Brennan than I intended or anticipated. I will say that where the Commonwealth's motion fails is in its explanation as to the relevancy and how it comes in under a state of mind theory. These are obviously hearsay statements. In some cases, they are multiple hearsay
The
statements.
state of mind is not
or potentially multiple
self-relevant. It's
hearsay
only
statements.
relevant to the extent
John O'Keefe's state of
shows
mind
motive on her
is
part.
irrelevant unless there is a specific admissible evidence that he communicated those statements, and we'll have to sort of take them as they come, given I don't have the full breadth or an understanding of the full breadth of the information that is being sought. Mr. Brennan just indicated it's going to be consistent with the last trial, so that gives me some target range. Without knowing more, under a normal hearsay or even state of mind analysis, it's irrelevant unless there's a specific admissible point that he communicated that, or point at which he communicated that state of mind to Miss Reed. She was aware of his state of mind, and very importantly, that the information that was communicated to her was of such a nature that she would have acted on it in a manner that's consistent
That's
with.
what we were talking about, the bins, calls, those points. that
Correct.
need to be made.
And that's what I'm getting to. With that last point, and to drive this point home, that's preposterous. The idea, there is no evidence to support that last point, that this type of information, let's say, for instance, it's information that he wanted to break up with her, or he was mad at her, or he was angry at her about something, some incident, some specific thing having to do with feeding the kids donuts or not feeding the kids donuts, or they had a what was considered and what was testified to in the first trial as a very normal row or argument about something as insignificant as that. The fact is, the state of the evidence is that on the night in question, it's uncontroverted by even the Commonwealth that the two of them were getting along extraordinarily well. The facts are borne out in both videos that are uncontested. They're borne out in witness statement that went uncontested, that they were affectionate, they were happy together. They were described by basically everyone on the Albert side, the McCabe side, as well as individuals who also saw, that were not related to those families, who also saw Karen and John interacting throughout the evening. And they all said that they were getting along very, very well. One person described them, the court may remember this phrase, as lovey-dovey. I think that it's pretty clear that through this testimony, or through this rubric of bringing in John O'Keefe's state of mind, the Commonwealth really wants an opportunity to call one or more or several witnesses who will basically say he wanted to break up with her, she was not a good girlfriend, he didn't like her. That is an assassination of her character. You can couch it in whatever terms he wants, but that's really what it is. These witnesses will have no corroboration, we expect. I'm leaving the text messages aside. If there are text messages between John O'Keefe and Karen Reed, that may be a different analysis, but certainly where it comes down to the witnesses, like the niece, they'll have no corroboration or no documents, no writings, no recordings, no videos, no audios, nothing but their word. And to allow a witness to walk in and to say negative things about Miss Reed with no way of verifying those statements is highly prejudicial. It's not just prejudicial, it's far more prejudicial than it would ever be probative in a circumstance. Even if the evidence was that he had discussed breaking up with other people, there are two major impediments to the Commonwealth's request. First, there is no evidence that, for instance, from the niece, I don't believe that there will be evidence that was imparted, or those specific conversations were imparted to Miss Reed. The state of the facts very clearly show the opposite. If we look at the circumstantial evidence, the videos of Miss Reed at both C.F. McCarthy that night, as well as at the waterfall that night, show the two of them getting along completely inconsistent.
The text
with two people who were talking about breaking up. John O'Keefe wanting to dump her, and her knowing that she was going to be dumped, which is what the Commonwealth is generally suggesting. And second, there's absolutely no evidence that even if she thought that John O'Keefe, if she was aware that John O'Keefe was unhappy in the relationship, that he might want to break up or in the relationship, that would have been a catalyst for murder. And that's where the rubber meets the road in this analysis. That's what the Commonwealth has an obligation to prove before this evidence is admissible. And that's a ridiculous stretch. They'd been together for about 2 years, notwithstanding the prior relationship many years earlier. She had her own career. Karen Reed had her own money. She had her own life. She had her own job, had her own house. She was not dependent upon John for anything, not for money, not for room and board, nothing. They were, at the end of the day, just dating. The fact that she had some text messages with other individuals, or an other individual, Higgins, is actually evidence that she knew she had options, and John O'Keefe likely knew he had options as well. Both of these individuals were not tethered to each other in a way that if one wanted to break up with the other one was going to murder the other one. And that's what the Commonwealth would have to prove to make this admissible. There's no suggestion in the facts that Karen Reed would kill John O'Keefe rather than simply break up with him or allow him to break up with her, and they both go on their own way. It's absurd. And there's no evidence that she was angry with him that night before she got out of her SUV. All of the evidence that we have, all of the uncontroverted evidence that we have, establishes exactly the opposite. They were a loving couple out one evening, having drinks with friends, in a good mood, and happy with one another. We cite a case called McGraw, M-A-G-R-A-W. And just for the record, I'll state the site. I think it's at 426 Mass 589. And the McGraw court provided a very defined quote that I think is illustrative for our purposes, Your Honor. Quote, "A murder victim's state of mind may be material to the defendant's motive, but only if the defendant knew of the victim's state of mind, and most importantly," the court's words, not mine, "and most importantly, would be likely to respond to it." The best evidence that this second prong cannot be met is the fact that the Commonwealth will attempt to bring in these prior statements of John, which, if believed, Miss Reed never acted on. In other words, they're going to bring in prior statements to say she would necessarily act on it, and act on it in a violent way that would take someone's life. But at the same time, they're stuck with the very clear fact that if in fact that's true, and it was imparted to her that he was unhappy in the relationship, she never acted on it, not once. And the moment that we do have frozen in time that we can go look back on is the night of January 29th, or the evening of January 28th, going into the early morning hours of January 29th, in which they were both getting along perfectly well, completely in opposite of what the court in McGraw defines as necessary for that sort of evidence to be admissible. The reason that the Commonwealth's theory for admission doesn't make sense is because it's not really their theory for admission, I suspect. I suspect that it's more that they would like to have someone or some people get on the witness stand and assail Miss Reed's character, make her look bad, and say that she was either a bad girlfriend or that John was not happy with her. It's an attempt to inflame the jury,
glorified babysitter,
to make them dislike her for something that has nothing to do with the evidence that she hit him with her SUV,
or unpaid babysitter.
On the night in question. Exactly. It's a very transparent attempt.
That Carrie Roberts.
We strongly believe that this attempt does not meet the evidentiary standards that are required. The Commonwealth cannot meet those standards, and pursuant to McGraw and its progeny, we would ask that this evidence be deemed inadmissible.
Okay. Quick follow-up.
Of course, there will be follow-up.
It seems the thrust of the defense argument, and I appreciate their advocacy and argument, but it's not shared by the Commonwealth, is that they were lovey-dovey and got along well that night.
Thank you, Marissa.
Well, at the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On 2020, transcript page 43, line 1, she was asked, "Would you say that you were angry with John that night?" Her answer was yes. She was asked by Ms. Voss on June 20th, 2023 about that night or the day before. And she says, "I was temporarily frustrated. It wasn't an argument." She also says to Ms. Voss, "Were you worried at him or pissed at him or both?" "I was pissed until I fell asleep."
Well, that's after.
Now, in addition to her anger,
and
she specifies some of the tension. We heard from the testimony of Jen McCabe that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a prior relationship with. That this is minutes before we allege the collision happened. And so in the interviews that she has provided to these different outlets, she discusses the fact that she hears this information and that there was an issue or some type of interaction about the fact that he was previously dated another woman. And this is a conversation that takes place minutes before the collision. And so we have
What does that have to
statements
do
from
with
the defendant
wanting
herself
to
that
leave her?
show the discord in the relationship, the anger, being pissed, the motive, without reading them because it's unnecessary. There is substantial corroborative evidence. Not only that the text messages, which are corroborated by the niece's testimony, but the imminency of it, that this is happening in real time, moments before John O'Keefe's death. And so all of this should be admissible. It's all supportive of each other.
Well, so now are we limited
If anything
to?
Mr. Brennan just said was true, we
Moment.
might have an argument. My goodness. It's important to get some of the facts right. You got to get some of them right. The conversation that he just referenced with Jen McCabe was the next day. It was the next morning, not minutes before the collision. He's read the every time he stands up, he says, "I've read the I wasn't there. I read the transcript." We got to hold him to that burden, Your Honor. You got to get the facts right. That conversation with Jen McCabe was the next morning after John O'Keefe had been found, after he didn't come home.
I'm sorry. I just need to correct.
I'm sorry. I was talking to my client real quick. I'm not quite done. This was during the time after 5:07, after the SUV leaves, we see One Meadows and Jen McCabe and Kerry Roberts get together. And as they're looking for them, as they're looking for him and searching for him, that's the point at which they have the conversation about being some other woman, or why he might not have come home, or what her mindset might have been at the time. It's after the fact, well after the fact. The other issues concerning Karen Reed's statements about being upset, or in Gretchen Voss's words, were you pissed at him? It was in context of when. When were you upset with him? When he didn't come back out, when he didn't come back to the car. After she left, she was angry. That's where all the voicemails take place. That's what she was talking about, having been angry. There is no evidence, none whatsoever, no evidence in the record. I want to make this as crystal clear as I can. No controverted evidence, no suspect, no evidence at all that John O'Keefe and Karen Reed had a single crossword that night before he ended up missing and she went home. Before he ended up walking out of the car, going toward the house, and she ended up leaving when he didn't come back out. Zero. The only evidence that was propounded throughout that entire day was hours and hours earlier that morning, dealing with, did you feed the kids donuts? And yeah, I did. You know, I don't like it when you feed the kids donuts. She was spoiling the kids. It was not enough to enrage anybody. It's ridiculous. And the evidence that it didn't enrage anybody is the fact that they ended up later that night together in a lovey-dovey environment.
Look at the conversation
getting
itself.
along fine,
The whole
getting
thing.
along wonderfully. That's why the Commonwealth cannot make their burden to establish that this was the type of information that she would have, by necessity, acted on, and not just acted on in any way, acted on in a way that's consistent with their theory that she would have received the information and murdered him for it. That's the hurdle over which the Commonwealth cannot leap for the admissibility of this type of evidence. It's far, far more prejudicial than it is probative.
Okay. He said he's still going to come fix her bathroom. He's getting pissed with her about hiring a plumber because whether
Before
or not
accusing
stay
somebody
over,
of getting it
etc.
wrong, the person accusing should be right. I know that Mr. Jackson, Attorney Jackson, was present during the Voss interviews, but apparently they haven't listened to the interviews or read the transcripts. Page 88, line 22. Not the next morning. When Jen was navigating John to the Alberts, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating. Similarly, page 92, line 1, totally contrary to what you just heard. Totally. There was a woman who was a mother to kids that were close to John's kids who lived very close to the Alberts. In fact, when Jen was navigating John to the Alberts, when I was driving, she said it near Ashley's house. Ashley and John had hooked up prior to John and I dating. She broke up briefly with her husband.
Yeah, Jen
Not
said
my
that.
words.
Jen said that.
So we're going break. We've got a lot of ground to still cover. I suggest that we take the personal attacks completely out of this. Hold on. Both sides. I want to get through these motions today. If we don't, I'll bring you back tomorrow. I'll bring you back Monday. Let's get through these motions. Leave all the attacks, all the falsehoods, all of that. Leave it all aside. Let's focus on the motions and get through this. So I'll see everybody at 2.
Your Honor, if I could say one more thing. As the court ponders this last issue.
I'm not even thinking about it for the next hour. Let's leave it.
Not today, Mr. Jackson. Let's just leave it. Ugh. All right. Well, it's time for our little fan break and lunch. Of course, if you were here for the last trial, you know the routine. At some point, I'm going to have to get up here and leave you guys for a minute so I can go check in on all the animals and the trees and everything. I just got to show off. I've switched over to my tea now. I have this awesome new mug that I got from one of the folks at the boxing gym. I just love it so much. And it's kept my tea super warm. So, oh man, like where even are we? Let's recap real quick. Here's the issue. Here's the problem that I see. I mean, beyond just the methodology stuff, the tethering and everything that Mr. Alessi is bringing up, showing that what you're doing is actually science and within the scope of what this type of expert should be doing. I just want to focus on him challenging some of the opinions about like, he never got out of the car, et cetera, et cetera. And the argument that this constitutes an opinion on the credibility of the witnesses. Yeah, that's a huge problem. That's a huge problem. You don't get to go in and testify that certain things are true because you don't know. This reminded me so much. You know what this reminded me of? This reminded me of Dr. Hughes back there in Johnny Depp and Amber Heard. Remember Dr. Hughes? She was Amber Heard's DV specialist. Amber Heard had given her, the selective information and communications and so forth. And so she was making all of these, conclusions about what, because this happened and because that happened, and so on and so forth. And yeah, that should have been an objection at the time when Dr. Hughes was doing that as well. You don't get to comment on the credibility of the information. That's not your job to decide whether these things happened. That is literally for the jury to decide. That objection didn't come up. Instead, they really focused on trying to confront her with basically the limitations of what she was provided. They had that moment. It wasn't until after she was called back in rebuttal, but they had a moment where they got to play some of the audio recording that, of Amber Heard berating Johnny Depp. Ask her if she had heard that before, if that had factored into her consideration. No, she coincided. She had never heard any of that. That wasn't part of what was provided to her. So, all of those things can definitely come into play with a witness. There's issues with the validity of their opinion based on what they relied on that you can typically challenge, regardless of whether it clears the Stauber-Lannigan standard or not, whether it's admissible and reliable or not. You can always say there's other stuff that an expert, reasonable expert in your situation would have wanted to take into consideration, or things, that you wouldn't look at or that you wouldn't do. In this case, maybe blind box, go back to that blind box argument. Good science is not supposed to be tainted by extraneous information and knowledge of the theories and preferences of the person who's hiring you to give this testimony. So where does that then kind of draw the line? The way that I see it, experts are allowed to rely on assumptions. They're allowed to assume that if certain things are true, then X, Y, or Z. But that's all it is. It's an assumption that if this is true. And so that's how he would have to characterize this stuff, Again, if any of it even clears the reliability hurdle, which it sounds like some of it does not. I don't know. What's the scientific basis for distinguishing between a head injury that results from a fall and a head injury that, results from a fall that's caused by an assault? Like, what possible basis is there for that? I don't know. We never had it explained. The drop test, I mean, we didn't get much information about this either. But something about it, the falling backward and the G's generated. I don't know how you're doing that with a human subject with the proportions of John. The reason for the falling, is this a conscious falling back? Is this an unconscious falling back? Wouldn't that maybe have a little bit to do with a fall versus an assault? I mean, I don't even know. Intoxication, where that's going to play into it, and your ability to react and protect yourself, all that type of thing. I ain't saying any of this has valid methodology, and I think that a lot of Mr. Alessi's criticisms are really on point there. But I'm just saying, let's say Judge Cannoni lets it in, because we already know she's going to bend over backwards to try. Let's say she lets it in. He's a biomechanical engineer, and so this is within the scope of what he can testify to, his opinions. If these assumptions are true, then you can reach this conclusion based off of it. And so that just opens the door for the defense to get up on cross-examination and point out every single thing he's got to rely on. So if the jury disagrees that John O'Keefe never went in the house, then your conclusions fail. If the jury disagrees that, Jen McCabe testified truthfully and reliably, then your conclusions fail. If the jury disagrees that Julie Nagel, was credible or said X, Y, Z, then your conclusions fail. Like, you could just get to go through and highlight every single one of those assumptions and point out the ultimate conclusion requires all of them. And those are all things for the jury to decide. So that's where the limit is in that respect. But I just, I got some serious concerns about some of this stuff. He hit his arm. He painted his arm in his hand and swung it into the, what even is this experiment? It sounds ridiculous. It definitely does not sound like any kind of recreation of the circumstances that would have been in existence on the night of January 28th to 29th of 2022. Dark, snow on the ground, slippery, intoxicated, being hit by a vehicle going 28 miles an hour backwards and reverse in the arm. Where's that no, he didn't do that. He didn't do that, right? Because obviously he didn't. His whole theory is that would be enough to cause the accident that killed John O'Keefe. And yet here he is alive to testify in court about the results of this experiment. So I'm extremely skeptical, without knowing hardly any of the details at all, that this is any kind of valid experiment. It really sounds ridiculous. It sounds ridiculous. I, of course, always try not to be political on my show. I find politics just not particularly helpful in terms of how to categorize people and stuff like that. However, I have to say there was something that Mr. Brennan said that I wrote down in my notes, a Trumpism. This sounds like how Trump talks. And you can tell me if you agree or disagree. But when he's talking about the production, he was trying to say that, well, you know, Arca didn't hardly give anything as far as what they relied on, and we produced all this stuff. He gave eight gigabytes of stuff that that Dr. Welcher relied on, and that it was an extraordinary production. He's never seen a more complete production. It's like that sounds like Trump. Never seen a more complete. It's the most. It was an absolutely perfect production. Anyway. And then, yeah, the whole just missing the point of, you know, trying to say, well, Dr. Welcher just has a different opinion. No, you're missing the point. It's how he gets to his opinion. You have to substantiate that how he gets to his opinion matters. You can't just put any Joe Schmo up there to say whatever that disagrees with Arca, and it's okay. You have to show it's a legitimate scientific disagreement with Arca. You have to substantiate it. So total overlooking of the point. Nice to see we are now getting acknowledgement that there is at least a gentle nudging of John's SUV on video that we can see with our own eyes. I did wonder if we were going to continue to be gaslit about that. So no, we're going to get to believe what we can actually see, that they hit with enough force to actually move his vehicle. So that's a strike. Oh, Mr. Alessi was getting mad, wasn't he? He was getting mad. Did not like what Mr. Brennan was doing there. And then the projection, he knows the media is here. He's trying to dehumanize. Oh, you mean like you did accusing Karen Reed and the defense team of coordinating with the FBI to do the federal investigation, and that there's some weird relationship there, even though you yourself acknowledge you don't have any facts to base that on. You mean like that? The state of mind stuff, I mean, honestly, this is one where, from my perspective, it really almost doesn't matter if the defense loses this one. We already know they let it in before. I don't remember this particular legal argument that they have to show that it was communicated to her, which of course makes sense. That does seem to be the only way it's relevant to her motive is if she knows about it. But it's so tenuous. This is not significantly better than the Aruba stuff. It really isn't. That they argued about donuts and he wanted her to hold off on getting a plumber to fix her bathroom because he said he was going to go do it and apparently didn't. And therefore she killed him. Like, it kind of makes them look bad when they try to go down that road. So even if Judge Cannoni lets this in again a second time, I don't see that as being particularly damaging. So let's check where we're at in terms of how many motions we still have left. We got to the precluding the manner of death. Let's see. So we still have the Commonwealth's motion for an offer of proof before calling the district attorney and the victim witness advocate, Mr. Nelson. We just dealt with John's statements about his state of mind. We have the Commonwealth's motion to exclude bad character and misconduct evidence. This was that stupid general one that doesn't actually challenge anything in particular. It just basically says the defense shouldn't be able to suggest anybody else did anything wrong, which is, certainly not the law. So that one's dumb and kind of a waste of time. The motion to prohibit the investigative affairs information, the sustained findings, that one's going to get a little juicier today, isn't it? In light of intervening events. I don't know how you argue that sustained findings for misconduct in the course of the investigation that is under attack here, that multiple officers committed misconduct in the course of this investigation against Karen Reed is not relevant. Yeah, I think that's pretty relevant. Goes to their credibility as witnesses, goes to their bias as witnesses, and goes, frankly, to the legitimacy and credibility of their investigation. The motion to preclude the third-party culprit defense, we'll see. I've already suggested. I suspect the defense is backing off of that they're not going to try to assert a specific third-party culprit, which is really what this motion is about. You don't get to name a specific person. Kind of suggested from that Ted Daniels interview that they're not doing that. They're just saying, look, it could have been any of these people. It's not our job to know. It's police's job to know. They didn't do their job to rule these people out. And that's the Bowden defense. That's not the direct third-party culprit. So then we still have the Commonwealth's motion to exclude Garrett Wing, the defense's new dog expert guy, and then the Commonwealth's motion to exclude Michael Easter, the FBI officer who's got that CAS team experience, but is apparently going to testify about deficiencies in the investigation. So yeah, we still have a few things to get through after lunch, but honestly, I don't know why she's getting real concerned about time here. We'll have what, 2 hours to get through all this. I don't know, maybe it's not enough. Maybe it's not enough. Because we know court is going to hard stop at 4:00 p.m. in the afternoon. That's just how things go. All right, guys, at this point, I am going to go ahead and take myself off camera, just pause for a minute here so I can run and take care of business. I will be back. I'm going to aim for about 15 minutes, maybe 20, and then we will get to some of your comments before they get going back in court again. So thank you for hanging tight with me, and I will be right back. Okay, guys, trying not to jump scare. Trying not to just suddenly pop back in and surprise anyone who might be driving or otherwise attending to other business. We are very concerned about the well-being of our listeners here. So, welcome back. Of course, still waiting for court to get back in session. Real quickly, before we get into some of your comments, I did see the developments. The Commonwealth has filed a new witness list. And what are they trying to do? They are trying to put the defense lawyers on the witness list. So I kind of suspect that's going to be something that we have to deal with. I mean, today, soon, very soon. Because the whole reason that they would do that is to try to disqualify the defense team. It's very clear when some of the ethical limitations on attorney representation. You cannot be both an advocate and a witness in the same trial. Can't do it. You can't be sitting there representing a defendant and then be put on the stand where your credibility has to be at issue and so forth. So yeah, they're trying to disqualify the defense team, which, of course, if that happened, that puts you in a different situation in terms of preparing for trial. And we'd have to be going back and starting all over on that whole motion to continue and all of that. So they're going to have to make a showing of why the defense attorneys are necessary witnesses. Seems a little tit for tat, doesn't it? This whole you're going to put Morrissey and Nelson on the witness list. I'm going to put the defense lawyers on the witness list. What are they possibly witnesses to? It's just kind of ridiculous. That wouldn't be privileged, first off, and that couldn't be gotten somewhere else. If it's for example, like because Mr. Jackson was present for the Gretchen Voss interview, you get that from Gretchen Voss. You get that from the notes and stuff that you already have. The video, of the unaired parts of the interview that you already have. So you don't need a lawyer to testify to that. Very little else that I can think of that a lawyer could testify to that isn't going to be privileged. So yeah, be very interesting to see what sort of good faith basis Mr. Brennan has for making that particular argument. Oh, my tea's still warm. It's wonderful. All right, guys, let's take a look at some of your comments. Left, right, center, Michigan. Is there any chance Chloe the dog was let outside at the time of John's arrival and knocked him down, and he hit his head? I mean, maybe. I don't know. I think the question would be, where did this happen? Right? Where did this happen? Given where he was found. I ain't buying that the frozen ground caused skull fractures and this, contra-coup injury, if that's in fact what it is. It could be, I don't know, but I'm not buying that was caused just by, him falling backwards and hitting what is essentially at this point grass where snow is just barely starting to stick. So it would have had to be on the pavement or something like that. And then we'd have to have an explanation for how he ended up in the location he actually ended up at. That's part one. It also doesn't explain to me the other injuries that he has. The hands are a big one, the injuries to his hands, the ones that look so much like the kinds of injuries you get that you colloquially call a boxer's fracture. Very, very common. You have these, small bones and stuff on the, you can see mine real well now because I'm getting old, but all of these small bones and tendons and stuff. And you hit somebody wrong. There's just a lot of things that move in there. It's why you always tape your hands when you hit the heavy bag and so you don't look like an enormous douche in photos with your, big bloody knuckles. Not talking about anybody in particular, of course. But it is kind of a giveaway. Oh, you're some douche that hits the heavy bag without wrapping your hands. You always do that. It's not so much to keep you from getting skinned up. It's to hold those small bones in place because it is very, very easy. Your fist isn't quite tight enough, or you just hit at the wrong angle or something like that. And you can cause injuries in the back of your hand. And when it's on this side of your hand towards your pinky, that is typically known as a boxer's fracture. Now, again, like I said, I use that colloquially because when you talk about it in boxing, it doesn't matter if a bone is broken or not. It's just, you can have soft tissue injury and swelling and bruising and stuff like that. It's the same thing. It's an injury that's resulting from getting hit. So John's got those bruises on his hand that need to be explained to me because they sure do look like boxer's fracture types of injuries. And then also the other contusions on his face. He's got other injuries in his face that need to be explained. The one over his eyebrow, for sure. His nose looks pretty swollen. He's got the mouth, the cuts inside his mouth. That isn't explained to me by Chloe attacking him and maybe knocking him down. So that's where I would need to have a little bit more information to be able to accept that particular theory. James Casatelli, this trial is such a shit show, and Turtle Boy is doing more harm than good at this point. He's got a very bright tie in there today, doesn't he? That very, very pink tie. He's definitely making a statement. Look, I know Turtle Boy is controversial. Everybody has different opinions about him. Valid opinion. That Southern blonde lawyer. Gosh, what a pleasant surprise to see a competent judge holding non-upside down world court and insisting both parties adhere to the rules. Yeah, if you missed earlier this morning, this is about Judge Doolin. we got that nice little break where we got to see Judge Doolin handling the Commonwealth's Rule 17 motion, trying to get Turtle Boy's phone records. So it really was such a sharp contrast where he's got control, but he's not rude about it. He's not just outright rude. What is with Mr. Alessi getting up to speak and she's, we can't see the camera. She's clearly fucking snickering or some shit because he's stopping and waiting to see what her issue is. And she's like, oh, I'm just sorry. I just wondered if you were going to tell me what you were going to say and then say it and then told me you said it. What a rude bitch. That's so rude. It's so disrespectful and inappropriate and unnecessary. No, he's not. He's not going to do that. So yeah, I agree. It was nice to see a nice contrast with a judge who seems to be able to manage his court in a more impartial manner, the way that we expect it to be done. That Southern blonde lawyer. Did y'all see AJ jokingly say, Karen, unpack all this shit when she showed them the war room on the dock? Love AJ so much. P.S. This AM's hearing does my heart good so far. Some normal jurisprudence. Yeah. Love AB. Same with me. It really does. It's encouraging that everything is not a complete mess in the courts of the state of Massachusetts. He does seem like a competent judge. Being even-handed, being reasonable, being fair and erring on the side of protecting the defendant's rights. So I don't know what's not to like about that in a judge. I am still not catching up on the documentary. If you guys didn't see, there was like a 40+ document dump yesterday in the Koberger case. And I'm already way behind on making videos and stuff on it, but it's getting more and more difficult to stay caught up. So I've been kind of focusing on catching up with that. If I watch this documentary, it'll probably be over the weekend. So I haven't seen any of it yet, but that sounds funny. That sounds like they have a good relationship with each other, as you should and as you hope for when you're the attorney representing somebody. So that Southern blonde lawyer, it's telling that most of the Commonwealth's arguments are based in equity, not law. Obviously, pound that table, Hanky. Also, AB is the best. Yeah, clearly. He's switched now from obviously to clearly. You know, it's the same thing. If you have to say it's clear, it's not clear. Because if it's clear, you can show us that it's clear. So it's not clear. That's not persuasive. That's not a good argument. The whole entire argument. Yeah, dealing with Dr. Welcher. That whole thing was but Arca. He's trying to make a fairness argument. That's what's kind of meant by equity. It's this idea that courts have inherent powers to do what's just and fair in situations where the law doesn't necessarily give you an adequate remedy. So trying to say it's not fair, but never actually responds to what the law is. Maybe if you address the law first and the sort of remedy that provides to you by, for example, presenting an expert who can satisfy these standards that are set out in the law, you wouldn't have to ask for equitable relief. You wouldn't have to be complaining about how it's not fair, because you'd met your legal standard. So if you'd met your legal standard and it's still not fair, you might have a point, but you never even addressed the law. So yeah, he seems to have about as much concern for what the law actually requires as the judge does herself. Nikki, why aren't they trying to get this info from Karen's phone directly? Good question. I guess because don't they already have her phone? This had come up, because there were issues with, they had her phone, they extracted her phone, and I guess because it's after that, subsequent different phones, something like that. So they'd have to get a search warrant for it, or they'd have to get a subpoena for it, go through the same process with Judge Cannoni. Yeah, I don't know. I guess it's the fact that because they already did it in Turtle Boy's case, maybe. So they already have it. And they wouldn't have to do the whole go through the taint team process and stuff like that, like they had to do with Turtle Boy. I don't know. But I think that's a very legitimate question. Why wouldn't you try to get this from the defendant instead of from a third party witness in another case? Only reason I can think of is just logistics, because they think it's already basically been done. But then Mr. Bradel had that great point that they've had it since last year, and you're just now, asking for it, just now dealing with it at the 11th hour. Hallie P number 309. If Bev changes her mind, if it'll help the Commonwealth dog bite. If it'll help the Commonwealth, she'll change her mind. I think that that's a pretty valid prediction most of the time. I think, if you're the bookie in Vegas and you're setting the odds on what is the ruling going to be on any particular issue, you can go ahead and start with the minus sign in favor of the Commonwealth. You're at least minus 100 for the Commonwealth. Like, that's where you're starting. So as far as a dog bite, I think maybe what this is getting at is the fact that Arca wasn't allowed to testify about the injuries to his arm. And, Hank now wants to bring up these guys to say it, lines up with the patterns on the tail light, which just really seems pretty ridiculous, doesn't it? Doesn't that really seem pretty ridiculous? Is that just me? Maybe because I actually listened to Dr. Russell and her comments about, the flexibility of the skin and so on and so forth. I can see that his arm is round, and it's kind of silly. And you're trying to do this all from the unscaled photographs and everything. So in terms of, she might let the Commonwealth's witnesses do this. when she won't let the defense's witnesses do it, maybe. I don't know. Or their own, dog expert guy. I don't know. Lauren Boborin, how do you organize notes? Take bar in July. Oh boy. So my best, I outline. I'm a big outliner. When I'm doing notes like this, I'll just go ahead and show you. So I'm going through and listening to the arguments. This one's kind of long, so I won't use that. But so I'll have the motion. I'll say what motion we're talking about, and I'll underline that so that it stands out to me on the page. And then you can see here, I'll make a little note of who's talking, and I'll tend to shorthand that. And then I just take down the stuff that I tend to think is important, stuff that catches my attention and just really helps me track what's going on. Because this is a live stream, I'm not trying to capture everything. It's mostly just I'm trying to get enough so that if I want it, say I wanted to go back and clip something, I can find it relative to what else was talked about in the course of that motion. So in terms of raw note taking, that's really how I do it. When it comes to bar prep, I'm outlining. I am breaking things down categorically, really as much as possible. The main category is this torts, is this criminal law, is this civil procedure, whatever. The subcategories is this jurisdiction, is this standing, is this justiciability, whatever those subtopics are, and then just depending on what are the various rules that you need to know within that subcategory. Some of them will be categorized as well. Some of them will be a little bit more specific. I said justiciability, so that might get broken down into, is this a political question? Is this a separation of powers problem? Things like that. And then just the different rules that you need to know that would apply to that particular situation. And so that's really what bar prep is about remembering all the rules, how they're organized, so that when a topic comes up, you're able to identify, okay, that's where it fits in. We can see that this is triggering a question of, is this just, justiciable controversy because it's Congress trying to sue the president, or something like that. And then that will enable you to kind of work through, first off, identifying civil procedure is part of the subject of this question, right? So then take me back to my outline for civil procedure, and here's all the different things, because chances are, if the question is about civil procedure, that's not the only civil procedure part of it. That will alert you that there could be other issues to spot in this question that deal with civil procedure. But then, identifying the specific one, being able to state the rule and analyze it with respect to that particular question. So that's what I recommend. I did a bar review course. I did Barbary. Found it particularly helpful. Just the practice question thing alone, I think is really worthwhile. Practice makes perfect, and so the better you get at just doing it, at spotting how they hide little issues in the questions and things like that, the better prepared you'll be to do it when it counts. That Southern Blonde, oh, and by the way, good luck on the bar exam. Good luck. That Southern Blonde lawyer, violence is never the answer, but damn, wouldn't I love to see AJ, DYLL, and RA take on HBAL and Bev WWE style. Let's be honest, Bev is CW first chair. Yeah, first chair in the courtroom, and probably also in the WWE sense, right? You got to take her out, or you have no chance. I mean, she's got so much more power over what happens than everybody else. We're not advocating for violence here because everybody knows WWE isn't real anyway. Spoiler alert. Sorry, guys, if that's news to you. Yeah, it is very frustrating. Very frustrating. Greg, really liking Runkle's move on this now. Every single objection sidebar. We talked about this before, and it's an option. It's just it's a mixed bag. Because like Ellen Jackson pointed out, you run the risk that you're going to piss off the jury. If they think you're wasting time, they think you're dragging it out, they think you're not doing it in good faith, then yeah, they might hold that against you. On the other hand, you absolutely have to do it when you need to make a record. And so if you need to make your record, then yeah, you need to be going to sidebar. And so maybe if you do it every single time, she would get the point that you're serious about being able to make your record, and would bend on letting them just state it in open court. But why do I suspect that that's not actually what would happen? If she were open to this at all, she wouldn't have just been like, well, I'm denying the motion, without considering it, without asking for a response from it. She didn't even ask if the Commonwealth objects. You notice that? She's been asking as we go through, does the Commonwealth object to the motion? She didn't ask if the Commonwealth even objected to that one. She doesn't care. She's going to do it this way. So in terms of like the leverage it might put on her, I don't think so. I don't think that's going to work. So then it just becomes a strategic question of, is the upside you get from doing that going to justify the likely downside you're going to get in the jury's eyes? Lawyer nurse. Question, Andrea Burkhart. How can she deny such a simple request to allow them to state the objection? What is her reasoning behind this, do you think? I have said before, part of the reason why I believe she does this is to save her butt for appellate review. And that's because if she grants the objection or denies the objection, and it's clear, what's going on, what the basis is, you have a much stronger ability to be able to demonstrate her ruling was wrong. Because it's just, what the rules are. If you don't know what the basis for the objection even is, then if you're appealing that particular ruling, right, because it has consequences that you think were incorrect, you're going to have to anticipate every single possible objection that it could have been and try to rule all those out. And so it's based on this idea that in the appellate world, the judge can typically be affirmed on any basis that is there in the record. So, even if you think it was a hearsay objection, but it turns out it could have been to foundation, you can sustain based on that. But if she specifically sustained the objection based on hearsay, and that's wrong, it was admissible, then you're in a much better position to be able to get your relief. So I think that's part of why she's doing it. It is literally just to create a murky record for appeal. And then you have these secondary considerations that, if she is trying to make it as difficult for the defense as possible, which it, kind of seems like, kind of looks that way with the double standards about pretty much everything, then the fact that the jury will hold it against them for having to have all those sidebars, that's not a bug now. That's a feature. That's part of the reason to do that. Make them piss off the jury in order to make their record for appellate purposes. So it's nefarious. It's not reasonable. It's not efficient. It's not fair. It's not any of those things. And she's doing it because she can. She has that discretion to decide how things are going to be done in her courtroom. Obviously, within certain parameters, there's constitutional floors, but there's no constitutional right to be able to state your objections in open court. So, yeah, not particularly good reasoning from what I would see. And I have to notice she hasn't given any. She hasn't told us. She hasn't just told us this is why. She hasn't told them this is why. Just no, I'm going to deny the motion. We're not going to do it that way. It's not how we do it here. Why not? What's the rationale to not do it? I don't know. Marianne, his voice annoys the hell out of me, flaky hanky. He does have a little bit of that nasally thing going on that can be a little bit irritating. The accent I get used to. I don't find the accent in and of itself particularly irritating. But he does just have this manner of delivery that it is. I find it off-putting myself. Of course, I'm willing to acknowledge that maybe I don't like his voice because I don't particularly like him. I don't particularly like how he lawyers. I don't particularly like the things he's saying. I think he's often not arguing well, clearly stuff. I think he's often stating the conclusory, unsubstantiated things as though they're facts. I think he is rather squirrely with the truth of what he is representing. So that could be tainting me a little bit. I could acknowledge that, but just in general, it's the nasally quality of his voice that I think is a bit unpleasant. Melissa Dotson is out here gifting some Andrea Burkhart memberships again. Melissa, you are so generous. She's been doing this like every single stream, and I really appreciate that. I know that everybody here who's getting one of those memberships is appreciating it as well. Z&D Fifth is a new member. Welcome, Z&D Fifth. Tin Cat, Bev encourages the tit-for-tat accusations by not reprimanding Brennan's theatrics, and especially now that she has stated on record she thinks the defense lied. She is creating a circus. Yeah, this is a good observation. And you know what it reminds me of? It reminds me of a hockey game. It reminds me of why refereeing is so important. Because your job is to keep everybody in line and to police fouls. And so if you do not do that, they will do it for themselves. They will take care of their own business. And that's how you end up with, how you end up with big brawls on the hockey ice. Like another example, that's how you end up with somebody's ear getting bitten in the boxing ring. Because you're not policing the headbutting that guy is doing. The guy is headbutting. It's illegal and nobody's calling it. And the referee isn't taking care of it. So the fighter gets frustrated and he decides, you're fighting dirty. I'm going to fight dirty. Is that a good call? No, probably isn't. But is it natural? Yeah, it is. Yeah, it is. That's normal. It's normal that people are going to do stuff like that. So it's just a product of bad refereeing. I think this is such an on-point comment because it is. This is completely attributable to Bev and her enforcement or lack thereof, the uneven-handed treatment. Now they have to keep pointing out when the standard is not being applied the way that she applied it to them. So, am I hearing that we're back in court? Not seeing it yet. Okay, there we go. Looks like they might be coming back in. Let's see. Do we have no sound yet?
And I think we can do it. We need to spend some time talking about voir dire, so I don't want to run out of time for that. So what I plan on doing is finishing these motions by 3:00. We'll give each side 2 minutes. We'll see how we do with that.
2 minutes?
And we'll try and
Good
get
luck
through
with
this.
that.
Juror questionnaires, have you provided those? Remember we talked about it the other day? Have the two of you worked out a juror questionnaire?
I know you asked us to, we haven't
All right,
spoken.
so today's the final trial conference where I'm supposed to have all of this, right? Can Can you do it before you finish? Well, let's see where we get with the motions and we'll see it.
And Your Honor, if I could I finish that last point that I was about to make just before we broke?
30 seconds, Mr. Jackson.
It'll take me 30 seconds. I want the court to be super, super clear about this one. What Mr. Brennan referenced, and I understand why he would reference it in the transcript of the Gretchen Voss interview. The reference to the she called John and talked about Ashley's home or Ashley's house. The she was Jennifer McCabe. But on the 28th, calling John to say 34 Fairview is down the street from Ashley's house. My client was not part of that conversation. That was between Jen McCabe, as she testified, and John.
Okay.
Then the next day is when the conversation, according to Jen, took place about Ashley and could it have been some sort of an interaction or an affair or something like that.
Okay.
My only point in making this, and I just want the record to be super clear.
I understand what your point is in making
There
it.
was no animus, no evidence of animus on the night.
I understand that's your position. We haven't heard the evidence yet.
Okay, I just want to make sure.
All right.
Thank you.
All right. Well, Mr. Jackson, you can stand up again. Is the defendant pursuing a third-party culprit defense?
That's going to be my colleague, Mr. Yannetti.
So you get 2 minutes, Mr. Yannetti. That's sort of a yes or no, and then I'll
2
hear the
minutes.
Commonwealth.
And I'm sorry, I did not hear the question. Yes.
All right, so I'll hear you on your motion, Mr. Brennan, and then a 2-minute response.
Okay.
Jimmy, keep track, please.
Yeah.
Go ahead.
Thank you. During the first trial, Your Honor made a ruling prior to defense presenting any evidence or questioning any witness about third-party culprit the defense needed to provide sufficient evidence to pursue or place that issue in front of the jury. The defense, in my opinion, looking at the opening argument, ignored that directive by the court. The very first words of the opening were directed to third-party culprit. And thereafter, throughout the case, there does not seem to be any boundaries, parameters, or identification of the walls or the length of third-party culprit. The varying representations by the defense over time make very unclear what the third-party culprit evidence is, whether it is a particular person, includes particular people, or unknown. We know from the defendant's statements that there was a position taken on the front of the courthouse steps that everybody knew who the third-party culprit was. That position changed in the Ted Daniels interview when they were asked about third-party culprit, Mr. Jackson, and the defendant said they did not know. And so despite the recent position that they did not know who the third-party culprit was, in our argument the other day, Attorney Little identified Brian Albert as third-party culprit, Mr. Albert. And so there is this vacillating position on who the third-party culprit is and what evidence they suggest supports third-party culprit. I took an opportunity to go back to the arguments last year for third-party culprit. I have a transcript, and it's equally undefined at that point. And so what we have now is the defense with a hope or an expectation or intention to pursue third-party culprit, but we have no basis for it. The court has been very clear on third-party culprit, and they can't just come in and start accusing people arbitrarily of committing the crime of murder. Section 1105 of the Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the defendant.
So I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit. Your time is up at this point.
You see?
I've read your motion. I've read your memo.
Okay.
Or the pleadings.
Thank you.
All right, Mr. Yannetti. Jim, why don't you stand? Can you stand when it's done?
Your Honor, I can't do this in 2 minutes.
Well, then we'll hold it. We'll hold it to the end.
That's fine.
All right, Mr. Lessie, I'm going to hold you to 2 minutes. I've got the Commonwealth's motion on the Celebrate demonstration. I'll hear you for 2 minutes on that.
My 2 minutes start when I get to the podium?
Yes.
Thank you.
The courtroom demonstration that the Commonwealth proposes is incredibly vague, and it, to the extent it can be understood, is impermissible. I'm fully aware of what happened in trial one. Not only did I read the transcript, I went back and watched the video. The Commonwealth states that they want to conduct, I'm reading verbatim on page 1, a courtroom demonstration of how data was stored within Jen McCabe's cell phone. That's it. No elaboration, what it's going to be. They're looking, to me, this is a blank check. Similarly, with regard to Jessica Hyde, we'll use a courtroom demonstration to show jurors information and data on both the phones to explain concepts and to illustrate particular information of importance. Vague, again, we have no idea what it's going to be, nor does the court. And there are similar statements, and also on page 2, they concede they want Mr. Whiffen to use the highly disputed extraction reports to demonstrate Celebrate Software. It says this demonstration would closely mirror the actual Google searches, but we don't know how. It's obviously not going to do it. And lastly, with regard to the law, section 1006 talks about the witness presenting the summary is not permitted to state deductions or inferences. That's right in the note to the rule, and that's exactly what they want them to do, is to give the deduction and the inference that the 227 timestamp means it came to at 6:30. It's in direct violation of the rule. And secondly, under 1006, the appeals court held that because the presentation selectively presented excerpts of other exhibits and evidence in such a way that it served to both bolster the Commonwealth case and rebut the defendant's case, it was not merely a neutral summary. It was more akin to an argument than evidence. The Commonwealth concedes that's the case. And with regard to Commonwealth v. Sosa, page 14, the only thing that was allowed in Sosa, the case they cite, it says the complete video footage contained several camera angles of the property. And the condensed video merely was a compilation of that which already existed. They just shortened it down. What they're proposing to do is anything but that.
All right. I appreciate your brevity too. Thank you.
Shut up.
Mr. Brennan?
God, appreciate your brevity.
The demonstration we would be asking Ian Whiffen to engage in is the same demonstration as he did at the first trial. No different, based on the same qualifications, based on the same experience. It is essential that the jury understand and be able to see the data in action so they can appreciate the legitimacy of how the data is stored and how those windows are opened. As far as Jessica Hyde, we've provided a number of different reports. We would like to provide chalks that come directly from those reports. So if there's anything that's particularly offensive in those chalks, I'm willing to discuss it with the defense. There would be nothing new or different than hasn't already been provided. It would be simply blowing up the photographs or the exhibits in her reports so that the jury can read along and see them.
Okay. Thank you very much. I'll get a decision quickly to you now. Does the defense intend to bring up any bad character or misconduct of John O'Keefe or any witness?
Not for character purposes. That's so vague.
Bad character evidence is inadmissible.
Right.
To the extent that evidence could be used for like motive, opportunity, all the alternative, under proposed rule 404, we reserve the right, but we would approach sidebar before introducing any such evidence, and certainly not against John O'Keefe.
What do you say, Mr. Brennan?
If we have advance notice, I think that's appropriate. I don't want to wait until we get the sidebar. If the defense has an intention of offering what would otherwise be prior bad act evidence, but they think it meets an exception under the rule, then they should propose that evidence so we have time to consider it.
Especially if you intend to open on it. Are you doing the opening, Ms. Giannetti?
I will not be doing the opening this time, and I do not believe we will be opening on that at all.
All right. So, okay. So what I'll do is not during the opening and only with advance notice and a ruling.
What would the advance notice be, Your Honor?
A week before a week before the evidence starts.
Thank you.
Okay, that's
Week
paper
before the
587,
evidence
Mr. Clerk.
starts.
Thank you.
Commonwealth's motion for an offer of proof regarding calling District Attorney Morrissey and victim witness advocate Steve Nelson. And it also includes a request to exempt from sequestration.
Your Honor, with regard to this motion, we have no, on principle, we have no objection to an offer of proof as necessitated by the court's guidance.
Yep.
The issues do go strictly to trial strategy and attorney work product. So any such offer of proof, we would ask, we make that ex parte. I can tell the court, just to kind of streamline things, we would not be seeking either of these individuals in our case in chief. They would be merely impeachment if necessary.
Okay.
Certainly, we could make those offers of proof at the appropriate time.
Okay.
Thanks.
All right. I'm satisfied with that. What's the Commonwealth's position? You satisfied with that?
I am. I would like the victim witness advocate to be able to.
Yes, the victim witness advocate, he'll be able to come in for trial.
I wasn't worried about the sequestration aspect of it. I should have mentioned that.
Okay.
Thank you.
All right, so they're both exempt from sequestration. Okay. So the other motions do seem like they may take a little bit more time. I'm going to well, actually, let's try this one, see how we can do with this. So the Commonwealth's motion eliminate to prohibit reference to the pending internal affairs investigation, sustained findings unrelated to this case or unfounded allegations. Well, this is in a little bit different posture now than when the Commonwealth filed it.
It sure is.
Back on March 10th, right? With Michael Proctor being fired. Do you need some time to reconfigure this, or you want to just be heard? And for this, I'll give you both 3 or 4 minutes.
I think it'd be helpful to have more time. I can report that when we learned that Mr. Proctor was fired, we filed a request for all the IA files. We included the defense, and I understand there was a production produced to us, to both of us. Now, I have not seen it.
Okay.
It may be voluminous. It's something I'd like to review. I'm expecting that there may be many pieces of material in that production that is going to be relevant for the defense in this case. And if I have a chance to review it, much of it I may not object to, but there are some fundamental things I'd object to. Traditionally, ultimate findings or opinions of an advisory board or a body aren't admissible. So there will be some constant argument about what is objectionable, but I think a review of the material is helpful so we can better define what is in there and what should be admissible and what shouldn't.
All right, so you just received it. When do you anticipate being able to review it and forward at least what you feel the rules require you to forward? And then if there's anything else that I have to decide, how long will it take you to review it and provide defense counsel with everything that you believe you're required to provide them?
They have a copy of everything that we got.
Oh, okay.
So we had them on the email so they could get everything that we received. We don't have anything they don't have.
Oh, okay.
So it's really just an evidentiary argument. Can, for example, a firing, can that come in that he was fired? Can the conclusions of the board come in, whatever their position is? Maybe they found him acting unbecoming of an officer. I don't know.
Yeah,
but those type of conclusions are what I'll probably object to. The material, I haven't read it. I hear it's voluminous. Need some time to read it.
Okay. How much time?
Well, I think till the end of next week.
Is that a same timetable you would have whoever's arguing for the defense?
That's fine, Your Honor. I would just ask for notice about what specifically the Commonwealth is seeking to exclude. There were some, even just in the motion that they filed, there's inconsistencies.
Yeah, but I think it's all different now, right?
Exactly, but there's just inconsistencies between the title and then what's actually in the body of the motion. So as long as I have clarity, then I know what to address.
Okay. All right. Is this something we should come in the day before impanelment and deal with?
I'm happy to come in if the court's available.
Want to do that?
That's fine, Your Honor.
I'd rather not have anything, but I think it makes sense that we at least give you that time and then the weekend. And if you go through it, I'd like something by next Friday too. If there are materials that the two of you are disagreeing about, so that I can view it next weekend and then we can have a hearing the following Monday.
Yes, Your Honor.
Okay.
Does the court intend to have a hearing on the Monday after that? I just would like some time to be able to review their position so I can have time to respond.
So you need until next Friday. I'd like to do it before we start the trial, but I suppose we could start the trial and then hear it.
That's fine, Your Honor.
Can you
I'll move
have,
as quick as I can. I have a lot of
Okay.
obligations over the next week. I'll try to facilitate it. I just don't know.
So which one are we doing, Judge?
without knowing how much is in dispute, Ms. Little, you have no idea how long it will take you to address that, right? So,
Correct.
um, all right, so Mr. Brennan, by the 28th, you're to provide the defendant with anything that is disputed and when you, or that you feel should be excluded. And when you provide that to the Commonwealth, I'd like you to let me know as well.
I will.
All right, and then Ms. Little, why don't you tell me on April 1st how much time you need to finish up? It may be nothing, you may have it and we can do it. So I guess we won't meet on the 31st on this?
Thank you, Your Honor. I appreciate that.
All right.
Okay.
So on the 1st, you'll tell me how much time you need. All right, so Mr. Brennan, since we are making good time, I'll let you go back and finish what you were saying when I gave you a 2-minute, when I cut you off after 2 minutes on third-party culprit. And then Ms. Giannetti, I'll give you both up to 5 minutes on this. 5 minutes is a long time, Ms. Giannetti. Let's see how you do.
If the court's inclined to admit the evidence, then I don't need to speak at all. But if
Well,
you're-
last time I said I wasn't excluding it, you just couldn't open on it. Right? So
Yeah, but now you
that's
have an
where-
entire
that's where
trial
I'm
with an
at
offer
this
of proof.
point, and I'll hear the different sides. So,
if that's the ruling, Judge, I don't need to be heard.
and I know, Mr. Brennan, you wanted it in advance, but, you know, I guess I'll hear you on your motion on that.
The
We have an
requirements
entire
of
trial
providing
now.
evidence to support third-party culprit are clear. The evidence has to be relevant, it can't be speculative, and it can't tend to prejudice or confuse the jury. If it involves hearsay or inadmissible evidence, there has to be a substantial connection between the crime charged. And so what we would want to avoid is what appeared happened in the last case when it was just a broad-based attack on anybody. There has to be relevance
wasn't a
between
broad-based
who they
attack on
choose as
anybody,
a target
Mr. Brennan.
and the crime itself.
It was an attack
Looking
on the
at the
people in the
transcripts,
house.
I do not see that they've met a substantial basis between any particular individual and John O'Keefe. If we start from the premise that every single witness who testified that John O'Keefe never entered the home at 34 Fairview.
And the jury
Every witness,
can
there is
reject
no
that.
substantive evidence that John O'Keefe ever entered that home. So to open up an invitation
There
for the
was
defense
Waze
to start
data,
to present
or the
evidence,
health data.
sometimes alleged prior bad act evidence or character evidence is unfair because then it becomes a mini trial for each witness. And so I haven't heard any basis or any proffer by the defense that would substantiate any particular witness is a third-party culprit. Now, there are some cases that saying you don't have to actually identify the witness. Those are particular circumstances where there is still substantial evidence that an unknown person had committed the crime. That is not the case here. They have used names liberally, randomly, and those names have changed throughout litigation, whether it's in trial, after trial, but we've never seen a proffer by them. Who is it that they're going to claim as a third-party culprit? What evidence do they have that they want to introduce? There has to be parameters and limitations if they're going to try to introduce third-party culprit evidence, not only about who the person is, but what evidence are they going to introduce? Otherwise, we're going to spend half the trial at Sarbar fighting whether
is somebody
this is
in the house,
substantial,
Mr.
whether it's
Brennan?
supported. And so
Somebody in
no
the
proffer
house.
has been made. I think there's an obligation to the defense to identify who the third-party culprit is and what do they want to introduce? Do they have a witness? Do they have evidence? Do they have
Yes,
any
Had a whole
records?
trial.
Simply
Perhaps
assailing
we should
people's
review it.
character randomly is improper, it's unfair, and then it causes the Commonwealth to have to spend extraordinary time rebutting, which is going to confuse this jury. and it's prejudicial. So I think that the court should order the defense to articulate who they claim the party culprit is and exactly what evidence they're going to introduce to support that claim. It's not until they articulate it we can really fashion an argument for the court, whether we think it is appropriate or whether we think it's insufficient.
We're going to rely on
But
John's
now it's
false
just an
data,
empty box where,
their own lack of
as in
credibility,
the last trial, the defense can
dialing,
simply get up and
their
blame
consciousness
anybody
of
and
guilt.
everybody. And that's not the
That's what
way
we're gonna
the
rely
court
on.
and the courts have seen third-party culprit evidence.
Oh, and
There's
also
a
John's
standard, there's an
injuries.
obligation.
We're going to rely on
It
that
hasn't
too.
been met. So at this point, the court should preclude third-party culprit evidence. They shouldn't have, they can certainly pursue some type of critique on the police investigation, but as far as third party, without a proffer and a finding, there would be no guardrails, there'd be no parameters, and it would be chaos.
Chaos.
All right. So, Ms. Giannetti, I will hear from you, and I'd focus on, could you tell me whether this is pure third-party culprit, third party as it goes to Bowden, or is it simply somebody else did it and we don't know who?
It's the second alternative. In other words.
Okay, so that's a little bit different, Mr. Brennan, not pure third-party. I'll still, go ahead, you can go over there. It's a little bit different if it's
So they are
third-party as it
picking
goes
off
to Bowden, but we
specific.
know that it's not admissible if the police didn't know about that third party and not act on it. So are you going to tell us who? Last time you told me you don't have to prove that, but can
Well,
you make
it's
an
still our
offer?
position that we don't have to prove or narrow it to one potential third-party culprit.
Are you saying it's several?
Three, yes.
Okay, so can you tell me the three that you say it is?
Sure. So the potential third-party culprits that we have identified are Brian Albert, Brian Higgins, and Colin Albert. I have, evidence with regard to each. I'm sensitive to the fact, Your Honor, that, and I have a lengthy argument prepared detailing the evidence against each of them.
Do you want to put it in writing?
Well, I'm just sensitive to the fact that the court is seeking not to, pollute the potential.
So we can do this over here.
It's up to Your Honor.
Why don't I see you preliminarily over there?
So if we're worried about polluting the jury, it's either just because the timing and we don't want to repeat everything we already heard in the first trial, like right now. But, what was already heard in the first trial, we've already heard it. It's already out there. So we don't need to be having a sidebar. Do they have more? Maybe they have more. I don't know. I would expect that's part of the reason why they have so many experts, and I expect that's part of the implication of them having so many more experts is that they are, fleshing some of this stuff out. The whole idea that Karen Reed was framed is violating the third-party restriction. It's ridiculous. Who frames somebody? The police do. The police do. That goes absolutely directly to the Bowden issue. They didn't I guess I'll take her off until we're back in court. They deliberately, like ex-trooper Proctor told us in his text messages, no heat's going to come down on that house. He's a Boston cop too. Girl's going to be in a lot of trouble. They did that on purpose. They set her up so that they could protect their fellow Boston cop. Karen Reed was framed as focusing on the police conduct. It's not focusing on which specific person are they covering up for, because under these circumstances, it doesn't matter. It doesn't matter who's the one that got in the fight with John. It matters that it happened in Brian Albert's house. Brian Albert is the one who has potential interests from a liability standpoint, from a not getting in trouble with his superiors standpoint, from, protecting people standpoint. He's the Boston cop they were going to protect. So I don't know what's happening right now. Obviously, everybody is back at their seats. I don't know why we're looking at the tray of envelopes and Kleenex there. Or are those the gloves? Are those the gloves that the witnesses put on for the security theater? Can't quite tell. The security theater, the evidence integrity theater where they, put on the gloves and then touch everything in the courtroom and then handle the evidence and then handle the other evidence and so on and so forth. Yeah. Well, that's as annoying as the fan. So I don't know. Maybe Judge Cannoni went off the bench or something. I'm guessing maybe he gave her something in writing for her to go back and review. We have a whole trial with a record that is an offer of proof now. At least what came out in the first trial is going to come back out this time. So we could just start from that. Was it enough the first time? It seemed to be, because ultimately you were allowing it. So they're not trying to do a straight third-party culprit where they're going to go in and say X did it. They're going in to say police failed to rule this class of people out, these three particular people out. And they had a motive to do that. Yeah, they can and should be able to open on that. I really have a hard time seeing any kind of reasoning why they wouldn't be able to do that. It has to be relevant. It has to be non-speculative. Once again, Mr. Brennan, just on this, there's no evidence. Well, number one, the jury does not have to believe any of the witnesses. Just because somebody gets on the stand and says something, that does not definitively establish a fact. The jury is the ultimate judge of the credibility of the witnesses. They can decide, these people are all lying. I don't buy it. What other evidence is there? There was the whole issue with John's health data and the going up and down the flights of stairs. That's evidence that he went inside. There's the condition of John's body and the fact that it isn't consistent with a motor vehicle collision. What did it look like to Dr. Russell? Like he'd been in a fight. So there's that. That's evidence. The whole there's no evidence. God, it's so annoying to me. It's so annoying to me. There is evidence. And there's plenty of it. There's a reason why Judge Cannoni is having to go off the bench there and sit and review a volume of evidence provided by Mr. Yannetti. So interesting. He's not going to open, and they are sort of tweaking their approach. Oh, please let it be Mr. Alessi. I said this like the first time I sat and watched him in court. Please let him be the one to open and close. And the reason why is just because that methodical, organized approach he has is so effective. It makes things so clear and so easy to follow. He's so systematic at being able to walk you through facts and arguments to get to a point and a conclusion. That I think is going to be extremely effective when he can do that with something that is simple, which factual issues typically tend to be. He knows what points the jury needs to decide in Karen Reed's favor to decide she's not guilty. And so then he's going to go through and he's going to organize all of the evidence that's going to be elicited to support those points. And that's how you lay out an opening. It is a tell them what you're going to say, tell them, and then tell them you told them. That's literally opening, trial, closing. That's the process. So I do. I hope it's him. I really hope it's him. I guess we'll see. So, coming back to the issue with Proctor, a little bit of a different posture. Yeah, it sure is. Sure is a little bit of a different posture, isn't it? Of course, we could still be dealing with the other police officers, right? If the issue is the fact that he's actually been fired. Well, the other officers weren't fired. What did they get? Did they get some paid leave? Maybe unpaid leave? I think Buchanan maybe lost some of his paid vacation or something.
The defense has to make a decision as to what you intend to provide me so that I can make this ruling. So, all right, next is the Commonwealth's motion in limine to exclude the expert testimony of Garrett Wing. I know nothing about this person other than your motion just says that all you have is a CV. Does the defense intend to call this person?
I'm going to address that, Your Honor. How will you, I want to make sure I'm within your time constraints, so you want me to stand up?
2 minutes. Just my first question is, who is this person and why haven't you complied with your reciprocal discovery obligations?
Your Honor, because this witness is pending Dr. Crosby, and he's presented because of Dr. Crosby. So it depends upon what happens with that. If Your Honor is ruling on the motion for reconsideration, then we can have a better answer to your question. But that's the purpose, is to address if Dr. Crosby is going to be allowed to testify, and if so, as to what. And we're happy to provide, once we get that determination, provide all the things that I think Your Honor has in mind.
Well, I've already ruled on Dr. Crosby, right? It's just the reconsideration, whether I think I need to rule on it or not. I'd like you to provide the discovery on this, just so we can keep things moving and we don't have to suspend the trial.
We will do so, Your Honor.
All right, so what do you say, Mr. Brennan?
Well, discovery deadlines have passed, and the Commonwealth shouldn't be in a compromised position of receiving late discovery and trying to deal with it. So I'd like a time certain.
You probably have it, Mr. Alessi, right? You're very well prepared. Do you have all your reciprocal discovery that you need to give the Commonwealth on this witness?
I do not, and not only do I not have all of it, I need to go take a look at to make sure, in light of recent events, that I provide everything to the court. So I can meet a fairly short deadline, assuming I can communicate 3 days.
Can we do it by Monday?
Yes.
Is that acceptable, Mr. Brennan?
Yes.
All right.
Thank you, Your Honor.
Thank you. So
Light of recent
607,
events.
Jim, is the defendant will provide reciprocal discovery by Monday, the 24th.
Yeah, because you don't want to certify, because you know you'll be called out for it and Commonwealth won't.
All right. The Commonwealth's motion eliminate to exclude defense expert Michael Easter's opinion of the investigation. So I'll hear you on that, Mr. Brennan. I figured this is probably lengthier than the others.
I'm sorry, Your Honor?
I figured this might be more than 2 minutes, might be lengthier than the others we've had.
The defense would like to call Mr. Easter to essentially testify about his personal opinions of the investigation, and then to purportedly give opinions about the police investigation, their failure, in his opinion, to pursue certain leads, and to give opinions about their efforts regarding writing reports. This is, from my perspective, tantamount to having a witness come in and vouch for the credibility of defense arguments and essentially summarize arguments. This really, from my perspective, is the role of the defense attorney, to cross-examine the witnesses, to point out the inadequacies, to introduce any documents they have if they want to try to impeach the witnesses, and then the witness would have the opportunity to respond or explain or admit any type failures. This is an attempt to bolster a potential Bowden defense and a third-party culprit defense. It would involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit may be. That would be totally improper opinion and inadmissible. They would want Mr. Easter to come in and to go through protocol of the state and local police and point out what he thinks is failures. So essentially, he's a witness that would come and promote the defense theories, tout reasonable doubt, and suggest why somebody else committed the crime. I've done quite a bit of research. This is not a summary witness. This is not a witness that has any relevance other than his own personal opinion. This former FBI agent was a full-time member of the CAS department since 2013. He is not in a position to determine the best practices of local or state. If there are different rules and regulations that the defense will attempt to introduce, that will be a separate grounds of whether they're admissible and whether they can confront the witness. And a witness always has a right to explain or challenge accusations against them. And so I see that this witness is really simply a summary witness for the defense, but not summarizing information that the jury can then digest like information in data records or phone records, rather a summary witness of a witness who wants to come in and give their personal opinions about this case. I don't see any grounds for admissibility for Mr. Easter to come into this case and give his opinions regarding whether he thinks the police investigation was appropriate or not, or whether he would have directed somebody to do something different, and inevitably whether he thinks somebody is a suspect
whether he's an expert.
Was not pursued. That is all in the province of the defense in their case and in their cross-examination. So I don't see any relevance whatsoever of Mr. Easter.
All right, who's arguing?
Why am I surprised that you see
I
no
need you to start by
relevance
telling me what
whatsoever?
you expect him to testify
Definitive
to.
terms.
Certainly tell the court that we do not expect to seek testimony or elicit testimony from Mr. Easter as to a third-party culprit.
All right, but who is he? He's a retired FBI agent?
Correct.
So what purpose are you calling him for? What's his testimony on?
To opine on the adequacy of the investigation. He is an expert as it pertains to investigations, investigative protocols, the adequacy of a proper investigation, what investigations should look like, what a proper investigation should look like.
How is he an expert on that? How is that a field, and how is he an expert on it?
I'll go through that.
Is it something he's done? Has he testified on that in other courts?
He's testified in dozens and dozens, if not hundreds of courts on issues related to investigations. He was a lead case agent for the FBI for many, many years. He taught issues concerning or taught issues specific to proper investigations and investigative techniques.
So do you have a report and CV and all that material
Yes.
that you can share with me?
Sure. I've already shared it with the Commonwealth, but I'm happy to share it with the court as well. If I think I can address many of the court's concerns as it pertains to his expertise and why the law in the Commonwealth allows, in 702, allows him, someone with his credentials, to testify to a very specific issue, like, for instance, something beyond the normal capacity of a layperson or a lay juror, and that is proper investigative techniques. A lay juror might not know, for instance, that collecting items in solo cups or grocery bags would be improper. Mike Easter certainly would know that and could opine on whether or not that followed standard protocols. What he's not going to do to assuage the Commonwealth's concerns, he's not going to or we're not going to seek to elicit testimony from Mr. Easter concerning a third-party culprit or who that third-party culprit was, but merely what investigators should do when they walk up to a crime scene and how those crime scenes should be dealt with, et cetera.
So is the basis of his testimony just crime scene, like collection of evidence, or is it
witness interviews?
When somebody tells you somebody may have done it, you're supposed to go follow all those leads? Which is it?
That too, both. Because if someone tells you as an investigator, someone else may have done it, you're supposed to follow that lead. That is a proper investigative technique. Of course it is. But it also includes, as the court just noted, things like cordoning off the crime scene, maintaining proper logs, evidence recovery, evidence photographing, logging materials that are moved from the crime scene over to the crime lab, how that's supposed to be done, what types of logs are kept and why those logs are kept, how you bag evidence, how you secure evidence, how you maintain the integrity of evidence, and things of that nature. There is certainly, I would indicate to the court that 702 in Massachusetts mirrors very specifically 702 in the federal courts. It's literally, I looked at them side by side. They're nearly word for word. And the advisory committee notes for federal rules of evidence 702 is very, very instructive on this particular issue, specifically as it pertains to somebody with the expertise in a field like crime scene investigations and investigative protocols. And what the advisory committee notes say is, quote, 702, the rule is broadly phrased. The fields of knowledge which may be drawn upon are not merely limited to, quote, scientific and, quote, technical, the scientific and the technical, but extend to all specialized knowledge. Similarly, the expert is viewed not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education.
Doesn't have to be credentials.
Thus, within the scope of the rule are not only experts in the strictest sense of the word, for example, physicians, physicists, and architects, but also the large group sometimes called skilled witnesses, such as bankers and landowners testifying to land values. Now, again, obviously, we're not dealing with a banker or landowner, but the advisory notes and the advisory committee on the rules of evidence 702, the federal rules of evidence 702 clearly lay out this is exactly the type of field that is subject to expert opinion. Clearly, the rule 702 allows for experts with specialized experience, specialized knowledge, specialized education beyond that of an average layperson, in particular in a field without, or in a particular field without resort to, for instance, the generalized scientific methodology that we've heard so much about in some of these motions in limine. I can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and accepted investigative techniques and protocols. As the court noted, or as I just noted to the court, he was an FBI special agent for more than 20 years. He formally coordinated with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally. He was the lead case agent who oversaw arrests and indictments. He received awards and recognitions for his work with the FBI, as well as with state agencies in which he was a task force member. For 11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local agencies, with investigations and prosecution of thousands and thousands of homicides, robberies, kidnappings, other violent crimes. His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI, but those agencies as well.
To motor vehicle accidents.
Just a few of Mr. Easter's experiences and involvements in some of the domestic and international cases include the 2015 San Bernardino mass shooting.
So are these all on his CV that you're going to give me a copy of?
Everything, I believe, all.
I don't need you time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either what I was reciting is either in the CV or in his report. One or the other.
That's what I need. That would be much more helpful to me.
Then I don't know what more the court would like from me.
I wanted to know specifically what you intend to have him testify on. But if it's in his report.
It broadly is in his report. I don't know exactly every question I'm going to ask him, but I can tell the court in broad brushstrokes. Obviously, we're going to ask him, we've already asked him to review. He's reviewed NOD 1 through 59. We're going to give him the additional NODs that we've got as well. He's going to review everything. And from that, he's going to, I expect, render an opinion about whether or not the investigation followed standards and training, best case practices for an investigative
So I guess
technique.
That's my question. So without seeing the report, where are their standards and best practices? Is that something that somebody can turn to and see codification of it, or is
So-
it just his experience?
No, it's not just his experience. Those standards and practices are oftentimes reduced to writing. They have been reduced to writing with the Massachusetts State Police. So he's reviewed the protocols that are in place for the MSP.
Okay.
He's very familiar with FBI's protocols for investigative techniques and investigative protocols. He'll utilize those skills and that knowledge base to assess his opinion, or to render an opinion and a conclusion concerning what he believes are the proper protocols that should have been followed in this case. That goes directly to our Bowdoin defense, and he is the primary expert that we would use to propound that Bowdoin defense.
All right, can you get me that report before you leave? Do you have it extra?
I think
All right.
I think we probably have an extra copy of it. Yes.
Mr. Brennan, did you want to respond?
Of course he does.
Mr. Easter was a agent who did CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about how he feels an investigation was done. Not a report, not an assignment, but as an expert witness in Bowdoin. How many cases has he gone into court and testified and been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police. This is just Monday morning quarterbacking, and it's an attempt to bolster argument by counsel so that they can use some type of opinion to lean on when they're arguing to the jury they should have because of the police investigation. I don't see any recognition under 702 or in law where somebody can come in and subjectively give their opinions. If there is a state police protocol that wasn't followed, then the defense can see if that state police protocol is appropriate. If they're speaking to a state police officer, question them about it and ask them if they did it and why. If this person comes in and gives opinions, there'll be a slew of opinions that are shot like a shotgun approach that will never be able to
And
have
what
an
if they
opportunity to
deny,
explain.
or they've
Are we
never
going to
seen the
call in
policy?
the Canton
Mr.
Police
Brennan,
Department
then what?
again and call in the state police for a second round so they can explain why they chose certain actions that Mr. Easter is criticizing? I don't think this is an appropriate ground for an expert witness. I don't see any cases, I've looked through the state and federal court, that allow an expert to come in on a Bowdoin defense and give their subjective opinion about an investigation they weren't involved with. I don't know that this witness has ever been qualified as a Bowdoin type witness in any court. He may have testified, but about what? And so I think
Well,
this is a
that's
very
ironic,
dangerous
isn't it?
proposition.
You may
What
have
if the Commonwealth
testified,
wants
but
to
about
counter
what?
and bring in a state police officer to say that
Isn't
that
that what
the
we said about
investigation was
Cosby?
fantastic, that everybody did a remarkable job under the circumstances? What if we bring in a witness to talk about the fact that the evidence is so overwhelming that it should imply a certain finding by the jury? This invites that. This
Because
invites
that
a debate
intrudes the
between people's
province of the
personal
jury,
opinions. That's
whereas
done
this is
outside of
providing
the
them
courtroom,
information
not in a courtroom.
in
We
order
will
to
never
make
have an
a credibility
opportunity to
assessment.
be able to have all the witnesses come back to explain what
Those are
this
not
witness
equivalent.
subjectively thinks is a dedeficiency. I don't think it's appropriate for expert witness testimony. This is argument by counsel.
Your Honor, very briefly, I gently disagree with Mr. Brennan. He indicates that we want to use an expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder. He indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah. There's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says, well,
You
hang on.
wouldn't be objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Mr. Brennan said, what if I called a Massachusetts state police officer to say that this was the best investigation ever? I have two words. Do it. Do it. I'd love that. I'd love a shot at that.
Okay, so I said, let's take personal.
That's not an invective. That's not a personal shot at Mr. Brennan. I'm just saying, do it. You want to call in another expert? That's a classic battle of the experts. That's fine. I'll put Mike Easter up against any expert they want to call. But the reality is, Your Honor, we are entitled to present a defense. And part of that defense, the Bowdoin defense, is the adequacy of the investigation. And there's no question that a proper homicide investigation is not something within.
Yep.
I don't know. So if you can give me a case site for that, all right? that expert testimony regarding a Bowden defense. I've never seen it. I've never seen it in research or anything. So
I've got
like
it.
a case site.
There are certainly cases outside the jurisdiction.
Yep, Massachusetts case. If not, you can give me the outside cases, but I don't
I
believe
will.
there's a Massachusetts case where this has been done.
We have searched and searched for a specific case in Massachusetts. There, to my finding, to our finding, there isn't one directly on point, but there are a myriad cases outside the jurisdiction where investigators are called consistently, especially on behalf of the defense, to talk about adequacy of an investigation.
Mhm.
That is an expert field, one that's utilized throughout the country all the
I need some
time.
authority, and the more persuasive the authority, the better chance you have at this. Okay?
Sure.
All right. So I think that's it for the motions in limine.
Needs authority
Did I
from
miss
the defense.
anything?
Didn't need it from the Commonwealth. Right? When it came to what exactly are you trying to do with Dr. Welcher here?
Oh.
Your Honor, earlier you alluded to, this is what defense wanted to talk further about the ARCA issue, the Rule 14. You said we'll wait for, we'll put that off until the end, if I heard you correctly.
I thought you and Mr. Brennan were going to talk about it first. Is that your understanding, Mr. Brennan?
Yes, and we have none.
Yes. So that was my understanding. So impanelment, you don't have anything for me for impanelment?
I regret we don't, we have not spoken.
Your Honor, if I may, on one point on the impanelment.
Sure.
I just know it's the court's preference to have a one-page front and back questionnaire.
Yes.
I was wondering if, in light of the unprecedented pretrial publicity in this case, if Your Honor would consider an additional one-page juror questionnaire that deals with just pretrial publicity. Last month in the Chisholm case, the SJC outlined kind of appropriate questions.
Right.
If in additional to the front and back, there was just one questionnaire that focused just on pretrial publicity, I think that would expedite the impanelment process.
I think that makes sense. Is there any objection from the defense on that? There's been an extraordinary amount of
Depends on what the
publicity, even
page is,
far
huh?
more than the last trial, and so close to jury impanelment.
Or generally,
makes
no,
sense to me.
probably fine with it. But it sure depends on what that page is, doesn't it?
Oh, I'm sorry, Your Honor, I was looking at for outside cases. No, there's no objection.
All right. So I need the joint questionnaire, and it can be that third page, Ms. McLaughlin. I think that's a great idea. And I was thinking about Chisholm earlier when I was expecting something from the parties. All right. File your questionnaire, file your proposed questions that you would like me to ask the venire and that you would like to ask at
Venire?
sidebar.
Oh,
I need
Judge,
that by tomorrow.
it's a veneer.
So tomorrow by the
C'est
close of
français.
business, I need that. So if I need to see you again next week, we'll let you know on Monday. All right?
Yes, Your Honor.
Okay.
Well, obviously, it would be the day after Monday then, right?
Yes, Mr. Unit, it would be after Monday.
We did file 2 motions today that at some point we'll need a hearing
Oh,
on. The
okay.
defense just received notice this morning, so we're not prepared for today, but we would want a hearing on both of those motions. The sooner, the better for us.
So why don't we come in next week?
Next week. When next week? Oh, so much for deadlines and notice. Ooh. I don't know who that gaze was focused on, but that was a sharp look. Why are we going to the I don't know why we're going to the fan. Are we going to sidebar? I suspect at least some of this has to do with the amended witness list and adding the defense team to it. I mean, surely you would need to, present your basis for why you think that that's appropriate to do it. What's the other motion? I don't know. Has anybody seen anybody in the chat or those out there yet? I can run and see real quick if there's I mean, not seeing anything that jumps out. So let me go and check my girl Dee Dee real fast. Because I tell you, if there's been documents filed, Dee Dee's going to have them. I'm not seeing anything, so.
So I will see counsel on whatever is outstanding next Tuesday, the 25th, and we'll do that at 11 o'clock.
Tuesday at 11.
All right.
Guess we'll be
Okay,
here.
thank you very much.
Thank you.
Rise, please.
Yes, we'll be here on Tuesday for whatever is outstanding. So I guess we'll come back to the whole ARCA Rule 14, maybe. I don't know. And they're going back to the fan, so we'll go ahead and just go ahead and pull that off. Well, boy, that was a little different this afternoon, wasn't it? First, we're going to make Mr. Brennan absolutely, or Mr. Alessi absolutely sprint, absolutely sprint through his argument on the Celebrate demo, and he did, in fact, do that phenomenally well. He brought up how it's vague. He brought up how it's no elaboration. It's a blank check. It is kind of a blank check because remember the whole problem the first time was that he wasn't using the right operating system. He was using a different operating system than the one that Jen McCabe's phone used. And so they're trying to demo what Jen McCabe's phone would use, but it's not equivalent to Jen McCabe's phone. So we have no idea if that's actually what Jen McCabe's phone would do or not. Got into the rules and the problem that it presents under the rules. Yeah. I appreciate your brevity. She just has to get that in, this little backhanded stuff. She just has to get that in. Yeah, it looks like they are indeed coming away. So I'm just going to make sure that I got law and crime shut up so they don't start yelling something at me. Gonna do an offer of proof, only ex parte on the Morrissey and Nelson stuff. The bad character misconduct. You notice when it comes to the Commonwealth's motions, she's going to ask the defense, well, what are you going to present, or what are you what's the issue? She always kind of makes them be the one to define it. She doesn't make the Commonwealth clarify what exactly are you challenging here. She's saying that the defense needs to anticipate anything whatsoever that the defense might present that could be construed as bad character evidence. That's problematic. Because that's kind of in the eye of the beholder, in a lot of respects. I mean, let's just take, for example, last trial, we had that whole Carrie Roberts babysitter with benefits thing. Okay. What might that open the door to with respect to Carrie Roberts' own history with John O'Keefe? Is that he broke up with her? Is that like prior character evidence? I don't know. I wouldn't normally think so. And I also wouldn't think I would need to disclose it under these circumstances if it's something that I'm responding to by the other side. But who knows? Because this whole thing is so vague, and she is kind of offering this blank check to the Commonwealth. If they don't put it on their list, you can go ahead and object instead of putting the burden where it should be, that you, the Commonwealth, knowing what they have produced in discovery, knowing what the evidence is likely to be, you should anticipate it, and you should specifically challenge it. Just more rules for me, but not for thee. Yeah, different posture with the IA. Well, I'd say so. I'd say so. Now, Mr. Brennan asserts, oh, well, the ultimate conclusions and the findings aren't admissible. I'm going to take issue with that because they might be. I have been working on a quick little, kind of quick and dirty Substack piece, hoping to hit publish on it before I go to bed tonight. Got a little bit of a busy afternoon, which I will get into. But I'm looking at this. I'm looking at what can they do? What can they not do? I saw that Brother Counsel did a video yesterday too. We have very similar approach when it comes to let's go do actual law. Like, let's go and look at some cases. Let's see what the rules are, what the kind of limits are. But we've also got a little bit of kind of different lines that we're going down, like different ways that you think, which is totally fine because there's often lots of different ways to get a particular legal outcome. So I'm looking particularly at certain types of impeachment. So I'm probably gonna have some thoughts about that because there are some times where things that would not maybe ordinarily be admissible, they get to become admissible. So we'll just see if that holds up or not. Bev is like really wanting to come in some more, right? First, we're going to come back in on March 31st. No, we're not. But now we're going to come in next Tuesday anyway. So that's going to be apparently still on the horizon. Maybe we'll deal with that Tuesday, this whole issue with the IA stuff. I guess we'll see. Maybe not because what is next Tuesday? Yeah, no, it won't be next Tuesday because next Tuesday is the 25th and Mr. Brennan won't have his deadline to say what is disputed until the 28th. So as far as the IA stuff, I don't know. Guess we won't get to that. Yeah, the third party culprit, we talked about that. I don't need to bang on that anymore. Just the whole no evidence. There was an entire trial. There's all of the butt dials. There's all the shenanigans. There's the changing of the stories. There's the SIM cards and, the consciousness of guilt stuff, the getting rid of the phone. There's John's health data. There's abundant evidence that is non-speculative. It's at this house in this front yard. And by the way, the guy looks like he was beat up. So Wing, we just have to comply with that. So by Monday, you're so well prepared. Is she trying to like make it up to him that she's also being so snarky? Is she flirting, got that little crush on him. So she's negging him about to tell me what you're going to say and then don't tell me. And then she realizes that didn't land. So now we're going to bend over backwards and go with the flattery, something like that. She's just jerking him around. I don't know. But it's really not necessary or appropriate. You don't have to comment about the lawyers. It's really kind of better if you don't. Just let them do their job. That's really what you're there to do. You don't have to comment on it. Easter, boy, she is certainly wanting to signal that she's not going to let that in, isn't she? It needs to be Massachusetts. Well, there's a lot of times when there's not case law on something because it has simply never worked its way up to the Court of Appeals. It doesn't mean that nobody has ever testified to this end. It doesn't mean that at all. In fact, I would bet there could be lots of circumstances where an expert did testify and a defendant got convicted anyway. So, there's no ruling that's authoritative from the Court of Appeals saying it's okay for a defendant to do that because they got what they wanted. They didn't get an adverse reason. There's nothing to appeal. So You're going to have to be the more persuasive the authority, because of course legal authority from other jurisdictions is not binding. It's just persuasive. They've made a solid argument that this is beyond the ordinary expertise and experience of a juror, and it is. Police work is technical work. Aren't we going to hear all about how they go to the academy and they have their specialized training, and they're taught how to do all this stuff, and it takes months, and then they go in and they have a period where they're like probationary before they're full officers. They'll be in field training and stuff like that. Are we going to hear about that? And then don't we hear all the time about the officers' training and experience allows them to reach certain conclusions? That's because all that is beyond the experience of the jurors. They don't know. They don't know that stuff. So yeah, seems pretty reasonable to me to be able to bring somebody in and testify what that actually is and what those standards are. That would be what I'd give him to rely on. I mean, among other things, yeah, if MSP has standardized policies and procedures for how to do an investigation, great. You can absolutely analyze that. Coincidentally, maybe CPD doesn't have anything official for how they're supposed to do stuff. They just don't put it in writing. It's all I don't know, understood. Then go and get the training materials from the academy. Go and see what police officers are taught in the academy, the basic training that they all get with respect to how to conduct investigations, and give that to your expert. Because yeah, they should all know that. They should all know that, shouldn't they? And so, I mean, the way that experts, and certainly police officers, maybe I'll draw a distinction between those two, get out of giving you what you want is they just deny familiarity with it. Okay, so if the deal here, according to Mr. Brennan, he's supposed to just like elicit this on cross-examination. He's supposed to ask, did you receive specific training about how to conduct an investigation? Yeah, back in the academy. And what were you trained? I don't remember. It was 20 some years ago. They're not even going to know. I mean, is that the issue, that we have to establish a foundation? And it shouldn't be, because the right to present a defense does not mean the right to, present a defense only through cross-examination. Yeah, you have that too. It's a whole separate right that you have as part of a right to the fair trial, to be able to cross-examine and confront witnesses against you. But you also have your right to present your own defense. So I think they did an excellent job on this particular argument of tying that into the Bowden, and that means, yeah, it's of constitutional magnitude being able to do this. If it meets the evidentiary standards, it should be allowed. And if she abuses her discretion in denying it, that does go directly to a deprivation of her constitutional right to defend herself. So Tuesday at 11. Guess we'll be back. Let's take a look at the rest of the questions and comments that we have. Track worker, the Salem witch trials more honest and fair to defendants. Well, fun fact, how many of the Salem witch trials involved confessions? 70 some. That I've been talking about Duped by Dr. Saul Casson. It's still fresh in my memory. This book that I read, he talks about the Salem witch trials, because does it seem kind of fair to assume that somebody confessing to being a witch is probably confessing falsely? Yeah, that might be fair to assume. So it was quite a lot of them. Quite a lot of them were based on false confessions. And again, there's a whole variety of reasons for that. It can be coercive because, you're going to get some kind of mercy if you confess. If you go to trial, then you're going to be hung or whatever, burned. I mean, something gruesome. Can be because the methods of interrogation back in the 1600s weren't necessarily constrained by the due process types of considerations that we have today. So, nevertheless, still more honest and fair for defendants. Michael Muddragon. Good faith basis and Mr. Brennan don't deserve to be in the same sentence. How dare you, Andrea? That's why I said I wonder why. Are we going to be able to connect these two things together? Good faith basis for calling the defense team. I'm going to suspect that whatever got filed today is probably impounded. Just double checking my girl Dee Dee again. Still nothing up. So I'm suspecting it would probably be impounded, but I don't know. Maybe it won't be. Maybe we'll get to see what the argument is for why the defense attorneys are witnesses, essential witnesses. I don't know. But yeah, he needs to make that showing. Jason Sorensen, judicial discretion and immunity for arguments are things that look good on paper, but when left with no major guidelines lead to where we are here. Yeah, I mean, there's downsides to having these policies, most of which, by the way, these are judicially created policies. Think about that for a second. Who decided that judges have discretion to make these rulings? Judges did. Who decided that judges have absolute immunity from their judicial acts? Judges did. It's not in a statute. It's judges decided this. So yeah, I mean, there are reasons for having that, but when you have these completely unqualified protections, then you don't have any remedy. You don't have any recourse when they go afield. When they don't carry out their judicial function in the manner that they are expected to. So. Yeah, I agree. A lot of troublesome stuff there. Duncan, Idaho, this whole case is a great example of how, as long as there is a political will to put you away, regardless of the merits, the government will siphon the taxpayers' funds in an endless campaign against you. Yeah, it always falls back on the taxpayer. It always falls back on the taxpayer and their prosecutorial decisions. You don't get to question those. I saw just the other day that Fannie Willis lost her attempt to not have the public records. It was like a public records dispute that Ashley Merchant, I think, had brought against her. And, it was ruled she withheld records unreasonably in violation of the law. And so there was a attorney fee award, like $50,000 or something like that. And who do you think is going to pay that? You think that's going to be Ms. Fannie Willis herself that's going to have to pay that? No, it will be the taxpayer that has to pick up the bill for how she decided to exercise her prosecutorial function. So, yeah, I mean, I don't know what the remedy for this is. The sort of trite but not very satisfactory answer is, well, just elect better prosecutors. A lot of times elections, they're a choice between a lesser evil. You don't have a good candidate to choose. You have two people that suck and you have to decide which one sucks slightly less. So, choosing the less sucky guy isn't helping you get good people into office. So that's part of the problem there. But, the discretion that they have and the protection that they have from any type of personal responsibility for the consequences of their decisions, I really question that. I really, really do. Because, especially with prosecutors, the premise is, well, you don't want to chill them from doing, valid prosecutorial exercises. Yeah, I do, actually. Yeah, I do. I want to chill them from doing prosecutorial things that they aren't real damn sure about. I do, in fact, want to chill that because it is such an enormous power that they have, and it has such great potential to be abused. So if they aren't real sure they're playing within the lines, yeah, my preference is that they be deterred. Play within the lines, and then you don't have anything to worry about. Yep, always falls back on the taxpayer. Greg, is rushing them like this an appellate issue, or could it be? Not likely. She does have discretion over the manner of the presentation of evidence and argument and stuff in her courtroom. It really just is, does it amount to a deprivation of their right to be heard on something? They have their written pleadings. You know, they can make their record if they want to say, I haven't had enough time, like Mr. Yannetti did. I'm not going to be able to address third-party culprit in 2 minutes. And so, you know, she responded and gave them more time to be able to come back to that. So no, I don't think it's likely to be an appellate issue. They can also always, if they are out of time and she doesn't let him get to something that's really important, they can always file something supplemental. Say, here, I wanted to say this in my oral argument, but you didn't let me. And then you just make your record of that. SanDB, excuse me, Brennan, that was the Commonwealth's job. You failed to prove Karen did it. Therefore, there is a third party. Well, this goes back to the arguments that they had to make before the first trial when they're trying to point out, if you're saying Karen Reed didn't do it, you're necessarily saying somebody else did. And Karen Reed has a pretty unequivocal constitutional right to say she didn't do it. And so if you are interpreting this so broadly as to say a third party defense is any sort of defense that implies somebody else did it, you're really trying to expand it to say she doesn't have the right to defend herself. She doesn't have the right to deny culpability. And of course, that is not the law. As much as many prosecutors might like it to be, that is not in fact the law. So yeah, somebody else did it. She doesn't have to point the finger at anybody specifically. That's not her job. That's their job. That's their job to figure out who did it. So point very well taken with that comment. Anti-Deb's Judicial Bench Award. Can you explain adding the defense to the witness list? I can't because I have no idea what is in Mr. Brennan's mind. I have absolutely no idea what he's thinking about why the defense attorneys are witnesses now. I don't know what their witnesses to ARCA. I mean, is this going to be about ARCA? I don't know. I don't know. So I'd love to, but unfortunately I can't. Christina P is now a YouTube member. Welcome, Christina. Welcome to the crew. Guys, that's all we have for comments and questions today. So I am going to wrap it up. And the reason why I'm maybe going to do that a little bit faster than I normally do is because I do have another appearance this afternoon on the horizon at, I better double check now, make sure I remember what time. I think 2:00 my time here. 1:00 my time here. Shoot, I gotta go and double check. Give me a second here, guys. I literally posted it. Now I forget. 5 Eastern is 3 Pacific. So at 3:00 this afternoon, I'm going on with Bob and Ali Mata over at Defense Diaries. We're going to be catching up on Delphi, and they have scheduled for Stacey Eldridge to also be on with us. So Stacey Eldridge, if you remember, if you followed that trial, she was the defense's cell phone forensic expert. She's a former FBI cell phone analyst. And so she is the one who reviewed the extractions that the Commonwealth did. And she found that information, that code that indicated that at like 5:30 in the evening, a couple hours after the girls are supposed to have been murdered under the Commonwealth's theory, somebody plugged wired headphones into Libby's phone and then unplugged them at like 10:30 in the evening later on. And so that was new information that just came out at trial. Nobody had heard about that. We're going to most likely be limited to just talking to her about what she testified to. So we'll be going back over that, kind of fleshing that out. But I definitely have some things, if I can, that I want to be able to ask her. I don't know if she'll be able to answer or not, but we'd like to be able to do that. So we'll just kind of see what her comfort level is as far as questions. So that'll be in just a couple of hours. Hence why I'm going to try to wrap things up a little bit earlier here. And then, boy, what else do we have going on? Next week, we'll be back Tuesday. I'm glad they did it Tuesday because I'm supposed to leave town Wednesday. Wednesday is my birthday. And so we got a little trip planned. A little excited about that. Gonna be a good time, but it would be inconvenient if there was court later on in the week. So Tuesday actually works just fine. And 11 o'clock, I like that. That's 8 o'clock here. That's not anything uncomfortable at all. So, well, guys, I mean, we're going full speed ahead with this trial. I can't say I'm shocked. Poll, notwithstanding, did seem like she might be leaning that direction, but then had those concerns about just the logistics of bringing the jurors in, which I think is somewhat understandable. Conferred with the jury coordinator about that. It's not realistic to get a bunch of people in, on this short of notice. So I can't say I'm shocked, that she isn't allowing it. I know some folks also suspected after Proctor got fired that the Commonwealth really should just walk, like between the pressure of all of this stuff, the pending appeal, the new information about his status and everything like that, like at least just back off of counts 1 and 3 or something like that. I really never expected that to happen. And then once I heard that Mr. Brennan's going, full steam ahead over in Judge Doolin's court to try to get Aiden Kearney's phone data, that made it pretty clear to me. No, there's no dismissing anything on the horizon. It's not likely, really not likely. I did have somebody ask, is that something Judge Bev could refuse if she were so inclined? And she cannot. There is a rule in Massachusetts specifically dealing with noli prosequis is what they call it in Massachusetts, the old Latin term. And it's clear under their rule that the prosecutor has absolute authority to do that at any point until the trial begins. But honestly, even after the trial begins, they very likely have constitutional authority to do that because you have a separation of powers issue if the executive who gets to make the decisions about prosecuting is not allowed to exercise that because the judge is trying to intrude on it and thinks, somebody should be prosecuted when the executive doesn't want to. So, no, she would not be able to refuse it if that were to happen, but really don't think it's going to. And I think the indications we got today are that, still the case that is not going to happen, despite the changing circumstances. They are going to continue to go full speed ahead. So with that, guys, yeah, another rather frustrating day. Nothing really particularly helpful in terms of guiding us on the substance, because the most significant motions, we're taking them under advisement. We're going to continue to sit on it. No ruling on the motion to dismiss yet. No ruling on Dr. Crosby yet. I don't know when she's going to decide all this stuff. She's really creating a headache for herself, from my perspective, by pushing so much of this down the road. It would not be that hard to rule on some of these things from the bench if you had prepared to do that. But Judging by her comments, it doesn't always seem that she's necessarily that familiar with the motions, although she will certainly say, well, I've read your motion, Mr. Jackson. I've read your motion. So if you read the motion, go ahead and decide it. Go ahead and decide it. I don't know. It's a beautiful day out here today. And we're finally getting into spring. My apricot trees are blooming. That's always my internal calendar. I don't care what the calendar said. I don't care what the moon cycle is at, or the sunrise, the solstice. I don't care about any of that. If the apricots have bloomed, it's spring. And not just have the apricots bloomed, there's the most glorious humming under the apricot trees because all the bees are out, pollinators are out. That can be a little bit of a sticking point up here in the north. We are kind of marginal for apricots, which are like my favorite fruit, by the way. Oh my gosh, dried apricots. I lose my self-control around a really good dried apricot. Not those Turkish ones, not those like wet, kind of gross Turkish ones, like a nice sun-dried apricot. It's like all tangy and chewy, and it's just wonderful. I'm drooling a little bit. Just sorry, I got to take a little drink for myself. It can be a little bit marginal here because sometimes the apricots will bloom before the pollinators are really out. You don't always kind of like one in 3 years that you get a good apricot season. Sometimes you get a late freeze. Sometimes the pollinators are not out enough. We've had two good years in a row, and so asking for a third is really asking to push the boundaries a little bit. But that said, the last 2 years, we also did have late freezes. I just was proactive, and when they were happening, I got out my sprinklers and I sprayed my trees. That's the trick. If you're gonna get a frost event overnight, you just go out and you get water on them, because what happens is then the water will freeze and it will capture that little bit of air next to the skin, and that air will remain slightly above freezing. So that will help protect the fruit. The fruit's usually hardy down to, it depends on what stage of development it's at, but it's usually hardy down to like 20 degrees or so. So you can take quite a bit of damage before you have to worry about it. Anyway, I did have to do that 2 years in a row. So maybe that interferes. I don't know. But so now that's really hopefully all we have to worry about at this point is just controlling for a late freeze. Otherwise, we should have lots of apricots again this year. Very exciting. So I'm going to head out and check on things, but I will be back on Bob and Allie's channel over there at Defense Diaries at 3:00 Pacific. I dropped a link in the community tab. So if that's something that you want to jump in for, that's where it is. And you should be able to find us over there. Thank you all once again for joining us. Thank you for being such a clever and insightful chat. Really enjoy having you guys around to share us your jokes and your insights, your knowledge of, so much information, lots of times beyond, what I know about the case, so many other details. A lot of you guys know a lot more about the Turtle Boy stuff and kind of how that interacts with Karen's case, just because I haven't followed that side of it nearly as closely. So very, very valuable to have you guys around and sharing your insights. I saw a comment in there, pretty sure it was 4D Man, had a PhD advisor saying how there's a difference between method and methodology. And I think that's right. That is true. There is a distinction between a method and a methodology. I could try to characterize it myself, but it would probably not be right. So I'm going to actually go and look up what is the technical distinction between method and methodology. And so I love that we have folks with insights that trigger us intellectually, get us thinking about stuff. I think that's a particularly helpful activity to be engaged in. Already said, so much to catch up on in Kohberger. working on that. I've already been behind on doing updates. So for those of you following that case, my apologies. I am going to make an effort to, get at least to kind of bring us back up to speed at some point. There are going to be hearings coming up soon on that I want to be prepared for as well. So keep an eye open for stuff like that. And last thing, of course, like I said, trying to hit publish on a Substack piece tonight. It's nothing super fancy, but just a little bit of background into Trooper Proctor, ex-Trooper Proctor, and the implications of that firing, what that might mean from an evidentiary standpoint. So keep an eye out for that if that's something you're interested in as well. Thank you, everybody. Hope to see you next Tuesday, and hope you all have beautiful spring days ahead of you as well. And get some of that sunshine, get some of that fresh air, get some of that movement. It's just so good for us. Very, very important to do that whole touch grass thing that we talk about all the time. So I plan to do some of that, and I just find it helps keep everything grounded and in perspective, and not necessarily taking what happens online too seriously. So with that, guys, appreciate all of you. Thank you again for your support and your questions, and I'll look forward to seeing you all on Tuesday.